started. Good morning and welcome to Making Law Simple. My name is David Helm, a licensed practicing attorney in Oakland County, Michigan. I do practice in other counties as well. And I'm not muted. The screen is going. Hey, look at that. We had no boomer moments this morning. Thank you, everyone, for joining us. And with me today is Excited Utterance from a made-up land she calls Australia.
Yeah.
Yeah.
It kind of exists. I think I convinced Google like I exist at least. So
It's just a dome under Antarctica, and you guys all live there and live out your lives, pretend that it's someplace important. We know it.
it's very important. I live here. That makes it important. Anyway,
Okay.
hello everybody. My name's Hella as well. See there. Yeah.
So, but good morning. I see
kind of real name. Nice to see you all.
Josie's in the chat. We got Vodka Blood and Jessica. I see you all. There's a lot of people already in the chat, but welcome everybody. Welcome. So we have jury instructions this morning, and we are currently waiting for the court feed to go live. You can see my little spinning wheel of death with the Zoom feed, which I think is actually, so the game playing here today. The Zoom feed's audio quality is so much better than anything that Fox or ABC or NBC puts out. So I think we're going to stick with the Zoom feed for the most part for the jury instructions, because I really want to hear what they are, right? Yeah. We all want to hear. That's what we're here for, right? We want to hear what the jury instructions are. So we just won't be able to pause. So once they start, we're just going to kind of listen. And then when they're done, I don't imagine they'll take too long. We will, we can sort of comment audibly. Otherwise, I might be in the chat. Yeah, and if you have a question while this is all going on, Wendy H, throw a red question mark up, and we'll try to get to it. And then once we're done with the jury instructions, there's some YouTubers out there. I won't mention names, but the Broken Baker, who will talk for 35 hours while the jury is deliberating. I'm not sure I'm up for that. If I'm not, well, either way, I'm going to redirect you guys to a Verdict Watch stream, which I think is currently set to go in about 2 hours. And the 2 hours are just sort of a guesstimate. If we have a verdict and I haven't started it yet, I will absolutely just go live with it. So make sure you click the notification button, not just like subscribe and hit the little bell. There's actually a notification button. So hit that so that you get a live alert. And also, you know what, speaking of which, I need to post this stream in my Discord and give everyone a heads up that we are going live. If you are a member, also go to my Discord.
If you remember.
Well, someone's already done it. I'm sure. Yeah, see, so it's already in there. Aries has already posted a live alert, so we're good. But that's another way too to get good live alerts. And then so we might go live a little early on that stream just to talk about some stuff with the case or other things. We've got some new information on Sarah Boone. We've got some Turtle Boy. We've got some Courtney Clenny. So we have other things that we can talk about while we are waiting for a jury verdict. But I'm not sure I'm going to go live for 8 hours waiting for a jury verdict. We'll just kind of play it by ear.
I have a feeling it's going to not be a very quick verdict on this one.
Have you looked at the docket to see if there has been a DV yet? Oh, let me look, actually. Let me do that right now. Directed verdict. Yeah.
on this.
Yeah, there wasn't a motion for a directed verdict. Well, at the end of the state's case in chief, like there should be.
Yeah, there would generally be a motion.
Yeah, and I said, well, they don't have to do it orally. They could
Mm,
do it in a written form, and it
yeah,
could have also been something that was done um, on like when the cameras weren't on or something. So there were some
yeah,
conferences that took place outside of the camera view. Um, Not a fan of that, but there could have been something. Well, let me see if there's a motion right now. Case number 2022. What's the case number? 279990. We gotta remember that.
Do you know that off by heart?
279990. No, I just looked at it. I was like, that's why I gotta say it out
I
loud.
say, I would be so impressed.
All right, let's see here. Let's see what
Daily
we know.
quick bites. I'm pretty sure no judge is going to DV this either.
No, but you need to bring it, right?
You got to bring it. Yep.
Yeah, otherwise it's considered waived. And
Yes.
it'd be interesting if she argued that it was waived or not. Okay. Let's see here. So, motion file review text messages. That was on the second. Letter filed regarding sealed records. Opinion filed regarding sealed records. Media coverage filed. So there's a lot of people that file the media coverage things. I filed my notice of media coverage, and I said starting on January 23rd or whatever for the rest of the trial. I didn't even put the end of the date.
Yeah.
So I didn't have to keep filing them. Returned form Court of Appeals. What were they going to the Court of Appeals for? Jury trial continued. Letter filed. RTD from Court of Appeals. Looks like there were some interlocutory appeals filed while this case was pending. I don't know what that was about, though. People's response filed offer proof of supplemental motion to strike.
Could you explain interlocutory appeals?
Interlocutory appeals. So generally, you have the right to file an appeal when the case is done. If you want to file an appeal while the case is still going on, it's called interlocutory. It's while the trial case is still pending. So they did that, say, when they motioned to have the case dismissed because the facts that are being alleged don't line up with the actual law.
Right.
They brought a motion to dismiss that was denied. Then they went to the Court of Appeals on an interlocutory appeal. You have to ask permission to do it. The Court of Appeals won't grant it. And then we went up to the Supreme Court. Then we went back down to the Court of Appeals. And then in August, September, it was finally sent back down to the trial court to continue trial. And then that's when the trial date was scheduled. So, but an interlocutory appeal is just when the judge makes a ruling, like a pretrial ruling, such as admitting evidence or dismissing whatever. You can go to the Court of Appeals and try to have that addressed before trial. And so it looks like there was another interlocutory appeal filed because we have this. I could probably pull up the let me see if I could pull up the Court of Appeals docket. Just talk amongst yourselves for a minute.
Talk amongst ourselves? Well,
let me ask you this, Excited. Have you been watching all of this trial?
Here's the thing. I would love to have been watching all of the trial. Unfortunately, on the Monday of the trial, I was streaming the Murdoch retrial appeal, which was obviously something I've been waiting for quite a while, so I couldn't be watching that day. I did rewatch as much as I could, and I have rewatched about, I would say about 60-70%. I am on the other side of the planet, though. So I have this thing called trying to catch up on sleep while streaming and and
Yeah, what time is it there for you?
at the moment it is just getting on to midnight. So, and I was streaming this morning with you, actually, at 6 a.m.
Well,
my
it
time.
was yesterday for me.
Well, there you go. Well, you're wrong, and I'm right.
Oh, while I am going through the rest of this, I just thought I'd scroll down through here. I'm nervous for this verdict. I am too.
Yeah.
I'm a little nervous for this verdict. Do you think sending the jury home Friday is a good decision? You know, I've been taking the weekend to think about that, right? Because Ian Runkle thought it might be best just to send them to deliberate right away. And I don't like the last words that the prosecutor said. And while I'm sitting at home all weekend, I am rethinking a lot of what was said during closing arguments. And I don't know if it's my bias or if it's just it resonated more with me, but the defense's closing argument resonated more with me. And so what the prosecutor had to say just kind of fell by the wayside, right? And so maybe
Mm.
it was a good thing that they sat all weekend and then
Yep.
are coming back today because they're not going to get any more arguments. Everything has been said by the witnesses, by the attorneys. There's no more arguments to be had. The judge is literally going to read to them from a list of jury instructions, and then they're sent back. So I think it's a
Can
good
you
thing.
can you repeat then what were those last words that the prosecution said that bothered you?
Well, it wasn't so much the very last word, other
Yeah.
than convict her, find her
Yeah.
guilty,
Yeah.
but
Yeah.
she misstated uh, the elements of the crime. What
Right.
she did was, if you look at this, so this is involuntary manslaughter here, right? And so, in order for her to be guilty, the prosecutor must prove beyond a reasonable doubt first that the defendant caused the death of these four individuals. That is, these four individuals died as a result of mother's gross negligence, right? The defendant's gross negligence.
Yep.
Second, that doing this act um, that caused the deaths, so the gross negligence, defendant acted. Oh, here's the grossly negligence. Sorry, spelling
Hmm.
it wrong. So grossly negligence is more than mere carelessness. It
Yeah.
means a willful disregard of the results to others that might follow from an act or a failure to act. In order to find the defendant was grossly negligent, you must find the following: first, that she knew of a danger to another. Uh, that is, she knew that there was a situation that required her to take ordinary care to avoid injury. Second, that the defendant could have avoided injury to another by using ordinary care. And then third, that the defendant failed to use ordinary care. But the first part there is that she had to have known that there was a danger to others
Hmm.
and knew that the situation required uh, the act of ordinary care.
Yes.
Well, the way the defendant phrased it, it was there was no gross negligence standard when she applied. She just said she had a duty to protect and she didn't exercise any reasonable care or something along those lines.
Right.
And I can't remember exactly the way she said it, but I didn't like the way she said it. I thought she was changing sort of the standard.
Hmm.
And welcome, Jamie, by the way.
Hey,
You sneak
Jamie.
in the back door.
Hey guys.
Hello.
So have you been thinking about this all weekend too, Jamie?
Yes. I've watched some streams like on the side to see what other people are saying, and people are nuts.
Well, there's been a lot of talking heads that have been both ways. A lot, and I don't know if it's just my feed, but News Nation had a lot of stories about this case over the weekend, and a lot of them were in my camp. Like, I can see where the argument is, but I don't think the state got there.
Mm-hmm. Yeah, what I'm noticing is a lot of people are right off the bat in the guilty, like, oh, she should have this and that. And then once you start talking about it and seeing, like, a lot of the streams that I've watched will start playing like some of the arguments, and they're like, oh, wait, And like, exactly. Wait, this is insane. And then they change their mind. Some haven't though, but some have.
Oh, I am struggling to find this case in the court of. I don't have the court of. You know what? This is what I need to do. I need to pull up the Court of Appeals decision so I can just type in that case number. Okay, that's what I'm going to do right now. We're just going to see what these interlocutory appeals were. But getting back to the original question that prompted me here, no, I see no motion for a directed verdict filed. That's what was going on.
Longest answer ever.
That was an hour ago that question was posted. I see no motion for a directed verdict. That's the bottom line here.
Okay, so that could cause a problem potentially.
It could.
Yeah.
TDC Helm. Hey, Amy Z. Are you the Amy from the Detroit Cast? By the way, the Detroit Cast is an awesome YouTube channel and podcast. I used to sponsor them, and Mike Walters was a radio producer for many years. And when their show was shut down, 10, 12 years ago now, he went off and he created the Detroit Cast, and awesome show. And I've been trying to work with him for the last year or so doing this YouTube thing, but he's been busy. But hey, Amy Z, if that is you, awesome. Good to see you and welcome. Thank you for the $10 super chat.
Welcome, Amy.
Hello.
Okay, I got to get caught up. If I missed your question, I'm scrolling all the way to the bottom of the chat. If I missed your question, repost it again, because we're just talking here while this is going on. Oh, Aaron, with the $10 super chat. After watching this trial, I went back to rewatch your day one stream of the Miller hearing to hear his audio on 11/29. Hear whose audio? I realized again, this was all him. Oh, his.
Remember that?
Yeah. This would have happened no matter what, in my opinion. Yeah, his audio. By the way, if you guys aren't familiar with the Miller hearing, in Michigan, if you're a juvenile and you're charged with a felony that could net you life in prison, they have to give you the possibility of parole unless the court is convinced otherwise for a myriad of reasons. That's the Miller hearing. And we had 5 days of the Miller hearing for Ethan Crumbley, which I really wanted to watch to gain some information as to how this case might go, Jennifer's case and James's case. It's a really interesting, sometimes really stupid hearing with Jamie. You were there with me, right? This is all race. If he had been a black student, he would have gotten more attention, according to the doctors, who also dropped an egg in court to say that this kid suffers from a head injury.
I know.
It was so stupid. It was stupid.
Yeah.
But anyways, you guys go check out the Miller hearing.
Yeah, you guys should. And I agree, Aaron. This would have. I think this would have happened no matter what. They could have got him therapy, and I don't think it would have made a difference.
They can't bring that Miller hearing stuff in, though.
No.
Right?
Well, no,
because he didn't testify.
Yeah,
of course.
Because Ethan didn't testify. It was.
Yeah.
I think the state pushed.
Well, wait though, like. I mean, in my opinion, all of that is so prejudicial because none of it the parents knew about. Like people kept, I was in this other stream and some people kept saying they should have brought the baby bird. And I was like, but that had nothing to do. They didn't know about that. That was something he did on his very own.
There's no evidence that they even knew about the journal, yet they got it in. Anything Ethan related other than the pew was completely, the parents didn't know. They didn't know about the journal. They didn't know about the text messages. They got in what they wanted or what they could get in. The state wanted Ethan to testify. Absolutely wanted Ethan to testify. And so when Ethan was going to testify, the defense was prepared to bring in his medical records to show, look, he's got no signs even now of a mental health issue, let alone back then. And there was a lot of information that could have been used to help the parents from the Miller hearing if Ethan was going to testify. Since he wasn't, the state brought a motion to exclude his text messages and his journals as impermissible hearsay, which, as I'm drafting a motion against the Oakland County prosecutor right now for hearsay issues on one of my trials, I'm still more and more convinced that those journals should not have come in. Any of it. But
I'm just going to try and find the playlist that has the Miller hearing in it. Is it a separate playlist, David, or is it just part of the same?
No, it's all. So I have two playlists. One is Jennifer Crumbley's trial, and the other one is James and Jennifer Crumbley, like the whole thing.
Right.
So I don't have anything specific to Ethan, mainly because I don't care about his case. I don't care about him. It's a slam dunk case. I only care to the extent that it affects his parents' case. Right. So I never put. I should though. I could put a
Miller hearing separately.
Ethan Crumbley Miller hearing. I could do that.
Yeah. Okay, that would be cool.
Tara with 5 Canadian dollar redues. I can remember the defense closing nothing of the state. Wait, the defense closing nothing of the state. Oh yeah, I can remember the defense closing, comma, nothing of the states. Yeah. Well, that was my point. Like all weekend long, right? I'm just remembering Shannon Smith's closing, for better or worse, right? Everyone was talking about it. Even people in Australia apparently were talking about it, but nobody was talking about the state. And I think the state's arguments, they were too technical. They were boring. They lasted the same length as the defenses, but felt like it was twice as long. And then the last words, she's just screaming at the jury. So unless you had an emotional reaction to being yelled at by Karen McDonald, I don't think they're remembering it much. The witnesses that dealt with Ethan couldn't foresee or think he would have done it. Same with JC. Same for JC. Yes, I agree. Thank you very much for the $5 super chat.
I agree 100%. I don't remember a thing from the prosecution, but I loved Shannon, and I know a lot of people hated it, but I loved it.
She was definitely a Columbo.
A lot of people.
I think a lot of people hated it because she was just being like herself, and people didn't like her in the first place. I don't really care.
That's true.
And I thought she was so funny. I thought she drove me crazy sometimes, obviously during the trial, but I thought the closing was funny.
And she even said that, like she said, like
I thought it was really relatable.
If you might hate me, but
it's a closing I would have given. In the same style and vein. I probably wouldn't have been talking about TikTok, but it's the style of closing I absolutely would have given. I'm just letting you guys know we're still waiting for court to go live, so we'll see.
I think they said 9, so yeah.
Well, court starts at 8:30. Jury supposed to be there at 9. I didn't know if there was going to be any pretrial stuff. They go live with things before the jury sometimes, so.
Yeah.
Why is Jennifer not
like her personal stories in there? But I thought it was funny because it's every mom I know. My mom, every mom I know is exactly like this. So
it's exactly like what?
They have so many things on their plate. They're just like all over the place. So it's just like, craziness. And then having teen kids, like everyone knows what it's like to have teen kids. You were a teen. They don't want to hang out with you.
Even if you don't have teen kids, you remember what it was like to be a teenager and the
exactly
shit you put
like
your parents
me.
Through. Yeah, like you.
It related to me. Even I don't have a teen kids, and I don't have kids at all, and I still was like, I get it.
So, KKP or KKB has a question. Why was Jennifer not allowed to use the info that came out during the Miller hearing? Well, it depends on what you mean by that. Like, can you use the transcripts of it to develop your question of your, the witnesses and things like that? Absolutely. Can you use particular exhibits from there? Yes, depending. All right. So we have the hearsay rules and we have all these other rules that we need to follow. Obviously we weren't going to get the medical examiners in that examined Ethan because Ethan at the end of the day wasn't going to testify. Even if the state didn't put up a fight about that, but they didn't call Ethan, you kind of still don't want them in because, on balance, they're probably more damaging than they are good. You're just sort of preparing a defense to the state trying to use Ethan, right? So they could have used a lot of the stuff, and I'm sure her attorney was watching the Miller hearing and taking copious notes.
You would think.
But you don't want to call in. I mean, you can't impeach the prosecutor for arguing that it was entirely Ethan, and then arguing in Jennifer's trial that it was entirely her, because prosecutors are allowed to plead inconsistent theories. So, where can we find the Miller hearing? All right, we're going to work on that. Excited? Did you put a link up for anything yet?
For the Miller hearing?
Yeah.
Can't find it.
Okay. This is what I'm going to do. I am
I'm looking.
Okay. Hang on. All right. So let me create a playlist just for the Miller hearing while Jamie talks about something.
Anyways, how does everybody feel about them having the weekend to think about this?
I love it.
Do you think it's a good thing or a bad thing?
About the jury, the jury having the weekend to think about it, about the closing statements, about the closing arguments?
Well, yeah, the jury going home for the weekend and then coming back to deliberate.
I hope they didn't go look on TikTok. Personally, I mean that would be against the rules. But I mean, Shannon brought it up.
I think they did.
Yeah, and if they did, I don't know, like, because obviously I've been on there a lot to go and research for the stream I did today, and it's really like Shannon has turned into a meme, and it's in not a good way. And also Jennifer has been brought along for the ride with that. So, and this has been since the beginning of the trial, and it's a shame because this is an important case. It's a really important case, and I wish that, if considering, like, we watch so many trials play out, and when they play out on social media, they tend to play out around the actual facts of the case, sometimes around the personalities. That's fine, but not so much about the lawyers as much. Like some with Murdoch,
but think of Johnny Depp.
Was about Harpootlian. Yes, but Johnny Depp was, I mean, really, when it came down to it, Johnny Depp and Amber Heard were the main players. Camille got in there, yes.
Camille got her thing.
Yes, but in a good way, really. And there was Elaine, yes, but it was still Johnny Depp and Amber Heard. So
I have the playlist. I'm putting it in chat.
Yay! Nice job.
All right. So I hear recording in progress. And if you guys didn't catch it earlier, we're going to try to do a Zoom feed for this, just because I feel like it's going to be better audio. And once it starts, though, it's going to be hard. Well, we can't pause it. So we're just not going to be talking. But they are up and running. The court is up and running. So we're on our way.
Yeah, I hope TikTok makes them feel sorry for the defense.
I think they make her look endearing, but I don't know. It's like, I wasn't, I don't know. Everyone was ranting and raving about Camille Vasquez. And wait, which one was Johnny Depp's attorney?
Camille.
Yeah. And I was like, she's okay. I mean, she got handed some softball, witnesses to cross-examine, in my opinion. I think she did well, but and she performed well on stage, but otherwise I was like, yeah, she's all right.
Yeah.
But the, social media made her a huge star.
Well, because everybody hated Amber so much.
And she
demolition and nuclear reactors. I am this is, by the way, this is the cockpit door for the Millennium Falcon. Thank you very much. I have been kicked out of, evicted from my treehouse. So now I'm a homeless internet lawyer in space. That's what's going on.
Got kicked
Oh,
out.
now David's in space.
Poor you. Poor you.
Hey, Lefty, welcome. Okay,
Oh.
now I got
Hey,
like all this
Lefty.
stuff out of the way. I got the playlist out of the way. The stream is going. Okay, cool. Now I can like focus on you guys, watch the chat, and talk to you guys.
Yeah.
Do you think do you think the TikTok thing would be bad? Well, first of all, let's assume the jury's watching it, right? She brought it up. Let's assume the jury's watching some social media. Overall, on all the social media that you guys saw, do you think that that's going to be good or bad for the jury to see?
Had they been watching? It depends if they've been watching it the whole time or if they just started watching it this weekend because she brought it up. If they have been watching it the whole time, I think they're probably potentially they are getting more and more annoyed, and the social media is just feeding that because that's what tends to happen when people are influencing your opinion, because that's like, honestly, it's 90% out there. Shannon's terrible and she's annoying and guilty. Whereas if they only started to look at it on the weekend and they'd already made up their mind about whether they like Shannon's style and how they feel about the whole case, they probably would be like, hey, why are they attacking this woman? We kind of like her. This is a bit crazy. This is all happening. So
see, like that second approach, I think it could work in the defense's favor.
Exactly, yeah.
We heard so much about James and Jennifer in the media, and that's not what we saw in trial, right?
Yes,
so
yeah.
I feel like a reasonable jury could see that. And maybe it'll just refocus them on the evidence. All right, now we need to actually look at the evidence. Do I think female lawyers are held to a different standard than male lawyers? Yes.
100%.
But they also, I feel like they do it to themselves a little bit. There's a lot of female attorneys, just in my experience, that seem like they have to come across as assholes or bitches in order to like make a point. And I don't think they do. There's some really good female attorneys that I've gone up against. Like the old saying is like two guy attorneys. We go in to court and we'll argue back and forth, and then we'll go golfing after the hearing together, right? For some reason, I feel like there's a lack of that camaraderie with female attorneys, and I think they do that to themselves. They feel like they have to prove something, and they wear it on their shoulders a bit. But they do. With that being said, though, we were discussing yesterday on Excited Utterances channel that we have all these memes on Shannon Smith, but Karen McDonald had moments just as bad, especially during her Judge, it's my closing. How can she interrupt my closing?
I thought so too. I agree. And not just her, the male prosecutor, sorry, don't know his name, but he was a bully. He was horrible. He had some terrible moments. And no, I don't see any memes on him. I actually didn't see anyone bring him up outside of this space here. So what's going on with that? Why is this all about Shannon? Is it because I don't think it's because she's a woman as much. I think it's because she's for the defense and people don't like Jennifer and don't like that she's the shooter's mom.
I think the default is defense is bad, prosecutors good in this case.
Yeah.
And that's, but I don't know. Then you compare it to like Johnny Depp. I'm trying to think of one where the news media was completely one-sided, and then at the end of the case, they were completely other side.
They weren't completely one-sided in Johnny Depp.
Well,
I know you think they were, but they weren't. It was Johnny Depp.
No, I heard a lot. It was all pro Amber Heard going into the Johnny Depp trial. Well, I don't know. That's what I heard.
I did.
I wasn't watching the case like in depth. I wasn't paying attention to it at all. I was just sort of on the periphery. I wasn't streaming live trials then. And the media that was being fed to me was all pro Amber Heard.
I don't know. Maybe it's
here we
more
go.
from an international sense because I see things from over here. But from over here, it looked like Johnny Depp was going in.
222799990 Good morning, Your Honor. Karen McDonald on behalf of the people.
Thank you, Marquise, on behalf of the people.
Good morning. I'm Shannon Smith on behalf of Jennifer Crumbley, who sits to my left.
Good morning. I think a couple things. I sent you an email over the weekend.
Thank you.
Regardless of the verdict in this case, we've agreed that the gag order will stay in place until after the trial of James Crumbley. Is that
Yes.
correct?
That's correct.
What?
All right. And can you approach on another matter?
Well, I guess I'm not getting an interview. I had sent Miss Smith an email. Excuse me,
Sorry.
for an interview after this trial was done, after the jury verdict. So I guess I'm going to have to wait on that.
Sorry, what did we just miss? Why aren't you getting an interview?
The judge just said the gag order is going to remain in place until after James's trial, which is scheduled for early March.
Gotcha.
Yeah. So
Damn.
Mark got a haircut from a bald barber. Never trust a bald barber or a skinny shot.
Or a blind one.
A bald barber.
They
said
have no
that?
respect for your hair. I said that. Never trust a bald barber.
Is that your life
My
mantra?
That's my mantra. Never trust a bald barber or a skinny chef.
Or skinny chef, yeah.
Not the jury, though, right? Not the jury. No, the jury would be allowed to talk. And actually, I
That's
did email the
interesting.
clerk, and I said, would you please pass on my information, my contact information? I gave it all a list. If any of them wanted to speak about this. I really
That's
don't like the cops sitting
interesting.
there with the prosecutors. Yeah, a lot of people had questions about the cops sitting there. So the theory behind this is that let's assume this wasn't a big sensational case, right? 99.9% of all the criminal trials, you have one prosecutor, one defense counsel, nobody in the audience, and the defendant, right? And so the idea is well, the defense attorney gets the defendant to help with the case. So we're going to allow the state, an officer, usually the detective in charge, to help the prosecutor with the case. And that's it. There's usually 4 people and the jury and the judge. So that's the idea behind it. But then when you get bigger cases like this, you get 2 prosecutors, then you get the lead detective. And then after the other detectives get off the stand, they want to stick around and help out. There's actually nothing wrong with the defense having the same thing. They just usually don't. Like if you had friends and family that you called to the stand when they're released, then they could sit behind you and, offer support and things like that. What was it? Think of, again, I keep going back to Johnny Depp, but think of what's her name's girlfriend that was sitting in the back passing messages and things. She wasn't listed as a part of the defense team. That was why she got in trouble, but she could have been. We need to get a poll up. Let me get a poll up.
A poll, like a Festivus poll.
Yes, Festivus for the rest of this.
You both have copies of the jury instructions.
Yes, sir.
Okay, so I'm going to sign copies in as well.
Yes, thank you.
How will the jury vote? Guilty, not guilty, hung? That's going to be the poll. All right, the poll is up and running. Dude wants to be Boone's. Oh my God, that would be amazing. I would be standby counsel for Boone, so I get a front row seat to that train wreck when she represents herself eventually.
I'm sorry
to take a plea deal. And
sorry to tell you this. I don't think that's going to trial. I agree, Jamie.
It shouldn't. That is a case that should not go to trial.
No.
Farrell, welcome. And by the way, for everybody who is just joining us, the plan is we're going to listen to this jury instructions, and then I'm going to redirect you all to a jury verdict
I told them to bring all
watch
their personal
stream.
belongings, so that's probably what's taking a little bit of time.
And I'll go live with that watch stream. Probably not right when we get a verdict, but maybe a little bit earlier. We'll play it by ear. But hit the notification button when I redirect you guys all to the verdict watch, so that if we do get a verdict, you will immediately get a notification. And then if you are a member, make sure you log into my Discord, because you'll definitely get a notification there.
All rise for the jury.
Yeah, me too, Nicholas. Thank you very much for the 50 Swedish krona. Megan Amirowitz is a friend of Jennifer's and was on the state's witness list. And I believe truly that they put her on the witness list to have her removed from the courtroom so that she wouldn't be there for moral support for Jennifer.
You've all been so wonderful and timely that I have another jury starting next Monday, and I'm wondering if you'd all be willing to come back and help me with that. No? Hard no? All right. I'm gonna read you some jury instructions. You're gonna get a written copy of these in the jury room. Then I'm going to pick 5 of you by random who are going to be alternates. I know that you've all been in 2 different jury rooms, so when you're brought together, it's going to be like the show Survivor when the teams are merged, right? The tribes are merged, right? So I know you've been in 2 different jury rooms, but we'll be putting keeping the 5 alternates still sequestered in Judge Anderson's jury room, and the 12 will be in my jury room. That's why I asked you to bring your personal belongings when you came in here. All right.
All right, let's see who these alternates are.
Members of the jury, evidence and arguments in this case are finished, and I'll now instruct you on the law. That is, I'll explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless you're satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits submitted as evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyers' questions to the witnesses, my questions to the witnesses, are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's disability, race, national origin or ethnicity,
I think
gender
everybody
or
was
gender
white
identity or
and
sexual orientation,
handy
or
capable.
religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all of the other evidence? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. James Robert Crumbley and Jennifer Lynn Crumbley are both on trial in separate cases. The fact that they are both charged is not evidence that either one is guilty. You should only consider the evidence presented in this case. Each defendant is entitled to have his or her case decided on the evidence and the law that applies to him or her.
Glad to
The
see
prosecutor
lefties
must prove
optimistic.
beyond a reasonable doubt that the crimes occurred on or about November 30th, 2021 within Oakland County. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. There has been some evidence that the defendant ran away and tried to hide after she was accused of the crimes. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of a consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind.
Who keeps coughing? Who's like wheezing in the
before
background?
the trial, a witness or witnesses made a statement that may be inconsistent with his or her testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness or witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness and or witnesses said in the earlier statement when determining the facts of this case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. You should not decide this case based on which side presented more witnesses.
David,
You should think about what
Jesus.
about each witness and each piece of evidence and whether you believe them. Then you should decide the case. You must decide the case. You must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty.
It's just a bit much.
A lawyer or lawyer's representative talk to one of the witnesses. There's nothing wrong with that. A lawyer or lawyer's representative may talk to a witness to find out what the witness knows about the case and what that witness's testimony will be. You've heard testimony from witness Detective Edward Wagrowski, who has given you his opinion as an expert in the field of forensic cell phone analysis. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how
Like a
important it
Derringers
is.
for target practice.
When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they give for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards used to evaluate the testimony of any other witness. In count one, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Madison Baldwin. That is, that Madison Baldwin died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing that act caused Madison Baldwin's death, the defendant acted in a grossly negligent manner. In count two, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Tate Muir. That is, that Tate Muir died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Tate Muir's death, the defendant acted in a grossly negligent manner. In count three, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Hannah St. Juliana. That is, that Hannah St. Juliana died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Hannah St. Juliana's death, the defendant acted in a grossly negligent manner. In count 4, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Justin Schilling. That is, Justin Schilling died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Justin Schilling's death, the defendant acted in a grossly negligent manner. As I explained earlier in my instructions, the prosecutor asserts 2 different theories to support the charges of involuntary manslaughter. First, the prosecutor claims that the defendant committed involuntary manslaughter because she failed to perform a legal duty. In the alternative, the prosecutor claims that the defendant committed involuntary manslaughter because she was grossly negligent. Those theories are 2 different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. In count 1, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Madison Baldwin. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Madison Baldwin was directly caused by defendant's failure to perform this duty. That is, that Madison Baldwin died as a result of the defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count 2, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to tape mirror. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent their minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Tate Muir was directly caused by defendant's failure to perform this duty. That is, that Tate Muir died as a result of defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count 3, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Hannah St. Juliana. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child, and B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Hannah St. Juliana was directly caused by defendant's failure to perform this duty. That is, that Hannah St. Juliana died as a result of defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others, or the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count 4, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant had a legal duty to Justin Schilling. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent their minor child from intentionally harming others or prevent their minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Justin Schilling was directly caused by defendant's failure to perform this duty. That is, that Justin Schilling died as a result of defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. There may be more than one cause of death. It's not enough that the defendant's act.
I just have to kill some mozzies.
In order to find that the deaths of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. As previously noted, there may be more than one cause of death, and the defendant's acts or inactions need not be the sole cause of harm. In order to find that the death of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting someone was reasonably foreseeable. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another, that is, she knew there was
15.
a situation that required her to take ordinary care to avoid injuring someone. Let me read that again. First, the defendant knew of the danger to another, that is, she knew there was a situation that required her to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. I think I've told you this before. I'm not sure we did the greatest job at this, but I previously ordered the parties to be precluded from using the shooter's name during the trial. When you go to the jury room, you'll be provided with written instructions of the final jury. You'll be provided with a written copy of the final jury instructions, and you should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you will discuss the case amongst yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to my clerk. Possible penalties should not influence your decision. If the defendant is found guilty, it's my duty to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the clerk. It's not proper for you to talk directly to me, the lawyers, the court officers, or any other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. I believe that the defense exhibits are hard copy, and the prosecutor has their exhibits on a thumb drive. We have a computer that we're going to set up in the jury room, and you can look at those exhibits. If you want anything else, you can let us know. I think it's a thumb drive, right?
It's a portable USB or hard drive.
And Your Honor, I just want to make sure that mine are in a binder. I left it for Ashley.
Okay. Yeah, we're going to send all the exhibits in right away.
I've always said, I feel like they're going to come back with a verdict at some time late
They'll be
this
given a
evening,
written
but I
copy.
might be
I think I told
way
you
off.
this
I have no idea.
earlier. We can replay a witness. That it's very possible. And I think I told you this in the beginning of the trial. You can't, however, fast forward to the spot where you have a question and I'll yell, aha. You have to hear the whole witness, direct, cross, redirect. It's the only way that it's fair to both sides, but it is possible to replay testimony. All right. The defendant is charged with 4 counts of involuntary manslaughter. These are separate counts, and the prosecutor is charging that the defendant committed all of them. You must consider each count separately and all of the evidence in the case. You may find the defendant guilty of all or any one of these counts or not guilty. I have a verdict form here. It's like a flow chart. There's questions. Number 1, involuntary manslaughter as to Madison Baldwin. You can check not guilty or guilty of involuntary manslaughter as to Madison Baldwin. Count 2, involuntary manslaughter as to Tate Muir. Not guilty, guilty of involuntary manslaughter as to Tate Muir. Count 3, involuntary manslaughter as to
It's going to be
Hannah St.
all
Juliana.
one way or the
You
other.
can find the defendant
It's not going to be
or guilty of
two kids
involuntary
and not guilty
manslaughter
of
as
2
to
others.
Hannah St. Juliana. Count 4, involuntary manslaughter as to Justin Schilling.
There were
You
no
may
jury
find the
questions. They
defendant
weren't
not
allowed.
guilty or guilty of involuntary manslaughter as to Justin Schilling. So I'm amazed that we maintained 5 alternates. It's, a credit to how great you were at being here in time and following the instructions. And we're so
I'm wondering who's going to get removed.
So we're going to choose 5 alternates, but I'm still going to sequester you. All right. I'm gonna have you kind of cooling your heels and being bored in Judge Anderson's jury room. If deliberations went beyond today, I might consult with the lawyers about dismissing some or all of you. I think you can imagine that this has been
Why do you say that, Josie?
stressful event.
Because you saw
Both
Zachariah
parties,
Anderson
the
trial.
prosecutor,
Oh.
and the families.
Okay.
And it's been a lot.
Because if you spent 5 cases
So,
watching
you all
trials, you
I just wonder
so
whether it's something particular about this jury.
look
That's
at
all.
your names.
it's
My
all
purpose
juries.
is to take you to Judge
Just all,
Anderson's
yeah, I don't trust any
jury
jury.
room. You've all ordered lunch, so
Yeah, I can't pause
and
anything
match up
right
the
now, so we're going to
numbers,
listen
and you'll,
carefully, and then we'll
get
talk
your
after
lunch
the
in a while.
judge
I know you're
is
gonna be
done.
kind of bored still
I'm
for
going
a
to take
while,
up
but,
another feed too and go back
we just want to be sure that
after this.
we can conclude
Yeah.
this trial. Then the other 12 of you will go into my jury room and start deliberating. I should also say the 5 of you that are sequestered still cannot discuss the case or do research or Google it or look at newspapers or go on Facebook. So you're still sequestered as if you're home. All right. Sometimes I would, I thought about sending you home, but I'm gonna keep you for a little while. But you're still sequestered. Can't look at any media or talk to anyone about the case and can't discuss the case amongst you 5. The 12 of you can start deliberating momentarily. I'm going to consult with the lawyers to make sure that there aren't any errors in the jury instructions. Bring in the exhibits and then you can start deliberating. It's important that you only deliberate when you're all there. If one of you steps out for some reason, you shouldn't be deliberating. And you can send us notes about when you want to take a break. I still would like you not to go to the cafeteria, please. And be careful if you're walking through the courthouse, because there's obviously a lot of interest in the case, as you know. And we've gotten this far. So in any event, I'm going to choose 5 of you randomly, and those 5 of you will go to Judge Anderson's jury room. All right. Juror in seat 15. You're 15, seat 15. Juror in seat 17.
We got 17 off.
Juror in seat 10. 10. Are you 10? Seat 10? You're in seat 10.
Yeah, we'll go over the jurors that were removed.
Juror in seat 4. Juror in seat 4.
You gonna know who they are based on this? Sweet.
And juror in seat 9. All right. So 17, 15, 9, 10, and 4. I'm sorry that you'll probably be bored. We'll get back with you as soon as possible. All right. I did bring some cookies.
Cookies.
Candy, and there's muffins and what else?
And muffins.
Licorice, oranges, apples. So, all right. So if you could, I'm trying to think of it. Might be best to come this way. There's, can you go? Can they go both ways? I know it's so crowded. It's the coziest my jury box has ever been. So I'm gonna ask the alternates who I chose to go to Judge Anderson's.
Well, that makes it all better. Cookies and muffins.
We'll bring you
Maybe
coffee.
some board games.
All right, so someone was asking about 60 years versus 15 years sentence. Michigan is a concurrent sentence
All right, so I'm gonna
jurisdiction
ask you to go to the jury
by
room.
default
Give me a
with
moment. I
minimal
wanna consult
instruction
with the
or
lawyers
minimal
and make sure
differences
that
or
there are no errors in the
exceptions.
jury instructions. I'm then going to send in all the exhibits and copies of the jury instructions for you. All right. And if you all decide you're going to leave and walk around or whatever you're going to do, just let us know. We will all be awaiting you. Okay. All right.
All rise for the jury.
Let's just make sure that there's nothing else that they're going to talk about. Again, I can't pause this feed because this is live from the court via Zoom. And then I'll shut it down. And then we're going to go back to another feed because I want to get a clear record of what the jury instruction is with regard to the 2 various theories.
Anything about the jury instructions?
No, Judge, not from people.
Nothing from the defense.
Okay, we're gonna send in the jury instructions, and you're giving us,
Hey, first,
yeah, that computer can handle that, right? You're not giving us any hard copies. You're obviously not sending the gun in or anything like that,
Correct.
right? Yeah. Okay, and we have your exhibits. Please make sure we have phone numbers for you, because you get that usual question. Can we have copies of the police report? All the questions that usually come out of there. So
there are 5 exhibits that we didn't include in the USB to the jurors. That's the shooting video, the photograph with the blood from the bathroom,
okay,
crime scene photo depicting the 2 victims,
okay,
the video that was played with Gibson Marshall, and the video that's played with Molly Darnell.
okay. Do you want me to somehow tell them that? Maybe I should bring it back up.
They should be made aware of that, Judge.
Oh, okay. Well, I would have told them that before they went in. Can you write those things? Do you want me to just tell them?
That's fine. I can write a note on the envelope.
Okay. Or we can give you a, you can maybe write it there, a note. Just if you can initial it and Miss Smith initial it. All right. What else? Please just be sure that we can find you, because sometimes there's questions.
I'm gonna be right here.
How many
We're close
sets
by.
of instructions are we sending you? We could send 12 sets of instructions in. Maybe. Is
That would be good. Yes. And
Maybe they all want
like I
their own.
said, the jury will get all written copies of those instructions that the judge just read out. So someone who said the judge was reading fast, the jury's going to get written copies. And it sounds like they're each going to get their own copies, so they could take their own notes and everything in their own copy.
Yes.
Usually I have these prepared ahead of time,
Those
and
are,
I want to make sure
yeah,
the
and then I
jury
gave
has
the
them.
binder, so these are the binder. Yeah, the binder just has it like in pages or page covers. Thank you.
I don't know what Marky Mark just said. I
He said
wasn't
that
listening to him.
he wanted to mark the USB with the shooting video, the crime scene photos, and something else.
Oh, he has a USB full of all of their evidence is on a USB, so he just wants to apparently mark
I
it.
hope everybody here would be careful not to have any interaction with any of the jurors.
Yeah.
Again.
Yeah. Well, that one juror seemed to be like hanging out after court was off and just sort of like hanging out in the lobby, just I'm a juror. look
I
at my
think some
badge.
members of the media have asked the jury instructions. He
I
emailed
would
to
have
me.
went home immediately.
I agreed
I know,
to
right?
do that as soon
It was
as I
Friday
got
night.
them to the
It's
jury.
like I'm on my way out.
Have you ever been married, Jamie?
Welcome,
How do you think-
Broken Baker and Feral Housewife. By the way, now I got to put Feral's link in my channel description.
Sure.
By the way, all of my guests are linked in the channel description. So if you guys want to figure out who these people are and why they're so important, their channels are linked, except for Jamie because she doesn't have a channel yet.
What did I tell you? This is her channel. She just lets you pretend it's yours.
Yeah, that's fair enough. This is Jamie's
Same as
channel.
mine.
Yes. Yeah, exactly. Jamie has 2 channels.
I have 2
You
guys.
see Jamie on the Broken Baker
Those are
and
some
MLS
pictures
any
of
day
that.
of the week.
If you have any thoughts about the other thing I raised at the bench previously, let me know.
Michael Martin had a question about if you would have asked to reject all the sheriffs from the room, not to seem
All right, so I'm
prejudicial.
gonna send in the note.
Hang
I'll
on.
let you
Let
know.
me.
Okay.
Thank you.
Thank you for spotting
All right.
questions for me. All right, court is off. Okay, what was that question now?
He asked if you would have asked them to remove all the bailiffs who wasn't necessary because it seems prejudicial against her.
I would have, absolutely. I would have asked for minimal bailiffs, but that was probably not going to happen. I still would have asked for it, though.
They probably could have had them spread out a little more. They were all
Yeah.
standing right there by the door, right by her.
Yeah, I noticed. Okay, so a lot of people have been talking about the possible sentencing. Now, this is a 15-year maximum sentence per involuntary manslaughter. And there seems to be some confusion on other mainstream medias about whether or not, if she's found guilty on all four, if it's going to be 60 years. So what we're talking about is consecutive versus concurrent sentencing. Michigan is a primary concurrent sentencing, meaning we serve, if you're found guilty of multiple offenses, you will serve them all at the same time. So essentially, whatever the longest sentence is, that's the one you're going to serve. There are some exceptions, but none of them apply here. So the following so essentially, what Michigan has said is that unless it's specified in a statute that it's mandatory consecutive sentences, meaning stack them on top, you should get 60 years, then it's not really going to happen. So those are mandatory in certain statutes, such as crimes committed while incarcerated, like escape and things like that, parole violations, major controlled substance offenses, prison breaks, jail breaks. Most of it is escaping stuff, felony firearm offenses, and prisoner taking hostages. Those are mandatory consecutive sentences, meaning that you'll get one stacked on top of the other. Discretionary consecutive sentences, where the judge has the option, are offenses committed while pending a felony charge. Okay, so if you get a second charge while a felony charge is pending, first degree home invasion, carjacking, CSC, which is criminal conduct, assaulting and battering, witness tampering, using a computer to commit a crime, a certain S crime, and manufacturing or delivery of controlled substances. So those are discretionary. She could get consecutive if she was charged upon those, but involuntary manslaughter is not available for consecutive, so she will serve them concurrently. So if she gets the max on all four counts, she should only get 15 years with credit for time served, which is 26 months, I think, total. So if she was sentenced to the max, she'll get 13 years, a little under.
So that's 13 years. That is the top.
Yeah, so 13 more years. Yeah, so that's the top.
So assuming, so let's say that the judge is lenient. What could be the lowest end, do you think?
Time served.
Time served?
They will always give you time served. So even if it's like probation, right? Even if so for example, I get a lot of guys that are like DUIs, right? And they spend a night in jail. Well, they're not going to get jail time for their first offense DUI, but they'll sentence them to 1 day jail with credit for 1 day served, because they've already served their day in jail. So they're going to give them credit. So she's the lowest she'll get is time served. And then she'll be out, and she'll probably get, 5 to 10 years of probation or parole, or not parole, but probation.
Do you think that if it were to be a guilty verdict and she were to be lenient, that would play out very badly as far as the public perception would be? It
depends on how she does it, right? Like, think of Judge Valentine with Megan Nemirowitz. She got time served, and there were a lot of people that were against that, but she phrased it in such a way, I think you will have, you had a terrible childhood, and I feel sorry for you. And while you were convicted of this offense, I don't think that you it will be, there will be no further justice by having you incarcerated for years and years and years, and gave her time served.
I thought she was wonderful. I agree with that.
Judge Valentine,
I thought she was fantastic. I mean, the thing about it is there'll be people out there, like angry mobs out there, who'll be like, there was a guilty verdict, and then you let her walk out.
Yeah.
And she's an elected official that way.
Dory Kay actually wrote in the chat that the bailiffs might be there to protect her because of the
they could
move
be
against her.
The judge.
They could be.
Well,
I mean, like I said, a couple of weeks ago, we just had somebody charge the judge, right, in the courtroom. So
that's true.
They could be there for her protection as well as.
It's actually a really similar setup. Like when I first saw the judge and the marble background and her, I was like, "Is that the one who got charged?" It looks really similar.
Honestly, that's my first thought when I saw the base. So I was like, well, this is a high profile case. Parents are angry. The community is angry. I think it's for Jennifer's benefit.
Well, when I say time served, I mean if she's found guilty, right? If she's found guilty and she's going to get any jail or prison time, they're going to, sentence her to time served. Is a possible lowest thing and let her out kind of thing. But they're also not going to sentence her right away. If there's a verdict that comes back today, they're probably going to keep her in and then do a pre-sentence investigation and report and things like that. So she's not getting out today, even if she'll get out today if it's an acquittal. Absolutely.
So how'd the jury instructions go, David? I missed most of them.
Yeah. So that's what I wanted to potentially go back to. I'm indifferent.
Do you know who was removed? Because Judge Juros asked,
that too.
Please say which jurors got removed. Was it the gun owners? And when the MLS, don't they need to prove Jennifer knew he was going to do this? And that's my problem with this. How would she be supposed to have willingly let him do it if she didn't know it? And they haven't proven, other than he wrote it in a journal that he brought to school.
I have a problem with the first theory. So the first theory of the gross negligence jury instruction: the defendant caused the death of the 4 kids by storing the firearm and its ammunition in a way that allowed Ethan to have access to it, thereby acting grossly negligent. Now, grossly negligent still requires, there's a grossly negligent statute or jury instruction, which she read almost verbatim as to the one that I put up. Obviously, this one's modified a little bit because it doesn't have, these give options, but grossly negligence means more than carelessness. It means willful disregard to the result of others that might follow from an act or a failure to act. In order to find the defendant grossly negligent, you must find each of the following beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, she knew that there was a situation that required her to take ordinary care. So you still have the knowledge part of it. It's in the gross negligence part, not in the underlying involuntary manslaughter. So you still have to know. Then the defendant could have avoided injuring another by using ordinary care, meaning taking ordinary care to hide the gun away, and that the defendant failed to use ordinary care by not properly hiding the gun. Okay, so I don't like the way the first theory is written, because if they don't read it in conjunction with this, then they're just going to say, well, I believe she didn't properly store it. Obviously she didn't, because he got it, and therefore we can convict. So I don't like that.
Yeah.
The second theory is a little more muddled, and that's what I wanted to go back through and take a look. I was trying to type it out as she was reading it. The defendant committed involuntary manslaughter by failing to perform a legal duty. The legal duty here is to exercise reasonable control over her son, Ethan, to prevent Ethan from intentionally harming others or conducting himself in a way which was dangerous to others. To meet this, a state must prove that she knew or had reason to know of the ability to control her son, knows the need for control, that she had the ability to control and the need to exercise reasonable control. See, it was like really weird. That's why I'm going to go back through. Knew that the facts that give rise to this duty, and that had the ability to perform that duty, and the death resulted as a failure to perform that duty. So I'm a little confused. So don't take my words right now for that. We're going to go back and listen to it again one more time and see if I can't clear that up a little bit. Because that's more on point with where I thought this was going. I don't like the first theory at all, because it needs to be read in conjunction with yet another jury instruction, which I have a problem with.
Do you want some questions from chat? I wrote them down as they came in.
Yeah, that'd be great.
Is medium preferable to Oakland County? Medium security prison.
Wait,
will
what?
she serve full time if convicted? When is sentencing? And did they prove where it was stored? And these are from Costco, Patty B, M. Shannon, and KMP, and the last one, 2 last ones. Did anyone look at Law and Crim chat while instructions were read? Nope.
No.
If they acquit Jennifer, what are the chances they drop charges against James? You have answered
none.
that.
Slim to none. They're not going to drop charges against James.
Right. He has different facts for him. So even if they do lose this one.
Well, think about the very first one. Was it stored properly? Well, Jennifer testified that James was in charge of storing the gun. So based on that alone, they're not going to dismiss anything against.
Right.
All right, hang on. I'm going to go over the jurors in a second here. I'm just marking them down. What was the other question that was asked?
Is medium prison preferable to Oakland County?
Is medium?
It's a medium county jail preferable.
Oh,
medium
like
security.
medium security prison. Well, she's going to go to prison over Oakland County Jail if she's convicted. She's not going to be in Oakland County Jail any longer. Prison's actually going to be better because they have health care and all kinds. Think of it as an extended stay hotel as opposed to your motel, right? The extended stay hotel is going to be a lot better.
I think Zach would beg to differ with you on that.
Better than jail.
I don't know how great
Well,
it's
neither
he's
one
being
is
treated
good.
in. Yeah.
Guys, the law and crime poll right now is guilty 51%, not guilty 30%, hung jury 19%.
That's
So 51% is guilty.
Yeah, but that's for law and crim. That's pretty
For
good.
law and crim, that is very split for law and crim.
Our poll is 26% guilty, 41% not guilty, and if I can get it again, 33% hung jury.
So is your poll what the jury will do, or what the jury thinks?
What the jury will do after hearing the jury instructions? What will the jury do?
We should probably be a bit clear about when we do the next poll, like not how we feel, but more what we think the jury's.
Well, that's what it is. What will the jury do?
Yeah, that's what Dave did.
Oh,
and
is that what you were?
I did a poll the other day too that said, setting aside your personal thoughts, what do you think the jury will do?
Sorry, apologies.
And sentencing will be a couple of weeks out because or maybe months, because they have to do that pre-sentencing hearing because it comes up a few times. Okay. So it'll take at least some time because they have a pre-sentence hearing where they look into all kinds of stuff.
Yep.
So it's not instant.
I'll reach out to Megan. Last time I reached out to her, she didn't seem too thrilled with coming on, but I'll definitely talk to her. So, is medium security prison preferable to Oakland County? Absolutely. I would say so. Absolutely. I mean, neither is good, right? You're still imprisoned either way, but it's going to be better than. By the way, there's only one female prison in Michigan, and it's down just south of Ann Arbor. It's down in Saline. I've been there. It's a fine prison, right? It's still a prison, but it's not the worst thing in the world. You have access to tablets and computers and whatnot, things that you don't get in Oakland County Jail.
Do you take your wife on dates there, like Expert does to White Rabbit?
Oh my God.
I do, of course. Why not?
Okay, good deal.
All right, you guys want to hear the jury makeup?
Yes,
we do.
Yes.
Okay, so juror number 1 is still on. That's a white female, works in human resources, has 2 adult children. Her father was a hunter. She gave up watching news 6 years ago. She's pretty uninformed regarding her father's guns. She knows her dad had guns and they were locked up. It was not for us children. That's what she said. Juror number 2 is still on. That is a white 26-year-old married male. He says he grew up in a strict Christian home. He works in sales for the mortgage industry. He took hunter safety when he was 16. He's not an avid hunter, though, now. His father had guns and has a concealed carry permit. The juror said he doesn't have strong opinions on guns. He doesn't have cable TV and tries to stay away from social media and despises TikTok. So I don't know if that one was going to resonate with, or the closing argument was going to resonate with that particular juror. He despises it. Actually, it might resonate with him if she's talking about how stupid TikTok is and he despises it.
Yeah, it could.
Juror number 3 is still on. That is a white female hairstylist. Says she's familiar with the case, has no issues with guns, and can be impartial. Juror number 4 was removed as an alternate. So juror number 4 is still there as an alternate, could still be placed in the jury, but is currently not deliberating. This is a white female engineer. Husband is a lawyer. She said she'd be fair and impartial, and it's not a good parent, bad parent decision. See, this is kind of someone that I thought should be on the jury. The jury will be making it's not a good parent versus bad parent decision that the jury will be making. It's not why we're here. She did note, however, that she no longer goes to movie theaters or shopping malls following the mass shooting in Colorado, which shook her sense of security. So that one is removed.
I have a graphic that someone has made showing the makeup of the jury. I might just, if I present it to
I'll take a look at it.
Yeah, cool.
Yeah.
Fantastic. Yep.
Juror number 5 is white female married. She's still on, by the way. Jury number 5 is still on. So white female is married, has guns in the house, and says they are locked up. She has 2 grown children and recalls taking gun safety classes with the family when the kids were young. She works for a bank and her husband is in advertising. I feel like I can be fair, she said. Juror number 6 is still on the jury. This is a white female, married and retired compliance specialist. Her husband is a retired meat market owner, and her daughter, a special education teacher. She was on a jury many years ago. This is also apparently the jury who is taking furious notes. This juror is taking a lot of notes and seems very interested in everything that everyone has to say always. I suspect it might be our jury foreman. Juror 7, white male doctor. This guy I liked. He sees a lot of gun violence. He owns multiple guns, and he stores them safe. He calls himself very strong proponent of the Second Amendment and goes to shooting ranges about once a month, maybe even twice a month. He's still on the jury. I like him. That's good. Juror number 8 is a white male automotive engineer. I like an engineer. He has 2 twins. He has a collector's gun that belonged to a relative, service in war. He doesn't know where he doesn't have any ammunition, doesn't know how to use it, doesn't use guns really. He just has 1 firearm. Juror number 9 has been removed. This was a white female first grade teacher, married with 2 grown children and 1 older teenager. I don't have guns. But I understand that they are legal, she said. This is one that I'm kind of glad is off the jury. I remember her from jury voir dire, and I thought that that might not be the best person to have on.
Well, good.
Juror number 10 is also gone. White male, works in vehicle logistics, I guess. He owns several guns and remembers tagging along with his dad at the gun range when he was about 10. His best friend's a police officer in the jail, and his girlfriend is a personal trainer. I don't know why the girlfriend thing came in.
Yeah, that is weird. They let a teacher on the jury. Why weren't they? Ugh.
Yeah, I know, right? So juror number 11 is still on. That is single white female, no children. She has a gun for personal protection, worked 16 years as a police officer for the university. Now she handles parking tickets. She's actually like kind of a judge for University of Michigan parking, which is interesting. So juror number 11 has a gun for personal safety and former officer. And so that'll be a mixed bag. We'll see. But she's still on the jury. Juror number 12 is a black male, single, no children, works as a manager in sales. His father had a gun and taught him how to do gun safety. Juror number 13, still on the jury, single white male who works as a powertrain engineer. He doesn't own any guns, but he went to the shooting range with his girlfriend over the last year for fun. Grew up in Nebraska. He says his engineering brain makes him a good juror, which I agree. As he will be able to carefully analyze evidence as it applies to the charges. Defense attorney Shannon Smith joked with him that we don't let engineers on jurors or on juries, but yeah, that's kind of a thing. Engineers and lawyers. Juror 14, white male parole officer who says he is fair to a fault and sees success stories. So he's a probation or a parole officer. I tend not to like these guys. They tend to be assholes, but I don't know. I don't remember this guy being questioned. He's married, has 2 older teenagers, has guns at home, keeps them in a storage unit. His kids are not interested in guns. 20-year in law enforcement. He's worked with government Medicaid and food stamps program. Okay. Juror number 15, single white female who works as an account manager. Juror 15 is stricken, by the way. Lives with her parents. Very young girl, lives with her parents, single white female. She also may have worked indirectly with Jennifer's former boss who testified. She works for a company that he also works for. So, but she's been stricken. Juror number 16 is a white married female with an infant son, works in building and university studies, works in billing for university studies, rather. She is originally from the UP. That's good. And used to be a hunter. She remembers getting days off from school when they were kids to go hunting, but she no longer hunts. Her sister was the target of a school shooting. Oh, that's right. I remember that one. Juror number 17.
Nice.
This is the one that I didn't like, and I thought the defense should have used a peremptory on. Single white female, married, 2 school-aged children, works as a veterinarian. When she thinks of this case, she feels rage. She also said, which isn't in the notes here, her husband is very anti-gun. And when she was leaving to go to jury selection on Tuesday morning, her husband turned to her as she grabbed her Yeti and said, "I'll be thinking of you." And she said, "Why? Why, dear? Why shall you be thinking of me?" And he turned to her and said, "Because they're selecting the Crumbley jury today." And she said, "Oh, dear, that's what I'm going to Oakland County Circuit Court for." It was this weird dramatic thing that she went, and I was like, "Oh my God, this woman needs to go." Yeah. So I was like, "Oh my God, she needs to go."
Could she
She's
be
off the
more
jury
white?
now.
Could she
What's
be
that?
more white?
Awesome.
I know, right? As her
It's-
husband, as her anti-gun husband handed her Yeti, he said, "I'll be thinking of you."
What's a Yeti?
Well,
It's a
it should
big
have
It's one
been
of
a
those
Stanley
cups
Cup.
Jamie always drinks out of. You had a few more
Oh,
questions
the giant thing.
while you went.
Flask.
Justin Spitz wants to know: do they allow female plus inmates in that prison?
Female plus.
I don't know. I don't know.
Are the parents able to communicate with Ethan? And Megan asked, "Is it easy to get emergency psych assistant in Michigan, wherever you live?"
If it's not the easiest to get emergency psychological evaluations. Essentially, you need a doctor or a psychiatrist to sign off on it. You need to go to the ER, spend hours there, really, if it's an emergency kind of thing, until you're seen by somebody. So you're basically sitting in the ER for an entire day before you can really get evaluated properly. And then it's still sort of up in the air. With regard to Ethan talking with his parents and vice versa, no, they have not had. First of all, the jails don't facilitate inmate to inmate communication, so that's the biggest hamper to that. So absolutely no communication whatsoever between inmate and inmate. James and Jennifer haven't spoken with each other in 2 years. They haven't spoken with their son since they were in that police station that you saw. So nope, no communication whatsoever.
David,
And then I
Shannon
remember
wants-
the second question.
It was the female plus, and are they able to? Yeah,
Oh.
you answered
The
those. And
female
Shannon-
plus, I don't know, honestly. I don't think so.
and
They
David,
need to be biological.
when
or
they were
something.
asking her about like going to the gun range with him and things, did they talk to her? Did they ask her about like if they talked to him about gun safety while they were doing that kind of thing?
That question was not brought up, at least not on cross.
wouldn't that be
It
the
wasn't brought up on
defense's job?
direct either.
Well, that's what I
Something seems
mean.
to
I
be
mean,
happening.
I wondered if the defense had brought that up with her, like, you were taking him to the thing to try and give him a hobby and help him out, and was that a subject that was breached? That might be
No,
a good
not really.
question if they had done it.
No, it would have been good maybe on direct. I don't remember that being on direct. That would have been a direct thing. I would imagine would have been better. And I don't remember that, honestly. Let me go back through my
Okay.
notes.
Did Shannon use her strikes quickly since those awful jurors came on?
Yeah, I wasn't there for the strikes. I was there for or the peremptory challenges is what they're called. And that's basically you can excuse somebody for any reason so long as it's not like race or gender or something. But I wasn't there for that. I was there for the judge's dismissals for cause. There were a lot of people that were dismissed for cause. And I thought juror number 17 was actually going to get dismissed for cause, but apparently she answered the questions correctly the next day, and she was never dismissed for cause or preemptively challenged. I'm going through my notes on Jennifer Crumbley. It's direct examination, and I don't see anything.
No, because Debbie V just said it was not asked. She just rewatched it last night.
Yeah, I was gonna say I was just going through my notes.
Thank
which is
you.
it's like 5 pages or 6 pages of notes, and I don't see it.
And Ariel
Because
wants
it
to
seems
know.
like gun safety was a big question in the jury questions when they were doing Vardoir. I can't say that word.
Vardir.
Yeah.
Vardire.
That's why I've heard it pronounced 9 million ways. So I'll just put them all together.
Yeah, there you go.
And
It wasn't
Ariel
really
wants.
broached.
Ariel wants to know, did you say the jury originally from the UP had a son that was a target of a shooting? Or was it sister, right?
Sister that was a target of a school shooter, but that never actually materialized. The shooting never materialized. Her sister was a target of a school shooter that was stopped. So that's what that is. Yeah, that's juror number 16. Remembers going hunting and getting days off school for hunting and from the UP, guns everywhere. But her sister was the target of a school shooter that was stopped. So that's the quote I have. But yeah. Okay, I want to I want to go back. This is going to be a little bit harder to hear, I have a feeling.
And just let's say our prayers for Nick, because the judge haven't shown up yet.
The never-ending story.
Yeah.
Nick's just sitting there waiting for the judge to show up.
It's just another day in the RICO trial.
God, that's ridiculous. How do you have a judge that doesn't show up? Well, you know what? We have. I was going to do a story about bad judges in Michigan, or just bad judges, period.
Nick is 10 subs for 4,000.
Oh, everyone, go sub to Nicholas Staroff Trial Watch. He's Swedish. We don't hold it against him. He's covering the Young Thug RICO trial. Well, I know you do because you're
Swedes do it better.
If someone could throw a link in to Nick's channel.
I'm 1,700 and I believe 52 subs from 4,000. So you can do the same to me.
Just go sub to Baker.
If Nick came on channel, I'd put a link in the description. But he's off doing his Young Thug RICO trial, where apparently the judge shows up hours
Whenever
late.
he feels like it.
But I have a judge in Michigan that got elected, never took the bench. Like immediately went on medical leave and was just like, I've got the gout, and just never showed up. And they're like, well, why don't you run for judge if you didn't want to show up? And then they forced her to show up. And then she would like turn off the recordings and stuff. And it was a disaster. And she ended up, so then the chief judge removed all of her cases from her and basically told her just to sit her ass at home. And then they filed a grievance against her. She was eventually removed. But it was a disaster. It took like 2 years to get her removed. She was elected, collected her salary, and never like showed up to work.
She was the one that the news and stuff was going after, right? Like to talk to her. I remember seeing those.
I played a clip of it during one of my Turtle Boy streams because Rob Wolchek from Fox 2 was like tracking her down, and she called the police on him because he's stalking me. And then the police were like, well, he's just standing in the street, ma'am. There's nothing we can do about it. So I was using it as an example of Turtle Boy, But
I found that guy hilarious. So,
well, because he was more aggressive with his going at her than Turtle Boy was with his stuff.
Right. Mm-hmm. Okay. I boosted this. This is going to be worse quality sound wise, but I want to re-listen to the jury instructions with regard to the second theory of the case. And I don't know if I have this queued up right. We might need to jump around a bit, but let me take a listen here.
The defendant was grossly negligent. You must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another, that if she knew there was a situation that required her to take ordinary care to avoid injuring someone. Let me read that again. First, the defendant knew of the danger to another, that if she knew there was a situation that required her to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. I think I've told you this before. I'm not sure we did the greatest job at this, but I previously ordered the parties to be precluded from using the shooter's name during the trial. When you go to the jury room, you'll be provided with written instructions of the final jury. You'll be provided with a written copy of the final jury.
Don't even get me started on
And you
Judge
should
Brennan.
first choose a foreperson. The foreperson.
She
I don't like
sanctioned
that.
me.
Discussions are
I don't
carried on
like
in a
that
businesslike
not using
way,
Ethan's
and that
name
everyone
thing.
has a fair
I don't
chance to be
either.
heard. During your
It made it
deliberations,
awkward a
switch off your
lot
cell
of
phones and
times.
other communications equipment until we recess. A verdict in a criminal case must be unanimous.
Hey,
In order to return a
Clumsy.
verdict, it's
You're very
necessary
welcome.
that each of you
I haven't seen you a
agrees
bit.
on that verdict. In the jury room,
Hey, babe.
you will discuss the case amongst yourselves.
Farrell's been
But ultimately,
kicked
each
out
of
of
you will have to make
Clumsy's
up your
chat.
own mind. Any verdict must represent
What are you
the
talking
individual
about?
fair judgment of each
Weren't you
juror.
timed out for like
It's your
days?
duty as jurors to talk to each other.
No, Maddie timed me out for 24 hours once because I told him to.
Trust your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors.
Yeah, all my ex-girlfriends broke up with me because I told them to. That's how it works, Farrell.
It wasn't even my name. It was one of my burners.
In the end, your vote must be your own. And your
All right, hang on.
it's not proper for you to talk. Therefore, until you return with the unanimous.
Yeah, I got it back up.
First, the
Sorry.
defendant knew of the danger to another, that is, she knew there was a situation that required. her
Maybe
to
you can
take
answer love.
Hannah
Beth,
St. Juliana
was juror
and Justin
17
Shilling
chosen as an
caused by
alternate?
the defendant.
Yes,
It was also
17 was
found
chosen as an
beyond a
alternate. I'm
reasonable
so
doubt
happy.
That her son's act of shooting someone was reasonably foreseeable.
Okay, her son's act of shooting someone was reasonably foreseeable. That's going to be the big one, I think. I think if the jury's paying attention, they're going to find that it was not foreseeable at all by anybody. And I think even the prosecution said that on at least 2 occasions during closing arguments, that it was not foreseeable.
In order to find the deaths of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Shilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Shilling. As previously noted, there may be more than one cause of death, and the defendant's acts or inactions need not be the sole cause of harm. In order to find that the death of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Shilling was.
Who is Ethan, and is he related to the defendant? Ethan is the defendant's son. I believe it's stipulated too. There's proof of the relationship. Ethan went and shot up for a school, killing 4 kids, and now his mom's on trial for involuntary manslaughter because she should have known and should have taken reasonable steps to prevent her son from doing this. So the question is, should she have known? Or did she know? I guess. Really, that's the biggest issue that I think the jury's not going to be able to get past if they're really thinking about this. And that one engineer
Biggest
attorney,
issue.
well, there's a lot of
Feelings.
issues, but just thinking about this case in particular, that one engineer juror that was like, I'm an engineer, was it juror 13, single white male, powertrain engineer. He doesn't own any guns, but he went to the shooting range and he says, as an engineer, makes him a good juror because he will carefully analyze the evidence that is as it applies to the charges. I think anyone who's looking at it that way is going to have a hard time coming back with a guilty verdict.
Ariel asked, is there a compliance specialist on the jury, or did she imagine that?
Compliance specialist. What? I don't see a compliance specialist.
And Jano wants to know, did they ever define ordinary care? And that's what I didn't like with this one, because in the Treehouse trial, he kept saying what it meant legally.
Yeah, there's no definition of ordinary care. The ordinary care required is up to the jury to determine. So that's why I don't like this whole idea of a charge like this, right? So the bright line rule has always been the intentional wrongful acts of another cannot be imposed on a third party, right? It's a nice bright line rule. We can all get our heads around it. But when you have did they exercise ordinary care? Should they have known? Did they do enough? Well, what does enough look like? Well, it looks like whatever the jury says after 2 years of sitting in jail and losing everything determines it to be. So that's the problem with this.
Is it the law to lock up firearms?
So Michigan passed a law last year that said that you have to lock up your firearms and make them, inoperable and things like that if you have certain age children in your home and things like that. But they passed that law in 2013. It was or 2023. It was supposed to go into effect this year. I don't think it's in effect yet. There's been a lot of lawsuits challenging it, that and the red flag laws, because they're unconstitutional, in not just my opinion, but the Supreme Court's opinion.
Right.
And so there's a lot of challenges to it. I don't think it's in effect, but either way, it was not in effect at the time of this. And so we only use the laws that were in effect at this time on November 30th, 2021. And at that time, there absolutely were no laws regarding safe storage or whatever bullshit name you want to add to them. Safe storage. Let's make guns prohibitive for self-defense laws. That's what we're doing.
Also find beyond a reasonable doubt that her son's act of shooting someone was reasonably foreseeable. Gross negligence means more than carelessness.
Hang on.
Charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove
this
each
is
of the
where I
following
wanna go.
elements beyond a reasonable doubt.
This is Christy
First, the
Danielle.
defendant had a legal duty.
What's that?
Is Christy Danielle? Was she in the courtroom? She says, "I don't think the jury seats are correct. I know that juror 15 was a male and not a young female."
Huh. Really?
Yeah,
That's
and juror
concerning.
number 11 was the youngest female.
Juror number 11 was the youngest female.
Yeah.
Uh-oh. Well, then we've got some bad info here.
Mm.
Well, let me ask you this. Juror number 17, the woman that sits in the front closest to the prosecutor's table, right up by the witness stand, the bigger woman, was she removed? Because that's the one I'm scared of.
That's for you, Christy Danielle.
Yeah. Let's see. All the jurors allowed to switch seats. They're not supposed to switch seats because we identify them by their number. The only thing with names is their jury questionnaire that the attorneys get. It'll say their name, and then it'll be a badge number, a jury badge number, which then we replace with the jury seat number once they've been impaneled. So we can identify, we know their name and we know their occupation and a bunch of other stuff that's not necessarily out there that we didn't question them about on the record. And then they're replaced with the jury seat number. So they're not supposed to change seats. I was given the list of juror 1, presumably juror 1 was sitting in the juror 1 seat. And so when they pull, say, juror 15 or jury 17 or something, that should be their seat number. That's so then we don't necessarily know the makeup of the jury. Sorry, Jen RN had a question I pulled up and then I forgot to read it.
Oh, there's Christy Danielle.
2 females and bottom seat, 1 bigger, 1. Yeah, okay. So what about them? Did the bigger one get gone or is she still part of the jury? 2 females on bottom seats, 1 bigger, 1 a bigger female. Yeah, those 2. Is the bigger female, is she still there? That's what I want to know. And by the way, for anyone who's just joining us, Christy is actually in the courtroom. She was in the courtroom on Friday as well.
This is the Christy that was in the court. Right. Okay, cool.
There's no verdict yet. The jury just got the charge and is going back to deliberate. So I was replaying the jury instructions because I wanted to get the second theory of the state's case correct in its wording, because it's a little convoluted for me. The first theory is simply that she was grossly negligent by not storing the firearm and ammunition. Gross negligence still requires a knowing of a need to do it.
But if there wasn't a law saying you had to.
There we go.
is number 17 not in courtroom today? What? No, she had to have been in there because the judge made specific reference to the fact that we had 17 jurors and we didn't lose a single alternate. So she must have been in there. She had to have been in there.
Is Christy out of the courtroom now? Can she call us?
She could if she had a link, but I haven't sent her a link.
Oh, send her a link.
I will. Hang on. I'm trying to super chat, lock up your firearms and eat your kids at birth. And eat your kids at birth. Okay, I was wondering if I was reading that right. That's a tip for parents, but it won't allow me to send it. That's funny. Yeah, super chat. You can't super chat. Eat your kids at birth. There's a lot of people that are saying like if this is like the case, right? You're going to be held personally responsible for the intentional wrongful acts of your children. People might have another reason really to stop having kids.
I mean,
she was saying she wasn't in court today, not the woman, not the juror.
Christy wasn't in court today. Okay. Yeah, but the seat orders are weird, so maybe you got them mixed up, Christy. Maybe you got the one in the back, it zigzags. So it goes the one in the far back to the left, like if you're facing the jury box is 1, 2, 3, 4, 5, 6, 7, 8. And then the one in front of 8 is 9, and then it goes back, and then it's 15, 17. So maybe your order of the box was not right. Maybe that's the issue. Okay. Would you have presented experts as to the availability of getting emergency psych? If possibly, I would have expected some sort of experts. What my theory was, or not what my theory, what I thought might have been a good idea would be to present the state's expert, call the state's expert, but you just filed a motion to exclude the state's expert, and the judge excluded the state's expert because the state's expert testimony was unreliable from a scientific standpoint. And then for you to call the state's expert might have been bad. But to call an expert with a similar view that you can't predict this kind of stuff would have been good. And also to call an expert to say that this emergency immediate care wouldn't have been available would have also probably been good to do. Yeah, there's a lot of witnesses that, coulda, shoulda, woulda called sort of thing. But when you're in the moment, maybe you have a thought like it's not necessarily needed. Are the verdict sheets very long? No, there's one sheet per charge. So there's 4 sheets total, and they all say the exact same thing. They just change the victims' names. Let's see. I'm not convinced the psych bed would have been open. Yeah, so that's the thing. Okay, so I won't get into how I know all of this. What you do is you go to the ER and you say, my child is in danger of self-harm or harming others, I believe. Then you sit in the ER for, say, 8, 9, 10, 12 hours until you're finally able to see a doctor. In the meantime, you see social workers and things like that, and they do follow-ups. And then you eventually see a doctor. The doctor talks to you about this and that, and they say, okay, well, what we're going to do is we're going to find you a bed. And then you sit there for another 10, 12 hours while they find you a bed. And but at any point you leave, or you can leave. I mean, there's nothing holding you there. It's not like they commit you right away. Like, oh, well, let's see if we can find you something. And then you hope that you find something. Sometimes you're sent home until a bed is found. They'll
give you a card and say, here's a
therapy. There's Oakland County Community. Yeah, Oakland County Community Mental Health. Here, call them in the morning. It's not like you could just walk in and leave your kids there. They can't commit you to the problem with the 48-hour hold, or it's actually 72-hour hold here in Michigan. The problem with that is that you need a doctor or a psychiatrist to sign off on it. Well, you have to actually get a doctor or a psychiatrist to evaluate you before they sign off on it. And then the petition can be made. So, again, if you're walking in a child, right, we're not talking about the police picking somebody up We're just talking about walking a child into a hospital. You're not going to get that without the evaluation.
And can we be real honest about the pictures that he drew? I did not find them all that disturbing.
He's a 15-year-old boy.
He didn't say he was. He didn't say on that math sheet, "I'm going to shoot up a school."
Yeah.
Right.
I
He
didn't
didn't
find
say
the pictures
this
all
is
that
Matt,
disturbing.
my classmate in math class, all
Mhm.
dead and blown up. Or there was nothing to indicate that he was going to shoot up a school. He had a picture of a gun. He had a bloody person, or as the defendant testified, it looked like a cape. It didn't even look like blood.
No.
Whatever. But let's assume it's blood. Okay. It's not an indication that he's going to shoot up the school.
Boys like to draw weapons.
I
And
used
if
to
they're
draw.
play-
I used to draw
Yeah.
pirate ships.
Yeah.
They
That's
had
cute.
My
cannon. then.
little
Yeah,
Well,
the cannons.
the thing is, like the other side that I've heard, people are like, "Oh my God, if my kid would have drew those pictures on a piece of paper, I would have dragged him to a psych ward immediately." And I'm thinking, are you kidding? Like, to me, I was like, that is wow, that's way over. I did not think it was to the point of he needs to get
Everyone
mental
who's
help
saying that,
immediately.
everyone who's saying that is looking at this in hindsight.
Yes.
Jennifer Crumbley is sitting in a holding cell in the basement of the courthouse. Her attorney can go down and meet with her, but her attorney is most likely also in the basement at the cafeteria. So she might go back and forth, back and forth. I would assume she's in the basement. Prosecutor, however, gets to sit out in the West Wing in her nice, comfortable office while we're waiting. But everyone's sticking around.
Mm-hmm.
Everyone's sticking around.
Everyone's in the courtroom, yeah, sticking around all day.
I didn't hear that correctly the first time. Okay.
But so, like, I wouldn't have saw anything in the school. Clearly, didn't find anything wrong with it.
True.
They were just like, "Oh, I feel like what they felt was we have to do our due diligence to a point." They didn't really go above and beyond because they didn't find it all that crazy.
Right. If the school thought that he should be on some kind of a psych thing like that, like we were just talking about, couldn't they have done it too?
Yep, they could have. They
But
could
why
have sent
didn't
him
they?
home.
Oh, I forgot, because parents know their children best in this situation only.
In this situation only. Otherwise, the school is always right.
Yeah.
If you have a kid in public schools, the school is always right. Unless it potentially leads to liability for them, and then the parents on the hook.
Yeah.
In reality, it's both. In reality, I will say that a school is only as good as the parent is at home. You need to cooperate on all of this stuff. And if you're not cooperating, then your kid's not going to make it through school or have any sort of productive. But that doesn't mean that the blame is more on one or the other, or to say that it's even this particular thing, right? Normally you're talking about this, you're talking about grades, behavioral issues, whatever, not paying attention to the teacher. Unless there's getting discipline at home, the kid's not going to really honor and respect the classroom and the teachers and get their grades done. That's true. But at the end of the day, you can't make the kid do something. Like, I deal with a lot of family law stuff, and you got a kid that's suffering in school and not doing good, not getting good grades, not doing his homework. Well, you can only make him do so much. You can make him go to the school. You can't make him do well on a test. You can make them sit down and flip through note cards or write things out, but you can't make them do good in school. They have to do it themselves, right? At the end of the day, the kid has to be willing and wanting to do good in school on their own, or else it's not going to happen. And it's the same thing with any of this stuff we're talking about.
It's the same thing with therapy. If they don't want to be there and get the help and they need it, then you're never going to make them.
Like Michael Scott in The Office that didn't want to do therapy. Is the state's reference to the school shooting video on the 29th an appealable issue, considering they never showed it? No, probably not. Because the question then is, the judge gave instructions to disregard that during the closing, that the jury's not to consider it. It's not actual evidence. That's going to be enough. And you can't really pierce the jury verdict veil, in order to determine if that was a big influence or not.
You got an Icelandic person in chat.
Do I?
Yeah,
Let's talk about Iceland.
That's Icelandic.
if you say so.
Sure.
Well, it is because it means that Sigurd's daughter. They still use the old form where you get your parents' name and then you put daughter or son after. KPM asks, is the school being sued?
The school was being sued, but those charges have been dismissed for government immunity purposes. I will say that James and Jennifer are also being sued. However, they don't get the government immunity protection. So that's lawsuit's still ongoing.
Can you tell us about that? That's interesting.
Just, negligent standard. A negligent standard for civil suit is much lower. It's essentially 50% plus one.
Yes.
And that's all they have to prove. So the standard is much lower as opposed to this gross negligence, which has to be proved beyond a reasonable doubt, which is like the highest burden that we have.
So that would be the parents that are suing.
That would be the parents. No, the parents.
Parents had the duty to protect all those kids, but not the school.
Yep.
Yes,
well,
sorry, I was just asking.
The school can have a duty. The school can have a duty. They can establish a duty. I believe that there is a legal duty from a civil standard for the school. However, the government has said, thou shalt not sue me unless I give you authorization, and they haven't given authorization. So
are all sets of 4 parents suing the Crumbleys?
I believe so, yes.
Right. And assuming that Jennifer at least is found guilty, that would be a slam dunk, I would suppose, for the civil case.
Probably. Oh, yeah, definitely.
Yes.
Yeah, because
but I mean, there's different theories.
Easier.
So it's a different jury makeup. The jury could find on the civil case that they were not. We could have like a reverse OJ situation going on here, where she's found criminally responsible but not civilly.
Yes, you say the burden's much lower.
The burden's much lower, but it's also different. I mean, you could get all kinds of. You could get 12 of me's on the civil case jury, right? And I'm going to say no.
No,
so,
David, you're a unicorn. There's only one Dave.
There is only me. If Jennifer's parents were on the defense witness list, but not the prosecutors, would they have been sequestered? Yes, there was a mutual sequestration order so that any witness on any list was going to be sequestered from the courtroom. So her parents were not allowed there. And that's why the Megan Emirowitz thing is such an issue, because I believe the state had no intention of calling her. I don't know why they would have called her. But she was really the only friend that Jennifer had in the courtroom, the only moral support, and the state made her remove herself from the courtroom.
That's dirty.
So the state were going to call her.
The state said they were going to call Megan Emirowitz, yeah.
I wonder
They
what
put her on the list. They didn't want her in the courtroom.
They didn't want the emotional support. Vicky has a great question. If he went for therapy, the parents would still know what he had said if he had spoken to the therapist about demon guns, etc., and could easily lie to the therapist how he's feeling and still gonna do it. So again,
that's the exact issue, right? Even if he had gone to therapy, he still could have shut up the school. And was therapy enough? Should it have been 2 therapists? Should there had been family counseling as well as the personal therapy? Should there have been medication included with that? What's the standard of reasonable care that we're judging these parents by? Well, we'll just let the jury sort it out. And meanwhile, she spent 26 months in jail.
I have a question. Like your all's opinion. So he obviously lied to the school. Because when they confronted him about the picture, he's like, "Oh no, it's just video games, and it's just this." And
well, we don't know that he lied. He could have been truthful about that because all of his real thoughts were in his journal.
But when the counselor asked him, what was going on, he didn't come out. Here's my thing: if he really needed help and he was screaming for help, why would he lie about needing help when it's brought to their attention?
When it was essentially offered when they had that meeting before he did it.
Yeah, he could have said, "You know what? I need to talk to somebody. My parents won't help me. I need to talk to somebody." He could have told him right then and there, but he didn't. How is that Jennifer's fault?
I don't know. Okay, so maybe the state did put her parents on the witness list because they did play the father's phone calls with Jennifer. So maybe they put the parents on the witness list as like rebuttals and things like that. And the state was going to call them and they didn't. Yeah, just because you put somebody on a witness list doesn't mean you have to call them. But as long as it's, there's no way to challenge Megan or the parents, being on the witness list. They could have had legitimate reasons for putting them on the witness list, and then thought at the last moment, we don't need a rebuttal. We're not going to do anything. They're completely fine with that. Totally Pip with the $10 super chat. Thank you, David, for all your hard work you put into providing this great, informative live stream on the Crumbley trial. I'm hoping for a not guilty verdict. Jennifer should never have been charged. Well, I appreciate the $10 super chat very much, and you're very welcome. And I agree. They shouldn't have been charged in the first place. What was interesting is I had been streaming this case since the preliminary exam, and the preliminary exam was weak. I thought the preliminary exam did not have enough evidence to find these parents guilty. The judge thought it was enough to bind them over on a felony. And I thought, okay, I can get behind that, assuming there was going to be more information provided at trial that would lead to their potential guilt. Like if I'm the judge, right? Yeah, it's enough, assuming the state's going to have more information, more evidence to present. And then at trial, it was actually less evidence than was at the preliminary examination. So I don't think they should have been charged. I think this should have been a directed verdict. I did not see a directed verdict motion anywhere filed. I didn't hear one argued. Maybe
what did they have at the preliminary that they didn't have in the trial?
They had all of Ethan's journal.
Okay.
They had more text messages between Ethan and his friend. Like a couple more, not a lot more. And
right.
They had the bird head thing was mentioned, although there was like no video.
Oh yeah, I remember that.
But the biggest thing is they had less of the journal and they didn't have the bird head thing.
Right.
So I was like,
yeah, that was so gross.
Yeah. Well, they showed the video and stuff and talked about it a lot more during the Miller hearing, but they did mention it during the preliminary exam. The biggest thing is the journal. Like all of the journal came in during the preliminary exam. And even more of it came in during the Miller hearing, as would be appropriate there. But they had a lot less and no additional information that James and Jennifer knew. The new information that was brought at trial that wasn't in the preliminary examination was James and Jennifer's police interrogation videos, the in-car videos. That was not at the preliminary exam. So that's why when they said they had those, I was like, ooh, let me listen, because maybe this is something that's really going to incriminate her. And I would be fine to change my mind on this if she truly knew that something was up. And if they made a statement about, where the gun was, left out on the counter or something, I don't know, whatever. I was open to the idea, but there was no new information in those videos that connected me to, or that worked for me to connect their knowledge of what Ethan was going to do. Whether they talked about his journal, because at the time of the shooting, nobody knew. James and Jennifer didn't know about the journal, right? They didn't know about it until after the fact. But if they had mentioned the journal during the police interview before, they should have known about it from the police, things like that. But I didn't see anything like that.
Are you ready for some quick fires?
Yep.
I have K pictures that you can't get the records. How is the ordinary care instruction constitutional?
So the ordinary care is, what do you mean how it's constitutional? They have to prove
I don't
beyond
know.
a reasonable doubt that they didn't.
I'm just reading.
They have to prove beyond a reasonable doubt that she did not take she did not take ordinary care or ordinary steps that a reasonable, prudent person would take with the knowledge that she had. So first you have to assume that she had knowledge that he intended to do this. Let's start with that. Then what would a reasonable, prudent person do with that knowledge? And that's a question for the jury. So assuming you have knowledge that your son intends to shoot up the school, right? We're going to start with that basis. You know this. What would a reasonable, prudent parent do in that situation? It's a question for the jury. And if the jury finds that beyond a reasonable doubt that they did not take the reasonable prudent course of action, then they can find her guilty. But that assumes the knowledge, first of all. And the reasonable prudent person is a legal construct. It's a fictional individual that would act in an objective standard. It's a weird sort of thing, but it's up to the jury to decide what a reasonable prudent person would do. So therefore it's up to the jury to decide if ordinary care was met.
Then we had what the people involved, your gut feeling.
I know. I don't know. I hate predicting juries. My gut feeling is a hung jury. That's my gut feeling.
I feel like that too.
Yeah.
My gut feeling is a hung jury.
Would you have had an expert on to tell how hard it is to get a time with a doctor or an expert?
Yep, absolutely. I would have. There's a lot of things I would have done differently.
And one person said, why didn't Shannon call Megan? Because she didn't need her. She wouldn't have brought anything to the table. People online is saying prosecution should have objected to Shannon making the closing personal. What do you think?
I'm sorry, say that again.
People online says that the prosecution should have objected to Shannon making the closing so personal. But can you do that? It's closing. It's not evidence.
Yeah. So there's a thing about using personal reference for closing arguments, which I don't like. I think when you're doing your closing arguments, you should be able to make your arguments and use analogies and use things like that. But the courts generally frown upon you using personal references in your closing arguments. That could have been objected to. It wasn't. The judge could have made the ruling that she can't talk about herself and try to make that connection. There's a way to get around it by saying, imagine a scenario where blah, 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 and you try to still put the jury in the defendant's shoes, which I'm fine with. It's the personal examples, which a lot of people have issues with.
Yeah, with her 5 kids and an oopsie baby and all of that stuff.
Yeah.
Then one commented that the affair was new for trial. They didn't have that before.
The affair was new before trial. There were rumors
in
of
trial.
it. Yeah, no, there was testimony regarding it in the preliminary examination because the water cooler coworker had testified during the preliminary examination that Jennifer would sneak off to go meet with a guy at lunch. So that was testified to in the preliminary examination. That was actually originally precluded from the trial. So that wasn't going to be talked about until the defense opened the door wide open.
Did they call the art warehouse guy? No. Yeah, he was there, the art warehouse guy, wasn't he?
No, the guy who called 911, but not the guy that left him, that gave him access to the thing.
And the last one I have, same judge for dad?
Same judge for dad. Same judge for dad, same prosecutor, different defense attorney, and different jury.
I go back to
pull the jury over. You did a good job. We'll keep you.
Yeah.
Excited? You got to jump?
Yes. So it's actually 2 a.m. for me here. Yes, 2 a.m. So I have to get up in the morning.
She claims.
It is. So if this is still going in my morning, I might see you again then.
Okay.
Well, we will see.
We're gonna probably shut this stream down and direct you guys all over to the Verdict Watch stream, which I have set up, and then go live there in a few. No, it's a Verdict Watch stream. We're going to go live. It's just titled differently. This is jury instructions, and then there's Verdict Watch.
Yes.
Yeah, see, we're going to carry on. But everyone, go check out Excited Utterance before we get distracted by more questions.
Absolutely. If you didn't see the stream I did with David yesterday, 3 p.m., go check it out. I'll put a link in chat, actually, because
talked about all the gossip and rumors online about this case.
We talked about the fact that Shannon's become a little bit of a meme, actually. There's some stuff going around online. But yeah, it was very interesting, wasn't it, to see outside of the comments that we generally see within our little world. So thank you for having me. I really appreciate it. And bye, everyone on panel and in chat. It's been lovely hanging out with you for a few hours. I do hope that it turns out to be the verdict that we all hope is just. little
right.
fingers shots. But let's see. Yeah, if it's still going later on, I'll see you when I wake up.
All right, sounds good. Bye.
Okay, bye-bye. See you.
Okay, so I think the chat's unanimous that we're just going to keep this going, right? There's no
Yeah.
need to jump to another stream. We'll just keep talking.
Yeah,
I'm going to
that's
retitle
fine.
this.
Just go into edit and change the headline like the
Yeah,
pros
that's
do.
what I'm going to do. I'm gonna well, first I'm
Pros.
gonna kill the verdict watch. I'm gonna delete that, and then I'm just gonna change this title to we're now doing verdict watch. Oh yeah, here we go. Yeah, and that was actually a really good stream. We went through a lot of the social media having to do with this case, and it was interesting to see how people were responding, both good and bad, but mainly focusing on the defense counsel and not so much the parties themselves. It was really weird. Okay, I gotta edit. Day 8, jury instructions, verdict watch. Verdict watch. All right, save that. I'm going to change. I'll get this right. Farrell, entertain everyone.
Wait a minute. Her talking about her son.
Mixing.
All right, now we're going.
Who was doing that? Who was talking about their son sexting?
Shannon did that in the closing. She said, "Would I be liable if my son at some point gets a girlfriend and she sends him raunchy pictures because she might be underage, and I pay for the phone bill? Then I am actually on the hook for
Right.
sending the child corn."
Right.
So that's why when Shannon went into that, I didn't like the first 20-30 minutes of her opening. I thought she went way overboard with all of her. My oopsie baby, my son might send child corn. I like my babies, but sometimes I hate them.
Wrong analogies.
I did not find any of it like appalling at all. I thought it was
So
good.
there's so many people that have mixed emotions about that. I think that was a logical connection, right? So if you have a 14-year-old that's taking pictures of his junk and texting it to another 14-year-old, should you be charged criminally for possession of child porn? Yes or no, right? But under this theory, you could be.
Well, I think the oopsie baby stuff was a big deal too because they made such a big deal about Jennifer saying it to the horse girl.
Yeah.
And other people.
Yeah.
So bringing
I
it
think
up.
I think the child using a vehicle that you bought for them that's in your name because it's in your name because it's really your car, and even intentionally running somebody over.
Yeah,
or going out and getting tanked and somebody getting not alive. Like,
I agree.
Because it's not an accident. Like an accident would be different if they got in an accident just without doing something illegal to.
Right. And you also have to make the distinction between civil and criminal, right? We're talking about criminal
because if it's just an
culpability
accident, it would be a civil thing. But if they just mowed somebody over.
And the whole idea originally with differentiating between civil and criminal was that criminal was like the intentional bad acts that you did, and civil was to handle the accidental bad things that you did. And now they want to criminally charge you with all these accidents, which ideally is not the appropriate remedy. Everyone makes mistakes, and mistakes should be handled civilly, not criminally. You're still punished, but to be locked away for an accident is ridiculous. But we've gone way beyond that. There's all kinds of gross negligent criminal statutes out there now. So for me, it's always still been a bright line rule that an intentional wrongful act of a third party is an intervening cause between your negligence and someone else's death, right? So what I've seen, he was in the halls alone. The school failed. The school absolutely did fail, Pam. But that's not the question on the table today. The question on the table today is, did Jennifer Crumbley fail? Was she grossly negligent in causing these 4 people's deaths?
Well, I think MG made a really good statement a lot earlier. We missed it because we were talking about other stuff, but about how can you be liable of what your child does if they're not in your presence? And if I'm wrong on that, MG, like how you said that, say it
Yeah,
again.
I
But
mean, they're at
I was
school.
thinking the same thing. I'm like, okay,
They're not
well,
in
they're at
control.
school. You're not paying attention to what they're doing. How are you liable of what choices they make while they're in school all day?
Well, bye, Franz. We're going to listen to the instructions again because I'm a little confused as to the second theory of the case. Let's pull
I
this
don't
up.
know that I think the
Okay,
school
sorry.
is liable for it either, though. I feel like they should be because they're trying to hold the parents, but
I don't
they
think
didn't
this.
have all the information. The school didn't have all the information. Only Ethan had all the information. He's the
Exactly.
one that did it. Like, I don't know that I would say that the school.
But Kick actually has a question along the same lines. May not be a fair question, but without the benefit of hindsight, and the school told you what they told the parents, what would your gut say you would do?
I don't know
If
that
the
I would
school,
have done anything different than what they did.
no, because what did the school actually tell them? That he drew something weird and he was a weird kid.
And you know, we're concerned about self-harm. I would have been thinking the same thing. Well, if we're concerned about self-harm and he can't be alone, he's not alone in school, right? And we'll get him counseling. Absolutely. We'll set up an appointment and get him in counseling. I would have done the same thing.
They do, Lefty.
And even in my socialist paradise, where we of course have the best healthcare in the world because it's free, it would have taken us weeks, if not months, to get that kid in front of a psych shrink. So what could I have done? I could have had a talk with them, say, please, dear child of mine, don't do anything bad to yourself, because that's what the school said. They never said, oh, you might keep him home for a day because he's going to pew the entire school tomorrow.
Yeah.
I don't believe for a minute that the school was like, you need to take him home. And the parents were like, oh no, I got a meeting. And like, they're trying to act like they were like, no, we're not taking him. And I don't believe that.
I think that was the school covering their ass.
It was.
And what MG said was the most likely basis for how the law was intended is to be applied was the parents who are actually in the presence of their kids.
Yeah, because you can exercise physical control over your child, and you can physically prevent them from doing something. And if you don't, then you could be culpable. I get that. Yeah, absolutely. But when they're not in your presence, how can you exercise that control? Because you can't physically restrain a kid when he's at school and you're at work, right? So, all right, let me play this and try to listen to this again. I want to try to clear up the second theory as the judge was instructing it.
To Justin Schilling. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent their minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control.
Okay, so the second one was the ability. Hang on, let me back that up. So the first one is knows or has reasons to know that they have the ability to control their minor child. That's what I think where MG is coming from.
A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control.
So knows of the necessity and the opportunity to exercise that control. Okay, so first we have to prove those two things.
Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused.
Wait, what was the second one? Hang on. This is going fast.
An opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty.
Second, that the defendant knew of the facts that gave rise to the duty. Defendant knew of the facts that gave rise to the duty. So essentially knew that he was a danger to the school.
Yes, Jody,
Okay.
we're rewatching it.
Yeah, we're rewatching this. We're just trying to get all the jury instructions down.
Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life.
So that the defendant failed to perform that duty and that the failure to perform was grossly negligent. Failed to perform and the failure was grossly negligent. Okay.
Fourth, the death of Justin Schilling was directly caused by defendant's failure to perform this duty. That is, that Justin Schilling died as a result of defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so.
Okay, so the way I have this written out now is that so theory one is that the defendant caused the death of the four kids by storing the firearm and its ammunition in a way that allowed Ethan to have access to it, thereby acting grossly negligent. Or theory two, that the defendant committed involuntary manslaughter by failing to perform a legal duty. The legal duty here is to exercise reasonable control of Ethan to prevent Ethan from intentionally harming others or engaging in conduct in a way which posed a danger to others. To meet this standard, the state must prove beyond a reasonable doubt that the defendant knew or had reason to know of the ability to control the minor child. So you knew that you had an ability to control the minor child. You knew of the necessity and you had the opportunity to exercise that control, that the defense knew of the facts that gave rise to this duty, that the defendant failed to perform that duty, and that failure was grossly negligent, and that death was the result of the defendant's failure to perform that duty. Okay, we follow that? That's what I got. Does anyone hear anything different? I don't have it in front of me. That's why I wanted to listen to it again.
Yeah, I think you did a pretty good reading with your
I was
abilities.
trying to write it out in real time, and then every time I kept getting, she's just reading it so fast. And the failure.
Yeah, I don't like that when judges do that, when they speed read the jury instructions. I know you've done it 1,000 times, but the jury is hearing it for the first time. That's what I really liked in the Treehouse case. He took his time because the jury doesn't know any of what you just said.
Well,
how
and
do
that's
you
why they'll get
prove that you know you could control the kid?
They'll get it in writing.
Yeah, but again, if I told you, Dave, did you have the ability or know you could control your kid? What does that mean? That you could tie him to the radiator or say, don't do it?
Well, and then if they did tie him to the radiator, they'd be charged with child abuse.
Exactly.
Thank you very much for the $1.99 super sticker. I can't see what it is because I'm not looking at. I should pop out my chat, really.
It's just a blank screen. I think it's a super chat that just didn't.
No, it's a heart. It's a super sticker with a heart. It's a super sticker with a heart. Thank you very much.
They need to make it so they work in here.
I know, right?
I can't see it. I can't see it on the live.
There's a little heart all the way to the right in the chat. Oh, hang on one second, guys. Talk amongst yourselves.
Yeah, let's talk amongst ourselves.
Shall we talk about our cycles again, Jamie?
Nope. We shouldn't. I didn't take my kids out that much. I have 4 kids. She has so many Facebook pictures of activities they did, proven with timestamp. That's positive. Yeah, and again, they just go and say, "Oh, you like your horses more." I have friends who have horses, and yeah, they spend sometimes with them, but if they didn't do it, they would be neglectful parents. And how many 15-year-old boys wants to hang out with their mom? I thought it was amazing that she took him to the gun range and had some mom-son time. I
Solomon's right. If she would have just hugged him when they went to that meeting, everything would have been hunky dory.
yeah. Yeah.
Yeah.
Yeah, and if she had spent one less day with her horsey.
Or her
Mhm.
boyfriend.
Well, not her boyfriend.
Well,
I don't
she
believe
wasn't
for
taking
one
care of her
second.
son while she was sneaking off with her boyfriend during work hours.
Yeah. Well, I
Yeah,
don't believe
and
for one second that this was going to be prevented, to be honest with you.
no, of course not, because
Ooh, I got another heart.
Jamie.
he had psychological problems, and you don't fix that with a hug. You fix that with
Well,
therapy.
no evidence of that.
And
So,
Jody has it right. She had also a kid, but at some point he needs to have some freedom. Yeah, he's a peacock. You need to let him fly. So we can do whatever, and we can. I was the third kid of all boys. Believe you me, the stuff I did with my parents not knowing in a way too young age, because I had two older brothers and they had done a lot of stuff, and I wanted to prove I was worse than them in every way. I've been in more fights, drunk more beer, and been turned down by more ladies than they ever had. But it's what you do as a kid, and you can't hold my parents accountable for what I did when they're not around.
Exactly. The jury instructions are confusing. Yes, jury instructions are often confusing because they're written by lawyers and mainly prosecutors. Did the state prove that the parents had reason to believe that their kid would unalive somebody? I believe the state's own statements make it clear that the parents had no knowledge. Nobody knew. And even in the closing argument, they said nobody saw this coming, which is part of the
Kitty.
problem. For the state to even say nobody saw this coming undermines their own argument. And I don't know what their thought
Right.
was with that.
mhm.
Cindy Lou Woot with a 9-month member chat. Thank you very much for being a member for 9 months. I still believe the counselor should have made the connection with looking up bullets and searching the book bag. He even said BB was heavy. BB was
Book bag
heavy.
was heavy.
Oh, book bag. Yeah. He did. He said it was unusually heavy, but didn't think anything of it. Yeah. I mean, everyone dropped the ball here, but I still say that nobody's criminally responsible.
Right.
Civilly, sure.
But
why
again,
not?
They dropped the ball because you couldn't have seen it.
nope.
It's all the
Farrell,
only reason you
Farrell,
think you could is because of the hindsight.
Farrell, you have more kids than are on most NFL teams. Do you know whatever they have in their search history and whatever they find fascinating? As a kid, I loved guns, and my mom is very anti-gun. We can't have them in Denmark, but I bought all when I started making money. I bought all the cap guns you could have, and
I
she threw
watched
them
their
out.
search history, but I also was a teenager with the internet at one time, and I know that there are ways around that.
Yeah, there's incognito mode, and but still, I love guns. My mom hated guns. My dad took me shooting. What? Which of those parents were right? If I had done anything bad, it's again it's the pre-crime thing mindset you have to have from Minority Report. You have to guess that your kid is going to do something bad, but how could you
Right.
do it?
And
Because he did.
everybody in the situation thought he was a risk to himself.
Yep.
Yeah.
That was the big thing. They didn't think anything else other than that. At the most, it was that.
And that's the problem I have with this case is, and I think it's more and more becoming that way in every country that pre-crime will be reasonable
Mhm.
for the state to infer that you should have known. But how?
A risk to
That's what.
himself is still risk to him, yes, or a risk of harm, but that wasn't the result of his actions, right? He didn't self-delete him, and still, this is again the issue that we have here, right? So let's assume the risk to himself was credible, and let's assume he unalived himself. What is the ordinary care? Well, let's let the jury decide, as opposed to having some sort of bright line rule. What is the legal standard here to be applied going forward? It's whatever the jury decides if the state happens to charge somebody. That's a problem. And I'm not the only one that says it. There's that's the one thing that I did see on News Nation. That's one of the commentators was like, where's the legal standard that we're going to apply to parents going forward? There is none. And that's a big problem.
Zero. I don't send my kids to the government daycare system.
You homeschool?
Mm-hmm.
Now I'm more concerned.
Well,
Linda.
I wouldn't say that, because I think the expert went to public school. So I would homeschool as well.
I had a meeting at my son's school about nothing in particular, like nothing special. They're like, well, while we have you here, can we check your bag? I think that was a result of this.
It was because you spend all that time with your horse, huh?
Definitely. A lot of homeschooling families, huh? Christine Hall is a homeschooler. I don't like the I didn't want to put forth the effort in homeschooling. Well, my other thing too is the socialization. I think there's a lot to be said for the socialization and learning to get along with people that you don't like. Like, there's not very much that I use in my daily life from high school, except the socialization part of it.
Sitting in a room, you're there to learn. You're not there to socialize. That's what they tell you when you're in school. You're sitting in a room with the same kids for however many years.
Yeah.
We go out and do all kinds of stuff and meet all kinds of different people all the time.
Do you? You haven't been to Michigan to meet me.
Would you like me to load my children up and come to your house, David? I know where it's at.
Absolutely not. Yeah, I know. I'm sure you do. Debbie W with a $5 super chat. When getting my kids into therapy, we had a 6-week wait for the initial appointment. We're not in Michigan, but still US. Yeah, I mean, again, it's not something, even if it's an emergency sort of situation, you essentially have to be in police custody, and then the police can walk you in and have you under police custody in a hospital. Maybe you get an assessment within a day, within 24 hours, but you're still under police custody that whole time. And then they file the proper paperwork. So
I have a friend who works with people at a home where you can stay, assisted living or something, if you have mental problems, stuff like that. They can't even get them admitted, even though they are professionals. That says these people are so bad right now mentally that they are a danger to themselves. They can't get them admitted because we don't have room for it. And again, I live in a socialist paradise where everything is free, but you just can't go and get help. And if you go there, one time she put a lady out there. She went out there at 8 a.m, and they said, well, she's too drunk, she can't be admitted. So they took her back, sobered her out, went back at 4 o'clock. They called them at 2 a.m. in the morning, said, she want to go home, come pick her up again. She then lit her apartment on fire. Well, it didn't really take, but still, she tried to burn her apartment down.
As one does.
Yeah, she was there in less than 8 hours.
I got Wendy. He sent me an email since she can't super chat for some reason, but she was trying to say that she, I'm assuming Jennifer, handed James the paperwork when they came out of the school. She said that James was going to call around when he was done door dashing. Yeah. So, I mean, I don't know if that's throwing James under the bus, but at the very least, they were concerned and they were actively, working on stuff. They were taking the school's lead. Let's assume Jennifer took the paperwork and said, I'm going to start calling around after school or when I get back to the office. Still wouldn't have prevented anything because we're talking an hour and a half later. Oh, let's see. There was another super chat I missed. How much does somebody between 15 and 17 hang out with their parents? Not very much, at least my anecdotal evidence, although I wish it was more. They don't want anything to do with me.
I did my apprenticeship, so I went into the bakery at 4:30 in the morning, went home, slept till noon, hung out with my friends when they were finished with their high school. Went home, went to bed at around 9, so I was ready for to go in the bakery the next day. I saw my parents. Well, we had when I played in a band, so we went out 2 weeks every summer and played music in France and Germany and stuff like that. They were chaperones on those trips, so they could see me and my sister. Well, else I'd never seen my parents from I was 14 till, well, maybe in my 30s.
Well, it's the other thing too. Like, we left the house and went to school, and then after school, even when I didn't have a driver's license, but especially when I had a driver's license, we wouldn't come home until dinner time, and or we'd be out riding our bikes around and stuff. We were never at home, or if we were at home, we had a bunch of friends over and we'd run around outside. It's not like we were inside with my mom supervising us. Just so you guys know, I'm still watching the court feed, and right now I've only seen a few heads bob by, but nothing, no volumes come up or anything, so I don't think anything's going on.
Yeah, I agree. I mean, I was never home if I didn't have to be.
Valhalla awaits. I'm surprised he hasn't snuck in the back door like Nick did the other day. There's so many ways today to fulfill the social aspects that school fulfilled 20 years ago. That's true, I guess. But unless your parents are arranging situations where you are going to spend some time with someone you don't like, then it's not the same. What I mean by socialization is learning to get along with assholes. There's always the asshole in the school. There's always people you don't like. There's always people you don't gel with, and you have to learn.
I didn't learn
how
that
to
till I
interact
met
with
you.
them. Right? See? So well, that's a product of Farrell being homeschooled.
No, I was not.
But that's my point of socialization. Everyone's got to deal with assholes, and I feel like there's too many kids these days that are like, well, I don't want to do that. I don't want to work 8 hours a day. I don't want to have to deal with this really annoying person. Well, sometimes you have to, and that's part of life, and it's good to learn that young.
Huh.
Yeah, you need to hang out with people that are not your friends. That's why I invited Farrell on.
And it's good to learn, and I think the big problem today is when you're out there and having to learn how to deal with other people. We model coddle people too much, so they don't learn how to fight for their positions, because no one can disagree about anything today. I think that's a big problem.
Yeah, no, that's everyone got the Farrell reference finally. I thought I saw the judge's head popping up. I got all excited. I don't want a verdict this quickly, but maybe an instruction or something.
Right, Lars? Does our society look socialized to you?
No.
No, I mean, can we all agree that there's something to be said for being forced to hang out with people that you don't want to? Because you have to do that in work, right? There's a lot of people that work with people that they don't like.
Yeah, my tolerance has gone
I
up.
still think there's way more opportunity to do that with people from all ages and walks of life and things like that, when you're not sitting in a building for 8 hours a day with the same people day in and day out.
Jamie has learned to adapt, and when there's people that she doesn't like, she just records them.
I liked him, by the way. Let's make that clear. But I didn't like his things he did.
I just didn't like anything he did. I liked him, though.
Brandon with the
I know how
199
that
super chat.
goes. I like David. I just don't like anything he does.
Yeah, anything he says. I was like, and let's be
I
clear.
record him.
Wait, who did that? Who has controls? Valhalla pop in and play the sneeze and then leave real quick.
Oh my god, I don't know.
How is that working? Oh, Baker's doing something.
Yeah, he is. Look at his face.
You forgot to read Brandon's super chat.
Oh, do I have to?
Yes,
Sometimes
Brandon.
you even give money to the annoyers. Yes. Thank you, Brandon. Are you just playing that? You have like he must have something that's going through his headphones or his microphone feed.
What are you talking about?
You're in heck. That's a good
What?
comment.
Yeah.
He disgusts me, but he's a nice guy. Well, listen here, when he do those things, especially the sneeze and other things, I would talk to him and be like, do you really think that that's something you want? Like, I would be like, are you okay? I'd try to counsel him. But that's how he wanted to live his life, so what can you do?
I haven't got an email back from the clerk. I emailed her and asked her if she would give me a heads up, and she didn't respond. Now I'm a little, oh my God.
It's blowing my eardrums out, like in real life, when I experienced it in real life.
MLS. Still bothering me. The young female. Was she the one with short blonde hair? Would come up with a major pounding headache. What? Are you talking about the jury member? I'm not sure what you're asking me here.
Yeah, she's trying to figure out where her numbers and your numbers are off.
My numbers are jury seats. I know that specifically because I know juror in seat 17, which was the closest one to the witness, but also to the prosecutor's table. I know that was juror number 17. The identification matches up. I also know that the juror in seat number 7, who was second row, one in from the right, he was the doctor. And so I know these numbers match up with what I with the seat or seat thing. So I think when the juror pulled the numbers, or when the judge pulled the numbers, the judge is pulling the seat numbers. And
Christy, David knows he's right. David is always right in David's mind.
I am. Why are we questioning this? Christine, with the 99-cent super sticker. Thank you very much. What did I get? What did I get?
Three trees.
3 trees.
The
Awesome.
worst thing for me to say, because those words are really hard to say in Danish. Three.
Thank you so much, Christine.
Yes.
It's very appreciated, isn't it?
How do you say 3 trees in Danish?
Tre træer. But
Tre
it's
træer.
the sounds. It's really hard to make in Danish.
So Danish doesn't have the th sound?
No, that
words?
I can say that because that's a hard, but three, that's a sound. It's the same with Nick. I can say chat because that's a hard sound, but he says chat.
He says shh, like a sh, shat.
Yeah, he can't do that sounds because Swedish people talk differently. They are wrong most of the time. So.
Well, yeah, we don't have a deliberation counter, do we?
It's roughly 2 hours now. 2 hours and I think 2 hours and 15 minutes. I think
something like that. That sounds right.
I make up stuff.
They've been deliberating for 2 hours and 15 minutes. It is only 11:33. The jury should be getting their lunch shortly. They're not going to take their lunch in the cafeteria. The judge has specifically just said, I don't want you in the cafeteria this time. Prior to that, they had free reign to leave and go down to the cafeteria and stuff. But now that they're deliberating, the judge doesn't want them in the cafeteria. So ideally, lunch will be delivered to the jury room, and they'll be sitting there eating lunch while still deliberating. And I'm just still watching the court feed.
I
and
agree,
see a head bob
Lars.
by every once in a while. RA has a timer. Yeah. Well, RA has a timer. I'm not having a timer specifically because RA has one. No, if I could go to LNC Word, they'll have a timer too, I believe.
No, they just write it in the just go over to recovery and just say,
just go to snipe
I
his.
have one on my table, and just steal from him. It's the internet. No one will ever find out if you lied.
So 103 minutes. 103 minutes. That's how long.
So that's
deliberations
1
are
hour
doing.
and 43 minutes. So I was right. 2 hours and 15 minutes.
That sounds about
I
right.
just make stuff up.
I believe your number's better than RA's.
Yeah, because I count in my head.
Exactly.
Baker is so talented.
Well, if I go to the feed, I can tell you that the jury was sent away. Look at it right here.
There's obviously.
Yeah, he's probably right.
if you all decide you're gonna leave and walk around or what, whatever you're gonna do, just.
All right, jury is being let out, and that is an hour and 45 minutes ago. Presumably, they have a chance to sit down first. So we'll say
Yeah, okay. And we
an
have
hour
your
and
exhibits.
an hour and 40
Please make
minutes ago.
sure.
So that is.
Ooh, I like
But
the
it-
last option, Brandon.
But again, it's because you have we have the metric system and you have the wrong system. Ours is a little bit longer, so our hours is a little bit longer than yours as well. It's just like inches.
Well,
We have
time is a little bit longer.
We have our inches is a little bit longer because I found out the average size of Americans is below 6 inches, and in Denmark it's above 6 inches. I'm coming to America, ladies. Just letting you know.
May, Tennessee, Dollywood. You guys be there.
Yeah, I'm going.
Dollywood in May.
I'm going on a date with Danielle. I already fixed that up. That's going to be great.
Aren't you guys sharing a room?
Well, no, that was if I want to stay with Valhalla, I had to sleep with her. It's a weird way to say stuff.
Yeah, that's kind of weird. You don't want to force it, right?
No,
Brandon,
well,
let's go with 49 super chat. What if they don't bring food? Uber Eats, Seamless, Pilgrim, and
pillage.
The other jury room. The judge has provided food, but I like the idea of the jury running wild, pillaging food. That sounds
Me
fun.
too.
I do like that idea.
Run over to the courthouse and steal their lunch.
Let's see. Any idea why 16 was on the jury in the first place with her personal best? Why 16? So 16 was a single white female who works as an account manager for retail properties, lives with her parents, and worked indirectly with Jennifer's former employer. She didn't know that until Jennifer's former employer took the stand. They rattle off like 100 different names, right? And you're just listening. You're like, nope. But none of the names ring a bell. But then when she saw him and his name, I think she realized, like, I work for a company that also works with this guy fairly closely. So I don't, and no one really had an objection to it. And she's an alternate anyway. So let's see. Are you going to March, Jamie's, for jury selection? Oh, James for jury selection. Yeah, I'll go there. Most likely, if I can make it work. Now I have a trial scheduled for February. I have a trial scheduled for March. I have a trial scheduled for April. So my my time is getting stacked up. I hate asking. I love questions that start with I hate asking. But this is where we live right now. Any thoughts on what her sentence would be if guilty, knowing the local trends in judge? I think I predicted I think she was served like 6 years. So the judge would maybe give her 8, 2 years time served. 8 is more than half of the maximum, which is 15. So that was my prediction. I think she'll serve like 6 years if she's convicted. I feel like that would be.
Oh, that's with the max.
Well, the max is 15 years.
You don't think the judge is going to give her the max?
No, because she didn't pull the trigger.
I think the judge will give her the max if she gets found guilty.
No. Let's see. If found not guilty, would she walk out of court? Well, she'll still have to go back to jail for processing. Because she spent 26 months there. Presumably she has a lot of stuff there. So she'll actually be transported back to the Oakland County Jail, which isn't that far. It's in the same complex. And then she'll get processed.
But she's essentially she could walk. She's not going back to prison.
Yeah.
She's free.
Yeah.
She just has to go get processed.
She's got to go get processed, get all of her personal stuff, and be let out. Literally across the street in a complex from the court. So let's see. Michigan state seal is so nice. Elk and moose. Motto is Pleasant Peninsula. Pleasant Peninsula. Look about you. MA seal is a native surrendering to the sword. To the sword of European invaders. That's interesting, given Massachusetts' history with the. Isn't the Pilgrims land there? That was Massachusetts, right? Plymouth Rock. That's Massachusetts, I believe. I can't remember, but that's interesting that they're surrendering. The Indians are surrendering to a European sword. The one thing I wanted to say about the seal. Let me see if I could bring one up. The seal of the great state of Michigan has something that might be interesting to this particular case. I'm not going to be able to bring it up very easily. Let me try again. Let me try this way. Michigan seal. Michigan seal. For some reason, I have a dog barking. There we go. All right. Let me pull this up. This is an easier way. See our beautiful Michigan seal? Look at that. There's a man with a gun on it. He's got his rifle.
Is it Bigfoot?
No, that's a frontiersman with his rifle.
Oh, what is your state logo? Si queris pensionalem am senem?
Yeah, I don't know what any of that means. If you want, like, if you want a Pleasant Peninsula or something like that is their motto. We are two peninsulas actually, but a Pleasant Peninsula, that's our motto, or something along those lines. Something like that. But yeah, but I thought it was fun. Our state seal has a man with a gun on it.
Wow. Shame on us.
Right there. How dare us, right?
Mm-hmm.
It's dangerous, you know. Scott with the $10 super chat. I already read this one. Thank you, Scott. But yeah, so in reference to your super chat, there it is. I do like our seal.
I like a little deer and our moose.
Do you fight the moose like the Canadians does?
With fisticuffs, of course.
I don't know why there's not bears on there, though. We have more bears. I've seen more bears.
I've seen more bears than elk, definitely.
Yeah.
The judge decides the sentencing, not the jury in Michigan. The jury does not consider sentencing when they're deliberating, and the judge will do the ultimate sentencing in Michigan. So we don't have a hearing or anything. What will happen is that there will be a sentencing date set. The judge will ask the state, the prosecutor, or the state prosecutor, the defense, and the probation department to issue sentencing memorandums, essentially. And then any victims that want to speak will be allowed to show up and speak. And then the judge will make the sentencing. It's not like a big trial or evidentiary hearing or anything like that. It's not like a little mini trial like some states have.
And it's
the judge
you seek a Pleasant Peninsula, look about you.
That's what it is. Yeah, I knew there was a peninsula mentioned somewhere.
Yeah, maybe because it says Si qualis peninsulam. That's not that hard to figure out what peninsula might be. Do they even have Tuborg in Michigan? No, he only drinks Carlsberg because he steals them from his wife. She drinks real beer. He drinks Michelob Light.
I do. If I'm drinking anything other than Michelob Ultra, it's because my wife bought it and it's what's in the house. If she is acquitted, what's that?
I'm gonna jump off and take Molly for a walk. She is making all kinds of noise. I'm coming back, y'all.
I'll be here all day.
Yeah, you better. Jamie, get on camera. See you later.
Take care, Baker. We'll see you in a few. If she was acquitted, will she ever be able to actually get anywhere financially? Probably not. It's going to be difficult. She can even discharge debt for wrongful death suit in Michigan. So, well, I read that in Michigan, she can discharge liability, even like civil judgments, if they're negligent. If they're intentional, then you usually aren't able to discharge that. But it doesn't mean she's not able to go into like a reorganization where she's not discharging it, but is making a payment plan. So she'll be able to deal with that. But the wrongful death suit isn't, it's not based on an intentional standard. It's based on a negligent standard. So ideally she'd be able to discharge it. But I'm not a bankruptcy attorney, so don't take my word on that.
What'd I miss?
I believe nothing, absolutely nothing. We're
Okay.
just we're
Screening
staring at the seal.
questions. Yeah.
I believe
Oh.
I heard somewhere that Jennifer's mom, it's not talking to her. Does anyone know if that is true? I don't. I have no idea if Jennifer's mom's not talking to her. Why wouldn't Jennifer's mom talk to her?
Yeah. I thought their parents were okay with her.
Not yet,
Okay.
Mo.
Oh yeah.
What's that?
What's Mo doing? Miss Mo.
Laundry.
Oh.
Story of your life.
Nobody should move to another country, just another state. Fair enough.
I mean, I love Michigan.
There's no better state than
think-
Michigan.
Everywhere is going to
Mhm.
have it's like David said, it's our local government. We need to be more diligent on who we're voting in to our local office.
Oh, exactly. 90% of the laws that affect you are local government. Your local prosecutor, county prosecutor, county judges, your
Mhm.
city officials, township officials, whatever you have going on. Those are the ones that affect you most of the time. It's not the president. But everyone skips past those people and votes for president and votes for Congress and whatever and thinks that's the important stuff. And it's not. With a $1.99 super sticker saying, wait for it. Thank you very much, Emily CBE.
So where
Um,
did Baker go?
He went to go walk
the
his
dog.
dog.
Oh, okay. I was gonna say he bullied you into a verdict watch and
Yep.
then he disappeared. Gotcha.
I know, I was thinking the same thing.
Mhm.
My original plan was to just shut this down and come live when we had a verdict because I don't have much more to say about this case other than maybe asking or answering your questions. So, can the judge recommend time served? Well, the judge can order time served. The judge can literally go there and say, how many days has she been incarcerated and say, that's what I sentenced her to, time served, out. Absolutely, the judge can do that. The judge did that in Megan Amirowitz case. Judge Valentine did that. It's like, I'm sentencing her to time served. I want her out today.
Yeah, it's possible.
Michigan. Okay, let's talk about this. Jamie, how many earthquakes do we have?
None.
Mudslides?
None.
Hurricanes?
None.
Do we have any like super dangerous large animals and or insects that want to murder us?
Yes. June
No.
bugs.
June bugs. Okay.
Yeah.
We have all the fresh water you can possibly want, use, drink, play in, swim in, pee in, whatever you want to do. We have all 4 seasons. So if you like the summer, we have beaches. If you like the winter, you can go skiing.
Mhm.
It's absolutely the best state. And we don't have all this natural disaster that's trying to kill you.
If you don't like your governor, you can go to trial.
Yeah, well, government's left to be decided. I'm talking about Michigan, not the politics of it.
Yeah, I agree. I say that all the time to people because they're like, what's so great about Michigan? I'm like, we don't have things trying to murder us all the time.
We have
June
weather
bugs.
anywhere from 90 degrees in the summer to what we have like -10 or so a couple of weeks ago.
Yeah.
We don't have a ton of snow in Southeast Michigan right now, but up north there's a ton of snow. You can go skiing. I know my brothers have been up there the last week or so skiing. And
Valhalla has a perk.
goats.
No,
Yeah.
Flint has all the water.
Flint has all the water. Yes, Flint has the water.
I don't have Flint water, so I'm good.
Mm-hmm. You live in Flint. How do you not have Flint water?
I have water for my city.
Michigan is the greatest state in this nation. There's no other place I'd rather be. I've been looking at other places that I might want to move to at some point.
There's
And-
no other place I'd rather be. I've been looking at other places.
No, I've looked. I've looked to see if there's like, so I was looking at Georgetown, South Carolina. Looked at Galveston, Texas. I looked at maybe upstate New York. I've looked at, along Lake Erie or something because I like the water. And I just, nothing has a feature that I'm losing something if I go anywhere. Like if I go south, I'm losing the winters. If I go to like Georgetown, South Carolina, I'm losing the lake access. If I go to upstate New York, I'm not really losing a ton of stuff except for, I don't know, upstate New York. Niagara is kind of gross and violent. I went to Niagara not last year, the year before, spring break with my son. And there were like several murders outside the hotel we were staying at, like 2 days in a row. I'm like, oh, this is a great place.
What a good place.
So, yeah, I just haven't found another place. I don't want to go to Chicago. That would be disastrous.
Yeah, and I've like visited around different places, and I find too that Michigan's kind of cheaper way of living also.
People in upstate New York are a little odd. They are. There was just like something off with the water or something. I don't know. It was just weird when I went up there. I don't want to do New England because I'm not a WASP. I don't feel like I could fit into that lifestyle. Massachusetts apparently is a no-go state anymore, like Wisconsin.
Oh, oof. Sounds
Move
fun.
to Milwaukee.
No.
So I didn't get to listen to closing arguments. How'd they go?
Closing. Oh, do we want to rewatch closing arguments? Should we do that?
I got the very little bit at the beginning and very little bit at the end.
I mean, it gives you something to talk, like now that it's not something you want to
Right.
just sit
Now
and
you can
do
pause it
these
and talk about things they say.
different things.
That would be a fantastic idea. Lefty
All
has a
right,
good idea for you.
I'm going to start with the defense's closing argument. I'm not even going. Well, I did that wrong. I'm not even going to go do the state's closing argument. Let's play the defense's closing argument because this seems to be the hot button topic.
Sure.
And since Farrell hasn't watched this, I want her take on this.
Yeah.
And let me put a banner up just so everyone knows what we're doing here. Replay defense's closing argument. All right, there we go.
I would love to see David in front of that judge.
I'm in front of that judge a lot.
No, Judge B.
Who?
Borowski.
Borowski.
Oh, is that from the
Edgecombe.
That's Edgecombe. Oh,
yeah.
I'd get
You hated
sanctioned.
him though.
I'd get sanctioned and thrown in jail.
Oh,
I don't tolerate judges like that.
David hated him.
Oh, you don't tolerate judges, sir? I think it would
No,
be
I
the
don't.
judges tolerating
I
you.
file grievances against judges that I think are wholly out of line and inappropriate. And I'm not afraid to call them out on it. And at the very least, you either get out of a case you don't want to deal with because you don't like the judge, or you get a new judge. But no, I hated that guy. Hated him. You guys were all like wanting me to watch it, like, oh, you're gonna love this judge, and I watched like the first few minutes of it, and I'm like, oh my god, no, I hate this judge. I can't stand it. All right, let's watch this. I'll be right back. I'm gonna hit play and then leave you at your own.
Okay.
Go.
All right, one thing I wanted to tell you, I've been learning about sequestration. They still bring
One of them goes.
when they go out. Someone bring that.
I thought he was leaving.
As the prosecutor to finish.
No,
What's
he's
that?
gotta
I'm gonna
tee it up.
I'm teeing it up. I didn't have it in the right spot.
You left and it was click, click, click.
Yes, thank you. As the prosecutor to finish, she said, "This is shocking, unthinkable. I believe there were other words used throughout trial. Unbelievable. Obviously, unbelievable, unthinkable, unfathomable. And the reason that's the case is because it was unforeseeable. No one expected this. No one could have expected this, including Mrs. Crumbley. Now, the first thing I want to do very quickly is talk to you about the burden of proof. In the state of Michigan, there are different burden of proofs depending on what kind of a case it is. When people sue for money and say, I've been injured or I was failed by the school even, there will be civil lawsuits and the burden of proof is a preponderance of evidence. That means it's about a 50-50 standard. And if you have 50% of the evidence, that's the burden of proof for civil. When the state thinks it's important to take away a person's children, the burden goes up, and the burden has to prove more evidence, and that specifically is clear and convincing evidence that it's correct for the state to be taking away a person's children. Now, the highest burden in this country is in a criminal case, and that is beyond a reasonable doubt. And the reason I'm telling you about the differences in the burdens is because in a criminal case, if you have just one reasonable doubt about the case, you must vote not guilty. And so this is my poster just showing beyond a reasonable doubt is guilty, but there's many, many other options. If you think it's likely, probable, possible, not likely, those are all not guilties. You have to be sure beyond a reasonable doubt. And later, as I go through my closing, I am going to tell you the reasonable doubts that the defense believes exist in this case for you to look at. The other thing I have to ask you to keep in mind is that in the jury instructions, and I think you've been told this throughout trial, the defense does not have to prove or do anything. Like Judge Matthews said, we could sit at the table and play chess the whole time, call no witnesses, cross-examine no witnesses, provide no evidence, because we have no burden to prove a thing. However, in this case, you obviously saw the defense present Mrs. Crumbley, who took the stand, so that she could give you some context beyond parts of the evidence that were confusing when the prosecutor was introducing in.
Farrell, what do you think so far?
I liked her nobody could see it coming thing at the beginning, and then I like that she has a chart for reasonable doubt.
You like the chart? I didn't see the chart. I had walked away for that too, and I was going to stay here for this one, but then I had to run. Jen RN had a question for me.
Somebody, it's in private chat. Is there a ER doctor on the jury?
There is a doctor. I liked him too. That was juror number 7. He is a doctor. He says he sees a lot of gun violence. I can't remember if he's an ER doctor. He's a surgeon, I believe. He sees, and he has multiple guns himself, though, and he's a very strong Second Amendment proponent. That's the doctor. Can't remember if he's an ER doctor or just a surgeon. So, if I watch a Dean Cummings case, I feel like I have. What is that case?
Familiar.
It sounds so familiar.
He was the self-defense case in New Mexico. The skier guy, the Olympic skier guy.
Olympic. I did watch it, but I don't think I streamed it. That was a good case.
Yeah, you watched it.
That was a good case, and the defense had nothing, or not the defense. The prosecution had nothing on that case. That case should have never been brought either. No. Everything said self-defense in that particular case, and they still brought those charges.
Yeah.
Jennifer from Facebook says the defense sucks. But what do you guys really think of this? We're seeing it with a second set of eyes, or like after a weekend, and we've had chances to reflect on this.
I loved her.
There are people commenting on her outfit. She talked too much about herself, too much about TikTok. It seemed a little rambly, but then she really got into it. I liked it in the moment. I was really getting behind it.
Bits.
Remember, their jury only sees it once, right? So at the end of the day, we only have the jury's only watching it once. They're not watching it over and over and over and picking out everything.
I remember like thinking to myself, like, yeah, like every time she would say something.
I know.
So
I got like super excited for this.
I was on it.
Actually, you know what we could do too? We can go back to the prosecutor's last word because this resonated with me, and I don't think the jury's going to remember the prosecutor's last word yelling at them.
Pieces. And the problem in this case is that we can.
I'm going to put it at 1.25.
Everything can be seen different in two ways. First of all, when you look back in hindsight with 20/20 vision, when you look back in hindsight, it is easy to say, this could have been different, that could have been different, this would have changed. And the other circumstance, the second one that makes a huge difference, is when you get full context around the evidence that is being used. And in this case, the prosecutor has cherry-picked little bits of evidence out of mountains of evidence to put in front of you with no context to explain what they're doing. And when you get cherry-picked bits of evidence, it's easy to reach wrong conclusions.
See, I like this.
Now, during jury selection, it felt like the prosecutor was asking you questions and giving more of a campaign speech than a jury selection proceeding. And I would suggest to you that at the end of the day, the only
That's
judge,
funny,
although
actually.
Ms. McDonald mentioned she's got
What's that?
She said she was giving a campaign speech.
Yeah. No, she was. She was. Oh my God. If you listen to her opening statement, she absolutely was giving a campaign speech. I had been a school teacher. I was a judge. Then I stepped down to run for prosecutor. And then, her whole opening statement was a campaign speech. What I thought was interesting too, which I didn't know until I went on Excited's stream yesterday, is that this defense counsel, Shannon Smith, was in a Facebook group and during this trial and would chat in that Facebook group saying, hey, what'd you guys think? What do you think of this? What'd you think of that? How did I come off? And things like that. That was interesting. I didn't know that until someone dug that up. But I just thought that was interesting. And so her whole thing of like, everyone's trashing me or whatever, she was definitely in on the social media campaign that would seem to be against her.
It's a good idea, though. Like, how
I
am
know,
doing, guys?
I've always thought they should come watch streams like this at the end of the day, even just a snippet of it, just to kind of gauge how real people are feeling about how they're doing.
Yeah.
Kurt, the uncivil slob, says this is the worst closing and the defense attorney should be making him a large sandwich. What? I don't think he said that. He did say it was a bad closing. He hated this closing.
Well,
I don't agree with him. I think this was a great closing. Maybe it didn't hit everything. Maybe it's not exactly how I would have said it, but it had the energy and the stick-to-itedness. I guess I don't know. It just had sort of the level of energy that I expect of myself when I would give a closing argument, especially in this kind of case.
oh my Lanta, with the pregnancy question.
Everyone wants to know if she's pregnant. She said she has an oopsie baby. Her last baby was an oopsie baby. I doubt she's pregnant now. She would have told us, people. She would have told us.
Oh, yeah, she probably would have. Look at this. This is an oopsie too.
Absolutely, 100%. I'll be right back. I got to jump off really quick.
Could you bring the same charges to parents of gang members? Like these parents either knew or should have known? Yes, absolutely.
Right.
Absolutely. Okay, let's keep going.
Okay.
Judge and was a judge several times during her jury selection. The only judge in this courtroom that matters is Judge Matthews. And the only other people whose judgment matters are the 12 of you who will collectively decide this case. The rest of us don't matter. My opinion doesn't matter. Ms. McDonald's doesn't matter. The opinions of everyone in this audience doesn't matter. The media and all of the people
I like
who
that.
think they know everything behind keyboards at home commenting about what they think the evidence in this case has shown. So during this case, It's obvious real life is messy and complicated. And
That's a fair
during this
statement.
trial, I will openly admit that I'm a lawyer who messes up. I get thrown off when I'm surprised by something. I feel like I get overwhelmed when information is coming at me quickly. I say I'm sorry a lot. Evidently, there's a TikTok channel of me saying I'm sorry through this whole trial. And
Apparently, that wasn't.
all I'm
That
saying
was
is that
recovery addict or something.
I
No
like
one's been able to
that.
I'm
find it.
human. I am a human being, and so is Mrs. Crumbley.
I'm with
And that's
Jamie.
what
I
this
like
case is
her.
about. She's not a perfect person or a perfect parent. I'm certainly not a perfect person or a perfect parent. And I'm certainly, beyond a reasonable doubt, bad with technology, which is why you're not going to see me touch that laptop. So during this trial, I have stood before you and shown you all my flaws, and I embrace them, and they are a part of what makes me human. And so has Jennifer Crumbley. She got on the stand and talked about every nook and cranny of her life, things no one else in the world knew, in her family, among her friends. And she wanted you to see.
I was
the
really
whole
disappointed with
truth,
her
the
until
entire
closing.
truth,
I will
and
say that.
nothing but the truth.
I
on
really like
everything,
this.
where she had to show you that she has made immoral decisions to have an affair, that she has made decisions you might not make to have another person involved in the affair. Now, we didn't get too far into the details, but it was enough for you to know that Mrs. Crumbley got up there and literally stripped off her armor, let the prosecution cross-examine her, and show you what happened in her messy life. And I say that with all kindness because I'm a mess too. I saw a meme about a week ago that said, I'm trying to be a mom, trying to get exercised, stay hydrated, get enough sleep, text everyone back, and not lose my shit. And I've got to be honest.
I love this.
Yeah.
I love this.
So with the $5 super chat, was late. Did jury instructions against the mischaracterization of the law issue around prosecution making comments about charging Jennifer with murder? So the jury instructions were really on point. They disregarded all the nonsense that the prosecutor said and actually stated the law as the court has ruled it. I don't think it's a good law that it necessarily applies here, but the judge did restate it, and the jurors are getting written copies of it, which is why some people had said, maybe it would have been better for them to go straight in Friday. I don't think so, because the prosecutor said a lot of stupid things at the end, things that don't line up with the law or the facts. And it was good for the jury to have a weekend to forget about that and then look at the printed page, what the law actually is and how they need to apply this. And I think this closing argument that we're watching right now will resonate more with the judge from an emotional, or with the jury from an emotional standpoint, more so than what the prosecutor was presenting,
Right.
which is essentially it was a PowerPoint of the 4 dead children and the witnesses.
Alicia, is that how that from wrongful? She's speaking to the moms, the moms and the dads. You have to juggle so many balls in the air, and like
Right.
I think it's going to resonate with the jury. Anybody that's ever had to raise a kid, and you can't keep track of it all at the same time. And
so on the jury, we have
Alicia,
the jury that's deliberating right now. We have 6 men and we have 6 men and 6 women. So 6 men and 6 women are currently deliberating. Yeah, so half of them are moms, right? So,
but she was gonna, she talked about, and her coworkers talked about how she came to the we gotta get him some counseling and da. So
As a mom, a working mom, on most days, I'm lucky if I'm fit for human contact. I'm lucky if I've taken a true shower and didn't just grab a handful of wipes and scrub off the best I can on my way running out the door, putting on my makeup as I drive to court.
Feels like
my
this
car.
was my morning.
Because my life
I'm
is
still
not
at home.
perfect and no one's is. And during
Listen,
this trial, you
I
may
don't
have
go
concluded
late to
you
work
don't
like
me.
Jamie, who works in her
That's
living
fine.
room.
I am just asking that your opinions about me as a person, and if you're one of the people who plans to make a TikTok about me, that you won't hold those opinions against Jennifer Crumbley. and
This is
will
where I thought
judge
she was really hung
Jennifer
up by that
Crumbley's case
TikTok.
based on the evidence about her and her family. And if you hate her or don't like her or agree with things she's done, that's okay too. You don't have to like her. You are not expected to go hang out with her when this is all over. After
Jamie.
trial, you don't have to decide if you want to go to her house. You don't have to have Thanksgiving with her. But when you're looking at the evidence in this case, it's important to set aside your
That's fair. I
opinions
don't
of
think I'd be
her
friends with Jennifer
or take
Crumbley.
your opinions of me and supplant them on Mrs. Crumbley.
Hey, Kaiser.
Now, when
We're just
took
hanging
on
out,
this
waiting
case,
for the jury.
pretty early on, I realized I am Jennifer Crumbley, and I could be here accused and sitting in her spot very easily. Now, in my house, we don't have guns. I don't have guns, but I do have children. And actually, I have an oopsie baby, my fourth one. I did not want 4 in 4 years.
Girl,
but
do you
that's
have an
what
oopsie
I was
baby?
blessed with. I say I'm abundantly blessed.
Listen,
And
how many children were
I have kids
planned?
that seem to have no issues. And at the end of the day, they're good
All of
kids.
mine
They
were
go to
planned.
school. We have no
To
discipline
the
problems.
minute.
We have arguments here and there,
Okay.
just like every family does. I have a son that wants to hang out with me very rarely, but I have no belief that any of my 4 children would ever harm anyone else. And while I don't have a gun, I have a large butcher block on my counter with big knives that I use when I cook, and I enjoy cooking. And at the end of the day, my kids could just as easily grab a knife without me knowing it and without me having it on my radar and walk out the door of my house and go play with their kids, the other kids on my block. Granted, they live farther down my block because I'm in the middle of nowhere. And my son could kill somebody with my butcher block knife that I would have never expected to happen. And if you saw the
Speaking of on Law and Seaward over the weekend, they were streaming police interrogation videos. And it was like nonstop police interrogation. One of them was a mother who daughter had just stabbed her son. And she's like, oh my God, I heard him scream and I went down and I didn't know what was going on. And he said she stabbed me and then I saw blood everywhere. And she's like, I have no idea why she did this. Should that mother be charged? She's freaking out that her son is dead because of her daughter. And anyways.
Well, did she hug him?
Well,
Or
that's
her?
the real question. Yeah, that's the real question.
Yeah.
WW with a 5-month membership. Mine was planned. Yeah, no, mine was planned. No, I find it very odd that people plan their babies. I've had conversations with people
Well-
that are like, "Oh, we're holding off another couple of years. We'll have a child." I'm like,
Right.
Okay.
And I mean, some people do, but sometimes you just. I knew what I was doing, what it could result in. So I planned it, right?
"Yeah, there you go."
messages
You
that
disregarded the
my husband and I
consequences,
exchanged
Farrell.
on a daily basis throughout this past year and even years before. It would be so
And
easy
kids are not
for
fully
me to
real.
be in her seat. With
Yes,
my kids, I monitor
surprises,
assignments.
not
I don't look at their
oopsies.
phones. I have no reason to.
Happy
my son plays a
accident.
lot of video games. My
Oh.
son's online talking to a bunch of
Listen
people
to
who's
this.
just playing a lot of video games. Even though he has a cell phone, I don't go through it and look at his messages every day. And as he gets older, I do know he's interested in girls. If he starts receiving nude pictures of a girl on the cell phone I own but let him use and gave him for his birthday when he turned 11, should I be held accountable for receiving child pornography if a girl sexts him over some inappropriate pictures? If my son
A lot of people
Oh,
were
I
upset
like that.
saying, right? I
I
like
like how
that
she
too.
said it.
But
when you
the
were
word
explaining
child
it,
prawn.
the way that you were kind of explaining it, I was like, ooh. But I like the way that she explained it.
She does it better than I did.
Well, because like everybody was focusing on the CP wording rather than the whole that she just
Yeah,
said.
they took it way out of
The
context.
cell phone that I bought that I let him use. That's
Yeah.
everybody. This case is because pews are bad. If it was any other thing, a car, a cell phone, a knife from the block in the kitchen, we wouldn't be in this trial.
Oh my God, I heard CP. Now my brain is mush. Yeah, I mean, but that's the thing. It's like just that phrase. Some people are like, oh, there's going to be a member of the jury that's triggered by that phrase.
Yeah.
First of all, if you're triggered by a phrase, I don't think you should be on a jury. That should be one of the tests.
Son decides he's going to send some pictures back and takes a new picture of his bits and pieces. That's a 20-year felony. Am I then responsible because he sent a picture of his penis over to some girl? So not only taking the picture, a 20-year felony, but then we've got a 7-year felony for sending it over. Can every parent really be responsible for everything their children do? Especially when it's not foreseeable. And this clearly was not foreseeable to Mrs. Crumbley, because there's no one in the world, including Mrs. Crumbley, who would have let a school shooting happen and let what happened on November 30th take place. Not only ruining the lives of so many families and victims and taking the lives of 4 young people, but also ruining her own son's life and ripping his life right from her as well. She would be the first person on the planet who would have never let that happen in a million years.
I think because the pew pew thing is triggering, she went with something triggering.
It just is.
Yeah.
And it is one of the first of its kind. Luckily, however, this is a case where the prosecution cannot meet its burden of proof. And thankfully, it's a case where truly Mrs. Crumbley does have a defense. And this isn't just one of those stretched cases where a parent is liable for what their child has done. Now, the judge is going to tell you that you have to, if you find reasonable doubt in this case, you must find the defendant not guilty. And the law says you must have a reasonable doubt, not 3 reasonable doubts, not 5 reasonable doubts, not 10. If you have a single reasonable doubt, you must vote not guilty for Mrs. Crumbley. And when it comes to reasonable doubt, each of you can have a separate reason to have doubt in this case.
Jury
You
has
have
a
to
question
agree
coming up.
on what the doubt
eventually.
is. And for that reason, what I am going to do
What?
is show you
They have a
Sounds like the
question?
jury has a question coming up.
Ooh.
We'll go to live when that
all of the
happens.
doubts that the defense believes exist in this matter. Some of them may speak to one juror, some of them may speak to another, but at the end of the day, if you have just one, your vote in this case must be not guilty. So the first place the defense finds reasonable doubt is in the fact that the prosecution is so desperate to prosecute this case that they admitted a mountain of evidence that, quite frankly, was unnecessary. Now, they say to you, they needed to show you, they needed to prove the manner of death. We stipulated that 4 people died. We stipulated that it was the most horrific set of facts you could ever imagine. We stipulated that what happened to Molly Darnell and Christy Gibson Marshall was horrible. But this prosecution, putting that evidence on, was designed to inflame you and make you emotional, strike your sympathy, and get you to hate Mrs. Crumbley, which, by the way, has been very effective for most of the media, most of the public,
I agree.
and for anyone who has seen information put out by this prosecutor in this case. A second reasonable doubt comes from the fact that we know, and the evidence in this case showed, context is key. And that was clear when Detective Wygrowski
She'll be
took
very
the stand
upset. She'll be a little grumpy
and
this week.
said, you get better decisions when you have more evidence, and testified that in a former hearing, he messed up because he didn't have the video from before the one he saw. So he believed the parents arrived at the school together. And subsequently, when given more context, showing more video from further beforehand, he could see they actually arrived in different cars, met, and walked in the building together. And at the end of the day, the more context you have, the more accurate you can be. When Brian Maloche testified, another example came about where the prosecution had him testify that Mrs. Crumbley said to delete his messages, clear your cache. And I'm so thankful that the rest of the world sent me emails that I don't know how to pronounce cache, because now I do.
Jamie comes
Oh.
back for a
And
jury question.
When Brian
And she
ended up
still said it wrong?
seeing the
So she says cache, And then she got a bunch of emails apparently over the weekend or whatever that said, no, you were saying it right. It is pronounced cachet. And so now she feels vindicated in saying cachet instead of cash. I don't know. It's all kinds of nonsense. It's just funny though. Cachet. We're going to go with Farrell for the correct answer. Is it cash or cachet, Farrell?
I have no idea.
I don't either.
My
I've heard it
IT
pronounced-
people say cash. So
I serve my cookies.
Yeah, right. So if for those of you who are just joining us, we are rewatching a little bit of the defense's closing argument while we are waiting. Apparently there's a jury question coming up. So as soon as the court comes back with that, we'll jump over.
Messages before clear your cache and after clear your cache, he realized, oh, she wasn't asking me to delete messages. She wanted me to refresh my web browser to see if the Facebook had actually deactivated. And so that was proof again that when you have more context, you're more accurate. And the problem the prosecutor has in this case is they have very little context for the very little evidence they've submitted. There's also no context around some of this little bits and pieces of useless evidence, like Jennifer Crumbley saying that her son was an oopsie baby. I call my son that, so what? Does that mean I hate my son? Does that mean I would be okay if he went and killed a bunch of people and or if he committed suicide? No. Calling your child an oopsie baby was designed to try to make her look bad with no context.
See, Kaiser's got it right.
Having Amanda Holland come in, a coworker who's not a friend to Jennifer Crumbley and has been interviewed by law enforcement to tell you her advice on she should go have a mother Sunday with her teenager, so irrelevant when she's faced with raising toddlers every day. When I heard her advice, I thought, yeah, right. I have 3 teenagers. I almost have a 4th. And personally, not only would they rather do anything else than spend a day with me, I'd rather do anything else. And we do spend time together, but that's not their first priority when they get to pick what they're.
Earl, would you rather do anything else than spend time with your kids?
No.
That's what you just
They don't. Well, but they don't always want to spend time with any of the adults in their lives.
right? But is this resonating with you? Are you getting it? Is it like working for you?
Yeah, I like it. I'm with Jamie. I think she's doing a great job.
These are 2 Midwestern women.
I think she's the Midwest
Right?
moms.
And see,
I think
Farrell
she's
has kids.
speaking-
I don't, and it still resonates with me.
Right, but you've been a kid. Like we've all been there. We're like, ew, mom,
Exactly.
no.
Well, my sister is the mom of 3 kids, 2 stepchildren, and I see what she goes through on a daily basis.
I stood
know.
next to my oldest this morning, and I was like, when did you get so tall? Because I rarely see him because he works and I work, but I was standing next to him today. I'm like, holy, who's this kid? That's how often I see him.
Yeah, I know. I just don't see my kids very often. I posted a video over the weekend of me taking care of my horse.
It does not mean she loved her son
And,
any less.
My kids weren't with me.
Yeah, I know. I commented on it. And you liked
here we
it.
go.
So
I was telling others. All right, so here's where we are. So everyone's getting all excited. They're all dressed
Jury
up for court.
question. Do you think that's a good
Yes.
thing? They have a question?
I
guess it
don't
depends
know.
on the question,
hopefully
right?
we get to find out what it is.
Yeah, right. Is the videos all? Oh yeah, zoom in.
He was milking his horse, MG.
Court is live for a question. Yes, court is live for a question. Let me take the banner down. Put a new banner up. Jury has a question. Welcome, everybody who's just joining us for the jury question. We have no idea what it is.
Mhm.
Why is he ATF guy? Yeah. He's just our friendly neighborhood ATF guy. He doesn't look creepy at all. He doesn't look like he gnaws on people in the basement. Let's see. Sounded like he was taking care of his horse. Horse. I need to enunciate when MG's around. We have no audio yet. Let me boost it though, just in case. because I don't know how this feed's going to be. Sometimes it's quiet. Defense isn't there yet. So
I like that. They have him there to provide lighting because he glows in the dark.
nice. The ATF guy looks like a bully from a 90s high school movie. Yeah, definitely. Local news is saying a verdict.
Oh,
What? Really?
ew. I don't like that.
I'm going to be mad if Ashley is not emailing me saying that we have a verdict. Ashley, we had such a good rapport.
Well, you thought you did.
I didn't get a
Everybody keeps
twat
saying
from
that it's a question, not a verdict.
yeah.
So we'll see.
Megan Fox says, "Who will be next after the Crumbleys?" I don't have a tweet from Law and Crime Verdict Watch.
Where did you see that? Great success.
Let me go to.
Yeah, this is not good if that's what it is.
Quick verdict like this. I'm nervous.
Oh, you're asking.
Oh, no. Yeah, no, it's just a question from what we understand.
Yeah.
Okay.
Yeah, everything is just, it's in the hands of the jury and we have a question.
Court TV says question.
Yeah.
Mhm.
Okay, that's much better.
And all the
What
law
if
and
the
crime
question
stuff saying
is, what do we do if we
question,
can't
question,
agree?
question.
That might be the question, actually.
I know, like, if people are hot on both sides.
Like you've been deliberating for an hour and a half. Get back in there. That'll be interesting, though.
I mean, I could go in an hour and a half and know there's no way, people. We're never gonna agree.
Well, yeah, I mean, think about it. You go in there and talk
You're
with
free
people
to
and you're
join
like,
me.
yeah, but I'm not joining you. Yeah.
Yep.
Let's see. What are they saying here? Jury now has the case. Okay. That's interesting. So a lot of these chats, people are back and forth, back and forth. This isn't like our typical trials that we watch from Ellen Seward or anything else where they're all, guilty, guilty, guilty across the board.
Yeah. Exactly.
It's very interesting. Close. I don't want to take your poll. Jury
Oh,
has a question. All right. Defense
I say
counsel
the
is
same thing every time I come in here.
what? Is
Pose. I don't want to take your poll.
should we put up a poll? What is the jury question? Let's see. All right. So what is the jury question? It's going to be the poll. We have
We're hung.
Jury question: is the defense attorney pregnant?
yeah, there we go. Let's see here.
I think our jury questions are way better than whatever the jury's going to come up with.
All right. What else do we have? Is Smith Prego? What if we can't agree?
What's
I was
for
going to say,
lunch?
can we go home and come
Yeah.
back tomorrow?
I like what's for lunch.
Could you please make oatmeal raisin cookies tomorrow? Oh.
Did we get dinner
What
also?
was the app Jennifer used? Is it any good?
Mass.
Oh, I love the questions.
All right, here we go. Jury question poll is up. Is Smith Prego? What's for lunch? Can we come back tomorrow? Can you bring us cookies tomorrow? It only lets me do so many options.
You're a goofball.
Are shoulder pads coming back too?
Apparently.
Because cringe.
By the
She
way, I watched
really
the
loves
Grammys
them.
last night. Did you see Hannah Montana or whatever her name is now?
Miley
Hair.
Cyrus.
Miley Cyrus. It was all teased up. She looked like she was in a wind tunnel.
Oh yeah, I did see something and I was like, what
Mhm.
is going on? But I didn't look too hard. She's became something else for me. She's a weirdo.
The judge isn't going to give an Allen charge. The judge is going to be like, you guys went back there for an hour and a half, 2 hours. Go back and try to make a decision. When I was on the jury years ago, we were like, there was like, I don't know, whatever it was, 8-4 or whatever. And we're like, we can't come to a decision. Just like, you've been back there an hour. Go back and deliberate. Defense is a wine mom, so the LNC wine moms are confused. That's awesome.
Poor thing. Ugh, I just want to hug her.
We can't find the exhibits. Can someone help us? You guys have so many better ones than.
I really hope they don't want to
Before.
watch some testimony. That's
Yeah.
weird. Is that normal for them to be able to rewatch the video of the testimony?
Well, they don't have transcripts, so yeah, they'd be able to.
But they have to watch the whole thing.
They have to
right?
watch the whole thing. Yes.
Yeah, that seems weird that they don't have to rely on their collective memory or rely on their own memory.
Yeah. Too bad they can't watch the closing again. Can we just watch the closing one more time? Just the defenses, though. We don't care about Karen's. Maybe they want more text messages. Can we see that stack again?
Your Honor, calling People versus Jennifer Crumbley, case number 222799990 FH.
Karen McDonald on behalf of the people.
Thank you, Marquise, on behalf of people.
Thank you. I'm Shannon Smith on behalf of Jennifer Crumbley.
Good morning. We got a question, you can be seated. We got a question from the jury that I thought was really easy to answer. I guess, I don't know if there's an agreement about that, but if you don't agree, then we're going to decide on the record how to answer it. The question is whether the standard jury instruction 16.10 and 16.13 are different. It says in 16.10 and 16.13, two different ways that we can conclude that involuntary manslaughter, or a 16.13 a support to 16.10. So I guess I would say the answer to the first question, isn't it? Yes.
It is, Judge, and I would just ask that the court reread 20.30A, which clearly articulates that. So I think that's why it wasn't just a yes or no response. Because I think this instruction, 20.30A, is right on point to the
It
question.
doesn't sound
Okay,
good.
so can I answer the first question, yes?
Yes, Judge.
And then say, please refer to 20.30A unanimity.
Yes, Judge.
Your Honor, I'm not sure. I'm trying to find 20.30A.
It's right between 16.13 and 16.10. It's the one that talks about alternative theories.
Okay, we'll just set there.
16.30, they
It's a
said.
non-standard, because it's a adapted from a civil jury instruction.
Oh, I don't have that one.
20.30A, it's a non-standard jury instruction. Both sides agree to it. It's a unanimity instruction.
Oh, I don't have that one up.
Sorry, Judge, I'm trying to find. Okay.
All right. 20.
Okay, I believe the court is correct. However, the way I read the question is that the jury is confused, obviously, about there being two ways to prove the charge. When they ask about one instruction supporting another, I believe that they should reread 20.30A, and then the one theory of the prosecution is 16.13, which describes the legal duty. I believe the second theory by the prosecution is 16.10, which describes the theory. Okay, but I think what supports 16.10 is the definition in 16.18. So when this jury is asking for a question,
Yeah,
about
that's how I
support,
read it too.
I believe the confusion lies in the fact that,
They're talking about the two jury instructions that I keep
well,
pulling up.
when they say, I don't see how,
So the jury is confused as to how to read the jury instructions. They're wondering if one informs the other. And what the defense is saying is that this 16.10 jury instruction regarding involuntary manslaughter, because it's informed defendant acted in a grossly negligent manner, and to determine gross negligence, you go to 16.18. This informs this question. Whether or not she acted grossly negligent is determined by answering these questions. And I think that's what the jury question is.
20.3A clears up the question they're asking.
And I don't know what
I
20.3A
believe
is.
the
I
jury
have
needs
that
to be
nowhere.
instructed to read
I don't know what that is.
20.3A, and then they need to consider 16.13 or 16.10, and in doing 16.10, understand the definition of gross negligence is in 16.18. That's what the
So they're
defense
having the same
believes.
problem we were talking about this morning.
Yeah.
How do you
pretty much.
determine
They didn't
gross
ask that question.
negligence?
It's not up to us to guess what they're thinking or not. The answer to the question.
There is no
first question
chapter
is clearly
20 in the
yes,
civil jury
and
instructions.
20.30A is clearly on point, so.
Yeah, the answer
The
is.
problem I'm having is there is no chapter 30 in the civil instructions, which they said it was a modification of a civil instruction. And there is the chapter 20 in the criminal is about CSC stuff. So I don't know what they're looking at.
Yes. And then I'm going to say, please refer to 20.30A.
Can we get an idea of what that is, Judge?
Right.
I have no idea. It must have been a special instruction that they drafted. It's not in the model instructions that I've been pulling up.
All instructions as a whole.
Thank you, Judge.
You know what, though? Whatever.
Right, I'm gonna sign this letter. Right?
Thank you, Judge.
Okay.
All right.
This is what I hate about this kind of stuff.
You may be seated.
Yeah, I'm trying to look and see. Let's see. Yeah, I can't find a jury instruction in the civil that would be talking about negligence general instructions. No, but that's the same issue that we have that we've been talking about this whole time. Well, That's probably not a good thing, right? It means at least one of the jurors does not resound to the defense's position.
Well, I hate the way that they go about explaining this stuff because they don't know the law. They don't understand it. If they're not understanding it, writing down, refer to this, blah, 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 doesn't clear anything up. I'm just speaking from my own experience. I'm one of those people who want to be like, wait a second. I don't need you to write a response to me. I want you to tell me, like, read it to me and be like, this is where your hang up is. Like, I don't know. Like my job's like that. Like they'll do that all the time. They're like, submit your question if you're confused about something to this board. And then people will be like, refer to instructions this. Okay, well, I referred to those instructions and they didn't make sense. So that's why I'm asking a question. So please
Right.
stop telling me to refer to this. Oh my God. This is why we get so
Here's the
much
question.
confusion.
So the question was from the jury when they're reading this, which is the involuntary manslaughter jury instruction, how are they supposed to also read it with this? Are they supposed to read them separately or together? And the answer was essentially read this other jury instruction, which apparently tells them that this instruction regarding gross negligence informs them on how to interpret this instruction. That's what it sounds like. But I don't have this other instruction, which is 20 point whatever, that doesn't exist in the civil jury instructions, and it doesn't in the chapter 20 and the criminal instructions is CSC stuff, so that wouldn't apply. They did say that it was a modified version of a civil instruction, so it sounds like something special that they drafted for this case. So I wouldn't have it. But essentially, the jury is confused as to how this jury instruction defining gross negligence fits in with this instruction, which is involuntary manslaughter. And like I've explained, this is what gross negligence looks like. And in order for her to be guilty of involuntary manslaughter under a gross negligence standard, the state had to have met this burden of gross negligence, which is more than carelessness. It means a willful disregard of the results to others from an act or failure to act. And more specifically, the state has said that there's two theories on which Jennifer could be held responsible. That the defendant caused the death of the 4 kids by storing the firearm and its ammunition in a way that allowed Ethan to have access to it, thereby acting grossly negligent. So this way. And theory 2 is that the defendant committed involuntary manslaughter by failing to perform a legal duty. The legal duty here is the exercise of reasonable care to control Ethan and prevent the minor child from intentionally harming others or conducting themselves in a way which is dangerous to others. To meet this burden, the state must show that Jennifer knew or has reason to know of her ability to control her son, knows of the necessity and the opportunity to exercise that control.
I agree, MG.
That the defendant knew of the facts that gave rise to the duty, that the defendant failed to perform, and that failure was grossly negligent. So again, this standard here, and that the death resulted from the defendant's failure to perform that duty. So everything comes down to this, gross negligence. So the first thing here is that the defendant knew of the danger and knew that the situation required ordinary care to avoid the injury, that the defendant could have avoided the injury by exercising ordinary care, and that the defendant failed. So they're having a hard time with this and mashing up this and this. But for me, it comes down to, did they know, and did she have an opportunity to take any sort of reasonable steps? If you are having to create a special criminal instruction created from civil instructions, then you have a problem with your case. Yep. That's basically go basis. Yeah. I agree, MG, 100%. If you're having to come up with special, well, everyone admits that they're creating new law here. This is brand new law. That's I don't think anybody's differing from that opinion. Everyone knows that this is brand new law that they're trying to create. So you would expect some special jury instructions.
Didn't you just say something this morning about how kind of confusing that was? Like you have to pull this up into this, and they're not attorneys,
Right.
No.
Yeah.
which is why
no.
they're asking the question now.
Mm-hmm. Yeah. So in order for you to find this, it says if they acted grossly negligent. Well, what does that mean? Oh, well, let's go take a look at this one. And what does that mean? Oh, what does ordinary care mean? Oh, let's take a look at this other jury instruction. It talks about ordinary care. And so you want an engineer to do this. And that's why, thankfully, there's an engineer on the jury.
Yeah.
But what about subject matter jurisdiction?
She should have done I think she probably should have done like a flow chart of how to do it. I like it when they do that.
Yeah. Let's see here.
In order to find this, you have to find this.
Right. So let's pull this up here. Okay. So
Because they're not going to
ordinary
do it. They
care.
want it to be confusing.
Let's see. Negligence, ordinary care. Where's the instruction? If it was the duty of the defendant in connection with this occurrence to use ordinary care for the safety of others. I don't know what ordinary. It doesn't really define ordinary care. Ordinary care is really what the jury determines is reasonable. It's the reasonable prudent person standard. It's the whole idea behind the reasonable prudent person, which is this objective standard that we measure people's conduct by. It's this legal fiction that we create. Well, what would an ordinary prudent person do? Well, it's what the jury says an ordinary prudent person would do. Let's see. The question was about 16.13 and 6.10. Did you mean they didn't mention 16.18? Well, if I go to 16.13, the defendant is charged with the crime of involuntary manslaughter resulting from the failure to perform a legal duty. Well, that's what we went over. First, that the defendant had a legal duty. The legal duty, it's the same thing. That's the involuntary manslaughter for failure to perform a legal duty, but they have to identify gross negligence in that standard as well. So either way you're looking at it, we're looking at gross negligence, and you still have to identify and determine what gross negligence is. Let's see. Second, that the defendant knew of the facts that gave rise to the duty. So again, knowledge. And then a failure to perform that duty. Let's see. The defendant willfully neglected or refused to perform that duty, and his or her failure to perform was grossly negligent. So then you still need to go back to the grossly negligent standard.
Best case scenario is maybe one juror is confused is stuck on one side and they're trying to get the instructions to like sway the person, but maybe they're, I don't know. That's just like
no, that could be it. There could be one juror that's like, I'm not coming over to your camp until I'm convinced. All right, well, let's answer this question.
And then yeah, maybe they're like saying, well, it's this and this, and they're like, no, that's not what it means. So then they're trying to like.
What I'm concerned about is now that they got this answer, they're going to go back in that room, and in 30 minutes they're going to come out with a verdict.
It seems like one of those. We have one or two stragglers who doesn't want to go guilty, and we have to hit them with the law. Just have the judge explain it so we can hit them in the head with the law and say, it's clearly she's guilty. I have a Jamie dog today.
So, Nick with the 50 Swedish krona, reasonable now and reasonable in 2021, just as the government was screaming about restrictions, should be counted in and should have been pointed out. The law, as it existed in 2021, is what should be applied. people's perceptions. That's why I think it's important to argue, like even in like Zachariah Anderson. Well, he's calling Walmart to figure out when it's open, and he goes there and buys gloves and cleaning supplies. Okay, well, it's the middle of COVID. Remember, everybody? Like, the stores weren't operating under their normal hours, and of course, you're buying gloves and cleaning supplies. It's the middle of COVID. But yeah, I agree with you, Nick, that reasonable in 2021 is different than reasonable today. Six to six, you think? I could see that. Oh, you mean the makeup, men and women? Let's see here. They were asking how 613 and 610 were related to each other. Yes, I believe I answered that already. Yeah, so it's still the same in that no matter what gross negligence statute or involuntary manslaughter jury instruction you use, it all comes down to gross negligence. So you have to be convinced beyond a reasonable doubt that she was grossly negligent. And that is this, 1618. That the defendant knew of the danger to others and that you would need to take ordinary care to avoid that injury. That the defendant could have avoided the injury with the exercise of ordinary care. So first, you have to establish that she knew that there was a danger. Second, that not only does she have to exercise ordinary care, that ordinary care would have prevented this, and then the defendant failed to exercise ordinary care.
But how do we feel about a question like that? To me, it seems like it's we have to hit someone in the head to convince them question.
Yep, that's exactly what it is.
It's not good for her, in my opinion.
No, it's not.
It's not clearly they should have proven way much more. They just want to say, see, if you agree on this part, it's the same as this part. If you agree on 1613, it's the same as 1610. It's yeah.
Amy Z, I do know that picture. Anyways, no, they're not going to let her out on bail. They're not going to admit it. They'll maintain bail if there's an acquittal, or especially if there's a mistrial. They'd be like, all right, you got 7 days to refile or something, and we'll hold her on bail. Or 3
Are
days.
they bringing the jury back out to tell them, or are they just sending a letter?
I think they just send a note in.
Okay.
The note will say, please read our special instruction 20 point whatever.
Well,
I
at least
hate that
they're.
so much.
I know. What was that other one when they were like, nope, figure it out?
That was Borowski, wasn't it?
No, I
it's
think it
gone.
Was it? I thought it was a trial that David did.
But didn't you also have it in the Anderson case where he just brought them in and started talking for 40 minutes to say, but I can't tell you anything.
Yeah, I think that was in Anderson too. Juries do have questions quite often, actually. Jury wants to know if they should be referring to Kurt's channel or ours for information. Yeah, that's exactly what it is. Refer to mine. Kurt's got him guilty.
Yeah, but that's why you should watch both streams at the same time, and then you can yell in the one you're not agreeing with, and the other one you can say you're right.
That's very true. But he didn't unalive people or shoot at anybody at the range. It's only at school. So we have to deal with the facts that we have. Let's see. I thought they argued it was foreseeable. I'm so confused.
So what is the law that she broke, though, is what I'm, because if there wasn't a law on the books in Michigan for having to keep your gun locked up,
right?
and there's no law saying you have to take your child to therapy.
Correct. Well, if there was a law that said that, it would be child neglect, not involuntary manslaughter.
So then you go after them for contributing to the delinquency of a minor or child neglect or.
Yeah, well, that's what I said. Contributing to the delinquency of a minor and child neglect. I can potentially get my head around those charges because it lines up with the law. I still don't know if I would convict, but at least the law makes sense. Let's see here. So we have, let's see, if a hung jury, and the majority is not guilty, would the judge take that into account for bail? Nope. Nope.
No,
I don't
because
think
the judge doesn't know the makeup of the jury, of the guilty and not guilty.
The question was how to, and we'll go back to the question. Let's go back. We'll keep debating on what the question is. Why don't we just listen to the question again? There's nothing wrong with that. Wait, hang on. There we go. Magic. We have time travel now.
Your Honor, calling People versus Jennifer Crumbley, case number 222799990, FH.
Karen McDonald on behalf of the people.
Thank you, Marquise, on behalf of people.
Thank you. I'm Shannon Smith on behalf of Jennifer Crumbley.
Good morning. We got a question. You can be seated. We got a question from the jury. I thought was really easy to answer. I guess I don't know if there's an agreement about that, but if you don't agree, then we're going to decide on record how to answer it. The question is whether the standard jury instruction 16.10 and 16.13 are different. It says a 16.10 and 16.13, two different ways that we can conclude that involuntary manslaughter, or a 16.13 a support to 16.10. So I guess I would say the answer.
Okay, so the question is are 1610 and 1613, are they different types of ways, two different types of ways to find involuntary manslaughter?
Or are you supposed to use them together?
Or do they use them together? And that's what I've been explaining, is that you need to use them together. They're not two different ways of doing it.
First question.
Okay.
It is, Judge, and I would just ask that the court reread 20.30A, which.
And then I got all confused by this 20.30A because I don't have that instruction anywhere. I don't know what this 20.30A is. So I'm going to put up.
Didn't she read it when she did the jury instructions?
Yeah, but she doesn't say like, and 20.3A is this and 20.
Oh, okay. I gotcha.
Yeah. So I need to figure out what that is.
It articulates that. So I think that's why it wasn't just a yes or no response. I think this instruction 20.30A is right on point to the question.
Okay, so can I answer the first question, yes?
Yes, Judge.
And then say, please refer to 20.30.
This is
Yes, Judge.
16.13.
It's right between 16.13 and 16.10.
Even the defense attorney's having a hard time finding it,
Okay. We'll just sit there.
which I don't know if that
It's
helps or
non-standard,
hurts.
Because it's a different from a civil jury instruction.
But I like that we are all in disagreement of what it means. So the juries are sitting back there because as someone reads that question, is it two different ways to reach manslaughter, or is it the same way to reach manslaughter? So clearly they don't
So they
understand
have
the instruction.
Yes, they have to find both 16.13 and 16. Wait, hang on. 16.18. Wait, what was my question? 1610. Okay, so 1610. So this is 1610. So this is the one that we've been going over. Then this is the alternative theory, which is 16.13. So these are two different ways that the jury can find involuntary manslaughter. So I will agree with the jury's summation that these are two different ways to find involuntary manslaughter. They can find her guilty under this theory, which is the one that we've been talking about, or this theory, which is a new one that we didn't have before, but the judge read out today. But both of them require this to be interpreted, which is a gross negligence, 16.18. Okay, I think that's what we got. The jury is confused about that. I don't know what the 20, with the instruction number 20, whatever is, because that doesn't exist. So this is a special instruction that they just numbered 20. Yes, the jury is asking this.
20.
Let's go back. Amy Z points out she's worried about the way the question is phrased. So let's listen
I
again.
don't know if there's an agreement about that, but if you don't agree, then we're going to decide on the record how to answer it. The question is whether the standard jury instruction 16.10 and 16.13 are different. But it says a 16.10 and 16.13, two different way that we can conclude that involuntary manslaughter, or a 16.13 a support to 16.10.
Is 16.13 in support of 10. Well, 16.13.
A support to, not in support of.
Yeah, so this is 13, and it's not in support of 10. These are two different jury instructions. The one that supports the two is 18. 18 supports both 10 and 13. So they're confused, but yeah, she does say, or the jury question does say can. This is two different ways that we can find involuntary manslaughter. If we want to read into the can any amount of significance, then it might be concerning, or it might just be the ways that they phrased it. 499 super chat from
True.
Wendy H. that says, please smash the thumbs up. Yes, please do that, everybody. Because obviously you're watching, so you must like it.
I guess I would say answer the first question.
Yeah. You're on the
Yes, Judge, I
panel.
would
You're
just
supposed to
ask that
like
the
it.
court reread,
I already liked it.
20.30A, which clearly articulates that. So I think that's why it wasn't just a yes or no response. 'Cause I think this instruction, 20.30A, is right on point to the question.
Okay, so can I answer the first question, yes?
Yes, Judge.
And then say, please.
I do that all the time,
Please
Dennis.
refer to 20.30A unanimity.
Yes, Judge.
Brother, I'm not sure. I'm trying to find 20.30A.
It's right between 16 and 13.
They can get 1610 or 1613 and find her guilty. They can find her guilty under 1610 or 16.13. They don't have to find both in order to convict her, but both require an analysis of 16.18.
And 1610. It's the one that talks about alternative theories.
Okay, just there.
Dennis says I'm hate watching.
It's a non-standard because it's a technical civil jury instruction.
I'm sorry,
20.30A, it's a non-standard jury instruction. Both sides agree to it. It's a unanimity instruction.
What'd you say? It was the what instruction? You're muted.
She said unanimity instruction, which
Yeah, that's what I thought. What's that?
would be, I don't know. I have to look it up, but my gut is that means that you guys have to be united. You know, you have to all agree on something. But it doesn't matter. Oh, I know what it is. I know what this instruction is. She read this instruction. It says, some of you can believe that she's guilty under 16.10, and some of you can believe that she's guilty under 16.13, and that's still a unanimous decision of guilt. That's what I think.
That makes sense.
That's what 30.30 or 20.30A is. Am I hearing background noise somewhere? Is it just me?
It sounded like Jamie is tried to speak, and it's her mic cut in and out. There was something
Okay.
in
No,
the
I've been
background.
muted the whole time. Sorry.
Oh, is court back?
No, court's not back. So that's what 20.30A is. All right. So okay. So what it's going to say is that the parties or the jury, each member of the jury has to be unanimous on a guilty verdict. It doesn't matter if you say she's guilty under 16.1 or 16.13. You guys can be split on that, but you all have to come back with guilt. That's the instruction that they're pointing them to. Not feeling good.
Nope. They're just confused on how to get to guilty.
Sorry, Judge, I'm trying to find. Okay. Okay, I believe the court is correct. However, the way I read the question is that the jury is confused, obviously, about there being two ways to prove the charge. When they ask about one instruction supporting another, I believe that they should reread 20.30A, and then the one theory of the prosecution is 16.13, which describes the legal duty. I believe the second theory by the prosecution is 16.10, which describes the theory. Okay, but I think what supports 16.10 is the definition in 16.18. So when this jury is asking for a question about support, I believe the confusion lies in the fact that
They didn't ask me that.
well, when they say, I don't see how 20.3A clears up the question they're asking. I believe the jury needs to be instructed to read 20.3A, and then they need to consider 16.13 or 16.10, and in doing 16.10, understand the definition of gross negligence is in 16.18. That's what the defense believes.
They didn't ask that, Judge, and it's not up to us to guess what they're thinking or not. The answer to the question, the first question is clearly yes, and 20.30A is clearly on point, so.
Yeah, the answer is yes. And then I'm going to say, please refer to 20.30A.
Unfortunately, I think he's right.
He is.
Yeah.
And I'm also going to say, please consider all instructions as a whole.
Thank you, Judge.
All right, new poll up. After hearing the jury question, what do you think the jury will do? Guilty, not guilty, hung jury.
I understand this note.
Did you see I copied Sean's question into private?
All right.
Oh. Is that Sean potentially criminal? Did you say?
Yeah. Yeah.
Oh, Sean, you want a link? You get a link, man, too. Let's see here. YouTube potentially criminal. Sean, wait. They're allowed to seek a conviction under alternate theories. Yes, they are, Sean. Yes, they are. So what they have right now is they have two different alternative theories. This is the general involuntary manslaughter theory, and this is the alternative failure to perform a legal duty theory. They can find, half of them can find her guilty under this one. The other half can find her guilty under this one, and they can still convict so long as it's unanimous on the guilt. It doesn't matter how they got there. That is the jury question that was just posed, seems to be confused by that. But yep, absolutely they can. And I'll send you an invite, Sean, just in case you're available and willing and want to jump on. You can give us your 2 cents on this wonderful jury instructions we have going on here. Oh, wait, why are we sitting all at the top? There we go. That's better. And the jury is deliberating once again. All right, so our poll is up. Our new poll is up. After hearing the jury question, what do we think the jury will do? Guilty, not guilty, hung jury. Wow, 54% say guilty. I'm kind of leaning that way too.
Yeah, with that type of question, it's because you can often gauge which way they are going. It was the same we had with I believe in the Rentala case when they came back and asked for some questions about the lesser included. We knew she was gonna get one of those.
Mm-hmm. Hey, Brent. The question was with regard to the 2 ways to find guilt, which I'm not going to pull it up on the screen again. I'm actually just going to read from my notes, which is 1, that the defendant was grossly negligent by leaving the firearm and ammunition accessible to Ethan. So you have to interpret the grossly negligent standard statute or the jury instruction to get there. Or 2, that the defendant committed involuntary manslaughter by failing to perform a legal duty, and that duty is to prevent a minor child from intentionally harming others or conducting themselves in a way which is dangerous to others. The state must prove that she knew or has a reason to know of her ability to control the minor child, knows of the necessity and have an opportunity to exercise that control, that the defendant knew of the facts that gave rise to this duty, and that the defendant failed to perform that duty, and that failure was grossly negligent, and as a result of that failure, death resulted. So that's the second theory, and both of those require an interpretation of gross negligence. But the jury's question was, do we have to find both? Can we find one or the other? And the judge instructed them to read 20.30a again, which basically says the jury must be united in their guilty decision, no matter if some of them find her guilty under 16.10 and others find her guilty under 16.13, so long as it's a unanimous guilty verdict. Hey, Sean.
Hey, Sean.
Hi.
Hi.
So, okay. So this is just, it seems weird to me because there's the duty of care, then there's the leaving the gun. I would argue those are almost two separate, like there should be 8 counts of manslaughter than total. Duty of care for each one and leaving the gun out for each one. Instead, they've like kit bashed 2 counts together. And the jurors all have to agree on the facts. This idea of is this allowed in Michigan?
Apparently, never really seen it before. I mean, we see it a lot of times with lesser included, but not 2 alternative theories.
Well, lesser included, though. I mean, even then, though, the jury still agrees that they committed manslaughter or they committed murder. Not some of the jurors thought, murder, and some said manslaughter. No, they all sign one sheet.
But in that particular case, they have to be unanimous on one count or the other. Right?
Yeah, and this one is allowing kind of like a non-unit. Like, has she brought the Shannon Smith?
This is a civil jury instruction, right? So this is
that's already problematic.
Cases.
Oh my God!
This is a civil jury instruction regarding the unanimous opinion of guilt, regardless of how you got there, regardless if it's under 16.1 or 16.13. As long as she's guilty, then it's considered unanimous. But that's a bastardized version of a civil instruction.
This is fake
instruction.
Did she raise an objection to this?
I have no idea.
Okay, well, I didn't know this morning if she raised an objection at all, because this is
baking. I'm aware of. She agreed to this.
This is baking in a lot of error.
Mm-hmm. Yeah, I don't like the idea of in civil cases. It's very typical to plead on the alternative. Like, for example, say like promissory estoppel, unjust enrichment, and breach of contract are 3 causes of actions which are very different, but you can allege them all as 3 different ways to recover from one cause of action, which is essentially a breach of contract, right? And you don't have to have some of the jurors can say, well, I think he was unjustly enriched. Others say, oh, he definitely made a promise and he broke it. And the third says there was a hard and fast contract and they breached it. But that's a civil thing. It's not a criminal thing.
Well, I mean, I get it in the sense that like the prosecutors could say, look, it's murder. And if it's not murder, it's voluntary manslaughter. And even if you don't think it's voluntary manslaughter, it's still involved. Like, they can make arguments that even if you don't think that's a requirement, it should be X, Y, or Z. But for them to say you can come to any conclusion you want and it's all good, that's not how it's supposed to work. If you want if you want a separate elements test, that's a separate offense. And the idea you can, and I also don't think it's not necessarily wrong for civil stuff to come into play, because in Ohio, and I think other states do too, your rules of procedure, if there's no applicable thing under the criminal rules, the next step is to go to the civil rules. And what do the civil rules say? And then if there's nothing there, you look through different rules of court that you have. So I don't think that's wrong to, bring that in, but I think you'd only bring that in if you couldn't get a criminal statute to work. And it sounds like they have criminal.
2, apparently.
Yeah. But I can't believe she.
I don't like the
this-
idea of the jury. I mean, because we have a
Yeah.
fundamental thing about unanimous juries, right? And
Yeah.
criminal cases, you need to be
Exactly.
unanimous. Where in a civil matter, you can have juries of smaller numbers, and they don't have to be unanimous, so
Yes.
long as it's like whatever 8 out of 12 or something. You know, that's all fine for civil stuff, but for criminal, it's always been unanimous. So now we're going to say, well, you can be unanimous on the guilt. It doesn't matter the way you got there. Was like,
Yeah.
well, that's kind of the point, is that they have to be unanimous on not only the guilt, but the way you got there, because it's the same sort of thing. Like, yeah, like you said, you would expect then there to be 8 charges, and they can maybe find her guilty of the first 4 that involve 16.1 and not guilty of the second 4 that involve 16.13. But still, there should be 8 charges. You're right.
Yeah, I just
It's really,
when you allow them to just squish it all together, that's not how this works, because then that does allow for people to say, screw it, good enough. And if that's what they're, if she allowed that, that's malpractice, I would argue.
yeah, it might
But anyways,
be.
also, hi, Baker. I didn't get to say hi earlier.
Hello, Sean.
Well, I'm
Also,
gonna step
who-
away and let you guys chit chat
Okay.
for a minute. I'll be right
Well,
back.
I didn't see who else is here.
Farrell's
I'll
Farrell
wife
go
and
to their
Jeannie.
avatars.
Hi,
Oh,
Sean.
okay. Hi, guys.
Hi, Sean.
Congratulations on your engagement. I haven't seen you since you got
I
engaged.
know.
Well, thank you. Thank you very much. I appreciate it. I know
It's,
Mrs. Smart
And
2.0
just
probably
to say,
appreciates
I'm
it
a
more.
big fan of your Crumbley commentary. We've been talking about it.
I
before.
know. I just found out like 2 days ago that that's who she was. So
Oh.
congrats.
Yeah.
Well, thank you. Yeah, I don't know. This is, like I said, there's a lot of things in this case I think should be, I would have done differently, but I'm not the one doing it. So
no, and
I
it's
just-
always Monday morning quarterbacking is always the
Yeah.
easiest.
there is. And like, like I've said, I also try to say I'm not F. Lee Bailey, so I get it. I'm not, I'm not the best when it comes to this stuff.
No, but I still, I think that again, I'm not even, I don't know anything about the law, and I live in Denmark, so I know absolutely nothing. But I still think that this case has been run amateurish by the defense. But maybe it's just me not liking that Shannon girl. I didn't like her from the start. I thought she took some weird leaps, and I think because in the end, court isn't about law; it's about juries.
Yeah.
And you have to be likable to the jury. And I think a lot of attorneys doesn't get that part, especially because they talk so effing long. Keep it short and sweet, and don't go down all those narrow roads of stupidity. I'm sorry, I really didn't like her closing in the first 30 minutes.
Yeah, well, the first 30 minutes weren't the best, but after that, I am serious. She was running around with her hair on fire. I thought she did a great job. And the thing is, they remember that. They remember how you end. So I think she did what she had to do.
But you still have the first note and the last note theory. The first note and the last note must strike true. Then it's always a great concert. And she started out very weird, and everything suggests that people can't concentrate for more than 45 minutes at max.
Mhm.
And I think have been doing this layman job in Denmark for the last 12 years, and we don't have those big closings or big openings, and still sometimes you're sitting there and really trying to keep your eyes open. And I think that's a problem in this case. She went on too long. She should just have pointed her finger at how come the school didn't do anything if they were so convinced he was a bad boy.
Oh, I agree.
Why are
But
people talking
that's-
about another question from the jury?
That happens. I mean, this is the
Oh,
problem with juries. They start asking questions. They don't understand what's going on. So that's not.
Because
they're confused.
I said
Yeah.
that because I said, I am one of those people that don't write a stupid little note to me and say, well, refer to this. I wouldn't have asked the question if
But
I
that's
didn't know.
but that's the problem. We can only tell you so much. Like
I
there's
know,
times where
and it
we all know
sucks.
we want to say something, and we all look at each other and we're like, all we can say is X.
Yeah.
Right. Like I'd be annoyed as shit if I was on the jury and I sent a question out and they were like, read it again. because that's what
Yeah.
they told him. Read this
And
part
this
of it.
is so important. This is so important. This is someone's life. There
Yeah.
should be more to it.
Well, but that's why we give you the instructions. And there's a judge I used to practice in front of, and he said the problem with being a judge is you're kind of treated like a little kid, and in a way, jurors are treated like children as well.
Yeah.
Mom and dad are, the attorneys in this. Mom and dad are presenting evidence, and they present evidence that they only want so much to be said, and you only get to know so much.
Yeah.
And yeah, it's very. It was interesting when he said that. I was like, wow, it kind of is, but yeah, we're only telling you what we want you to hear, and you have to make your, it's almost kind of like it's like a video game or a board game. We're setting your table. We set all the rules, and you have to play within that rule set. Well, I don't want to. I want different rules. Nope, these are the rules we're giving you. I have questions. Read the rules.
Yeah.
John with a 6 pound, or not 6 pound, that's a €6, isn't it? I don't know.
Hold on, let me see which
That's
one.
€6, yeah.
Yeah,
€6,
€6
yes.
super chat. I wish every juror who votes guilty a conviction of cheese pizza because of their kids. Ooh, wait, what's going on in court now?
Conviction
Oh,
of
no.
cheese pizza.
Yeah,
I don't see anything about a verdict. I'm seeing a question, but the court's moving around.
yeah, that'd be very quick for them to say verdict because that means the forms were all filled out already. Then
Mm-hmm.
I don't think that was the case.
I heard.
Oh, look, there's
another
the brave
question.
ATF agent.
Yeah.
He looks like he crossplays as the baddies from the 40s.
Yeah.
We don't have a verdict. We can't have a verdict yet.
So
No, I mean, like they would have literally had everything signed and ready to go, and then like, okay, this is cool. They normally don't do it that way.
yeah,
No, they don't. But
Yeah.
I don't see anybody put anything in there yet. That's a question, but
Yeah, but if there, it doesn't surprise me. There's another question. That's.
And
I've
if they
had
have
this
another
happen
question
before.
about the same question that they had, then this is what I'm talking about. Like,
Oh yeah, no,
make
I've had that
it
happen.
clear.
I've had that
Yeah.
happen. They're like, but what does that mean? And we're like, you have to read
Yeah.
the instructions. We don't understand.
That would be me. I'd be like, well,
Yeah, but
that's why I asked the
will they
question.
then come back and say, well, if you don't want to explain it to us, it's a hung jury. You have to go over it again.
Well,
I-
then,
I
well,
ca-
no. Well, they. I've never seen that before, but a jury can say whatever it wants.
I
Yeah.
would.
Yeah, they can say, if
They
you,
can
we
say
find
we're
her not
stuck at
guilty.
6. Yeah. Well, generally they're told to keep it as, don't talk about the deliberations and things like that because that causes an issue.
Mhm.
But
yeah,
No,
they're
but we
saying
had
it's
that-
another question.
We covered the treehouse trial out of
yeah.
out of Florida,
Mhm.
and they came back hung, and they got the Allen motion, and they went back, and 30 minutes later they came back said, no, we can't do it.
I
Oh,
saw
yeah.
that. I thought the judge
Yeah.
was going to send them back.
Well, I had one once where I had one over the summer, and we got a hung jury, and the jury had been out for like almost 2.5 hours. They came back in. They said we're a hung jury. The judge read the L instruction, and I was like, I looked at my client. I'm like, they're gonna speed run this. They came back in, said we're still hung. Judge read it again. Still hung, and they came back a third time. Judge is like, okay, mistrial. And those 3 instructions took a total of 10 minutes because at that point they were at their wits' end. They're like, nope, we're still screwed. We're still screwed. We're still screwed. So I don't blame them. I think the judge realized with the situation, it wasn't going to get any better.
I actually like the guy in Florida because he said, I read it once, the Allen instruction. I can't keep sending them back because I don't think they'll change because I instruct them, go back and see if you can amend your disagreement, and they couldn't. So off we go. And maybe it's because it was a Friday and he wanted to go home.
It looks like it's confirmed that we do have a jury question, not a verdict, which was better. Tell the folks about Discord memberships. Wendy H says for $1.89. If you become a member of my channel, you get access to my Discord, where we have a ton of content, including documents and motions from this case, as well as photos of the exhibits, text messages, and whatnot, as well as all the other cases that I trial. There's also cookies and nudes, compliments of Feral Housewife. So join now and don't miss out.
You say that.
One of them's compliments of you.
And it's not the cookies.
Thanks, Baker. Baker brings the cookies.
Yeah, when my laptop
So
works
you have a
again.
Discord? I didn't know that.
I do. Oh, hang on a second. I'll be right back.
Okay, bye.
How much furry
Yeah.
stuff is on the Discord?
Furries.
Not enough. The answer is always
not
not enough.
furries. Not enough furries in that.
If you can get around Young, David would probably let you in for free.
Thank you, M. Jung. M. Jung, sorry. I keep calling you Jung. I'll look on that. But they
It's
should be
confirmed it's
seating
another
the
jury
jury for the
question.
next couple of days, so we'll probably start up in the end of the week. That's not going to be fun.
Now I'm curious what they're asking now. If they're asking the same question over again, I swear to God.
Yeah, they might be asking a variation of it. Like I said, that's not uncommon.
Mhm.
Because the problem is, but I've also had jury questions where there's a squibble, like we're arguing for like 20 minutes over what to write, but usually that's not a problem.
Mhm.
You might say I disagree, like I object, that's the answer, but in your heart, like, yes, that's the right answer. That's the right answer to the question. So we'll see what it is.
I know. I think that's just a thing for me being like a normal person is what I call myself. Is like if I'm asking and then your answer doesn't really make me feel better, I'm gonna keep asking and like then it's just gonna be like, all right, well I'm not doing this because I don't understand what they're wanting us
Right.
to figure out.
And Pam asked if it was illegal for the ATF guy to be there. It wouldn't be because he's there as an expert. So he's
he's not really. He wasn't there as an expert. He's there as one of the investigation team. So he's there
Yeah, so
investigating witness. Kind of like if there's a murder, the detective stays there. But once the trial's over, all the witnesses can be in the courtroom. At that point, it's already done. So they can all hang out.
Yeah, but he could be there during the trial as well if he was to be called for rebuttal, right?
Well, it's not necessarily that he was being called for rebuttal, but it's because he was the investigating witness like that. He has the right to still be there because I think he was the only. I think he was the only person. Unless I was mistaken, there were other cops.
No, there was one law enforcement in the beginning. The guy who cried.
Yeah.
Okay.
Well, any of the law enforcement guys get to stay there.
Not all of them do.
On the state sides, it seems like.
Well,
yeah.
Not all of them do because some of them are witnesses. So,
Gotcha.
Yeah, they're.
What did I miss in the conversation?
Well, I'm just saying in general, you can only have so many witnesses stay in there, but also, I don't think the ATF expert got qualified as he don't think he got qualified as an expert. He was just their investigating witness. And I think they thought it would look nicer if they had a Fed hanging out with them.
Yeah, the Fed thing is really weird. Although, I explained that once you're released from the witness stand, you can kind of hang out.
Yeah.
And they just said, well, now he's part of our team and he's hanging out behind the bar.
Yeah, which it just looks more prestigious. Ooh, a federal agent.
Mm-hmm. That's what I was thinking. That's the reason why.
It was the tobacco guy, not the gun guy.
I'm sure I missed a ton of your questions, people in the chat. If you have questions, go ahead and post them.
Technically he counts as a gun guy, quote unquote.
Yeah, but he gets his information wrong, so
yeah,
not a very reliable gun guy.
Yeah.
Well, he's a typical Fed.
Well, yeah, but it's even worse though because he works for the Bureau of Alcohol, Tobacco, and Firearms, so it's even worse.
He's a perfect Fed. You can always fail upwards.
Yes. Yes, and
I love how the judge called him out for just recently being in high school himself.
Yeah.
But I live in a country where it's very hard to have a handgun, and I know you don't use a Derringer or practice shooting. That's for target practice. Sorry, that's a Derringer. It was so stupid. Oh my God, and the worst part is somebody probably believe him.
Marta, so when the judge gave the special jury instruction 20.30A and said it doesn't matter, some of you can agree that she's guilty under 16.10 and some of you can agree that she's under 16.13. The fact that there would be different facts that would require each apparently doesn't matter for this. So long as they both or everyone agrees that she's guilty in some way, shape, or form of one or the other, then it'll be considered a guilty verdict.
which I think is wholly unconstitutional.
Yeah, I do too. I have a problem with that. And they use a civil jury instruction, bastardizing it in order to make that fit is the problem.
Yeah.
But welcome everybody who's just joining us. The jury has question number 2. The first question is how to read the 2 different theories of the case. This is the general involuntary manslaughter charge. This is the failure to perform a duty manslaughter charge, which half the jury could find one, half the jury could find this one, and it would still be considered a guilty verdict overall, which we were just talking about. That was the first question, was how do we interpret this and this? The defense wanted a special answer to go back that says you use this, which is 16.8, the definition of gross negligence, to inform you as to how to interpret both of these standards. But the judge said, nope, that wasn't the question. So we're just going to send them back with read our special jury instruction number 20.30, which says you guys can find either the failure to perform a duty or the standard involuntary manslaughter and be unanimous that way. So that gives them 2 ways to find guilt, even if the juries disagree on the underlying facts. That seems like it's problematic.
And Kay Baker asked if it could be appealed due to instructions, and it can't because they agreed to the instructions.
Well, presumably.
You could still appeal. It's at that point you have to, I mean, and jury instructions are massive error, but yes, it helps if she appealed it or objected to it.
Yeah, and she might have objected to it. These things were sent back and forth via email ahead of time. That's what you do. You email the clerk and you email these. The prosecutor will email a version, the defense will email a version, and then where they disagree, there'll be emails back and forth. It's not like a formal thing.
She said that both of them agreed on that.
Well,
2030, whatever the heck
all
that
right.
one
Well,
was.
then she agreed on it. Then I guess.
Yeah, she said it when she was reading it that you both agreed to this.
Yeah, I mean, there still are ways to appeal it, but yes, that makes it very hard.
Although you were,
this might be ineffective assistance because that's a significant thing to change.
Yeah. If you were the 4-person on the jury, well, the 4-person doesn't tell people how to vote. The 4-person just runs it and says, all right, we're going to vote. Now we're going to count. Now we're going to do this and that. They don't tell others how to do it. But I would use my reason and logic, much like when I sat on the jury last time in Oakland County. I got them to drop 2 of the charges or quit on 2 of the charges and find them only guilty on 1. Because I thought that was what was appropriate. It's not grounds for a mistrial.
Not yet, no.
You think it's grounds for a mistrial that he's there?
You mean
lead investigator or whatever is always that there.
Oh no, not at
He's
this
the
point. No,
government.
everybody can be in the courtroom at this point. There are no sequestration of witnesses. Everything's done, even witnesses that weren't called. It's all done. It's all
question, Volstorm.
Sorry, I misunderstood.
It has to be timed it right. It's a second question from the jury.
Yeah, it's the second question. The first question is how do they interpret the 2 particular causes of action, or not causes of action, 2 ways of finding her guilty if they have to, if one informs the other or if they're independent. And the judge basically said they're independent. You can find either one, and then directed the jury to another set of jury instructions, which kind of lays that out for them. We have no idea what this question is. But this came back real quick, though. This was, what? It was 15 minutes, 20 minutes before we heard that they had another one?
I actually seems like it was sooner than that. The judge must be in the middle of something, and that's why they're waiting.
Yeah. Well, the judge was having her lunch or something. Well, they also had to bring the defendant up. That's what
I think it's because they had to bring her up and change her.
I got a question from the jury. The attorneys. Hopefully they could answer the question is, can we infer anything from evidence or witnesses that the prosecution did not bring, specifically not bring in the shooter or other people who could answer how it specifically got the gun?
Oh.
The answer is no.
I couldn't hear it.
Correct.
I couldn't either.
Can they
Witnesses.
infer anything from the witnesses the state did not bring, including like the
You can
shooter?
infer whatever you want.
Yeah.
Well, the question is can we infer any evidence or witnesses
Yes.
that the prosecution did not bring? And the judge's first response was, no, you can't.
Well, and
can
technically,
only
you can't,
make a-
well,
You can only make your decision based off of the evidence
Well,
that was presented.
yeah, but they are allowed. They're allowed to make the inferences they want there. That
I
you
know,
know,
but for them to ask,
that's a
the
big
answer is
thing.
going to be no.
Yeah, but
They
there's still-
already are if they're asking.
yeah, that's a thing. It's
I
just
love-
like every other jury instruction. You tell them disregard that statement. They're not disregarding it.
Yeah, but here's
No,
the
no,
thing. They
you're
thought
ringing the
enough
bell.
to ask the question, right? And so they're talking about it. And then one of the jurors is saying to the other one, well, you can't infer that because that wasn't actually brought up. You're just assuming that. And so they sent the question to the judge. The judge is going to come back with, no, you can't infer. And I think that's going to embolden those that are potentially not guilties. So this might be good.
Attorneys,
Well, I think it might be the not guilty side saying, well, why didn't they bring in Ethan?
the question
Yeah,
is,
I think
can
there's a
we
little
I
bit
think
of
this is a
everything.
good one for the not
the
guilty side.
witnesses that
Well,
The
question
prosecutor's not
was
happy about this.
The question was specifically regarding witnesses that the prosecution did not present. Here, we'll play it again.
the prosecution did not bring, specifically not bring in the shooter or other people who could answer how.
The shooter or other people.
Who could answer what though? What does she say to answer what?
Correct.
You
Yeah,
can
what
only
was that?
put the evidence in front of you.
Do I need to refer them to
She said this. Here we go.
witnesses that the prosecution did not bring, specifically not bring in the shooter or other people who could answer how it specifically got the gun.
Oh, how
He got the
specifically got the
gun.
gun.
Yeah.
Who
Ooh.
could
Ooh,
say-
somebody doesn't think somebody wants to. Oh,
Yeah, it looks like
Interesting.
someone doesn't believe it's gross negligence.
right.
Okay, so I didn't hear the second part. What's the second part of this then?
Okay,
how
so
he got the gun.
can we infer from the evidence and the witnesses that the prosecution did not bring specifically the shooter or other people who could say specifically how he got the gun?
Yeah.
That was the phrasing of the question.
I mean, yeah, you're only bound by the evidence in front of you that was presented, but you are allowed to, you can draw inferences, conclusions based upon that evidence. And if the
The
inference
judges
and
can-
conclusion is that they didn't do something right,
See what the judge is gonna suggest as an answer.
Specifically not bring in the shooter or other people who could answer how it specifically got the gun. The answer is no, right?
Correct. Judge.
The answer is no.
Do I need to
yeah. But
refer them to, do I need to send them 2.9 or 3.5?
I believe you need to send in 3.2, Your Honor, because a reasonable doubt is defined as a fair, honest doubt growing out of the evidence or lack of evidence, and it appears they're asking about lack of evidence.
Yeah.
No, they're asking if they. can
Oh, yes, they are, ma'am.
Why the shooter isn't there.
100% they are.
Yeah, Judge.
They need to
Come on.
let them fill in the blanks.
I agree with that, but I think it goes to, they're asking essentially why the shooter didn't testify or other witnesses, and the defense doesn't have a burden to put any on. So we believe it's important to remind the jury that the burden is on the people and that a reasonable doubt can come from lack of evidence.
Mm-hmm.
Yeah.
Just
Exactly.
Guess what they're thinking. We just answer the questions.
That
Mark,
was their
go
question.
ahead.
Can we infer the lack of evidence?
I'm sorry. Which instructions did you?
I was thinking, well, these are preliminary instructions 2.9 and 4.3.
Prosecutor's not going to like this.
Oh, 2.9 I think would be appropriate here.
I'm sorry, 2.9, and what was the other?
3.5, I mean,
You pull up
I don't think it says.
based on the second question now.
You're killing me, Smalls.
2.9 and 3.5 to them. 3.5 talks about evidence
They're all
including
true.
unsworn testimony, witnesses, the exhibits admitted to evidence, anything else I tell you to consider as evidence.
It seems on point, Judge.
I have an objection to 2.9. I am just making a record that I'm also requesting 3.2.
Okay, wait, do you want 2.9 or 3.5, either one of those? I'm trying to keep myself to answering the question that they asked. They have.
That was what they
about
asked.
reasonable
Yeah.
doubt. They've heard it a bunch of times. They do not have in the jury room 2.9, although they do have 3.5. So
Judge, the answer to the question is no, and I think reading 2.9 again and 3.5 probably appropriate given the question.
that's what I'm gonna do.
Thank you.
I'm gonna bring them in now. Okay,
Thank you, Judge.
I'm sorry. what's that?
I'm gonna bring them in.
At least she didn't withdraw this time.
He's
Yeah, I
bringing
think
the
they can.
jury in this time.
Mm-hmm. Because they did ask that. Can we infer from the lack of evidence?
Yeah, I mean,
I'm not liking
Because they-
this. I would prefer a no. Please direct your attention to jury instruction 2.9 and 3.5 written on a piece of paper handed back to them. That's what I would prefer. I don't want this because the judge tends to talk a lot. And I think the judge is going to talk her way out of a no.
Yeah, because she kind of, I like to answer the question that was raised, but the question raised was, does it paint anything towards guilt that they didn't show how he got the gun? So,
Well, that's my thing too, is like what my thinking is they never presented how he exactly got that gun that day. They never said it. What
Yeah,
happened? And they're
the other
not
guns were in a
presenting it to
safe.
them, so they can't sit here and be like, nobody can tell you how he got that gun that day.
which is part of the care of negligence. I think there's somebody hung up on that, but you're allowed to make inferences with the evidence presented. Is the evidence
Or lack
sufficient?
thereof.
Yeah. Is the evidence sufficient? Is there manifest weight of the evidence? The credibility of the evidence? You can say there's a lack of evidence here. Therefore, I can't do what you want.
Hopefully it's a good thing. Hopefully it is a good thing.
So, you asked, can we infer anything from evidence?
That's the argument
of
I would make.
witnesses that the prosecution did not bring? The answer is no. And you say specifically not bring in the shooter or other people who could answer how he specifically got the gun. So I'm going to take you back to our first day of trial and read you this instruction that I read you on the first day. When it's time for you to decide the case, you're only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. You also have a copy of 3.5, which I'm going to read to you. You don't have a copy of 2.9. That was read in the
And they can still do whatever they want.
3.5 says when you discuss the case and decide on your verdict.
And I like the
you may only
no,
consider the evidence
because
that
that's
was
going to be a hard
properly
no to
admitted in
people
this
that
case.
really wanted it to be a yes.
Therefore,
Yes.
it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence.
Oh.
Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. So I'm hoping that I helped you. All right. So I'll have you return to the jury room.
All rise for the jury.
Okay, start some questions. Sir, does this constitute a reasonable doubt on the blank card? Did Shannon miss this one?
You may be seated.
No.
Here's approach on the issue.
Wait, what are they asking?
Previously.
Yes, sir.
So Shannon, in her closing argument, she had note cards, and each note card had a reasonable doubt. She's like, and it's, it's talked about, did mom know, blah, 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 blah. Could mom have done something to prevent this, blah, blah, blah. And then the last one was blank. And she's like, and this is a blank one. And it's blank because there might have been some reasonable doubt that I didn't specifically identify. I don't want to cage you into my reasonable doubt. Feel free to find reasonable doubt other places. That's what this is for reference to.
Oh.
Thank you for the $4.99, Murphs.
Well, because she couldn't have commented on them not bringing him, right?
Yeah, she
No,
did.
but she's just saying in case I forgot something in the evidence, or if you found something in particular, like every once in a while, jurors focus on sometimes you're like the dumbest thing.
Well,
my very first jury trial, I was at the prosecutor's office and we didn't have video, and one of the jurors focused on the fact that we didn't have video. He must be not guilty and acquitted. Like nobody even brought up the video.
Said in her closing, they didn't even bring him in. Why didn't they bring him in? And he could have told us because he was pleading the fifth.
Yeah,
she couldn't bring him up because
that would have been a mistrial.
Yeah, because that's the same as saying, why didn't they put the defendant on the stand? That would be the same if she had pled the fifth.
Yeah.
So you can't do that. But to me, that would be the thing I would be hung up most on. Did they recklessly leave the gun out and put the box of bullet next to it and wrote a note and said, "Hey, honey bunny, take this to school with you"?
Yeah.
That would be the thing you would have to overcome for me to find this reckless. And they never really mention it. The only thing we know was they found 2 pew-pews, which both were in a case.
Yeah.
Right. No, the judge cannot ask the jury foreperson or anyone to clarify the question. They could bring them out and they could say, "We don't understand your question." I mean, that would be about it. But
yeah, they can clarify in another written instruction, but that's it. Yeah.
Yeah.
I still think she's right, and they should have read that one again. The one she wanted.
Yes. Yes, I agree. So for those of you who are coming in late, I know Valhalla wanted to know what the question was. The second jury question was, can we infer from the evidence and witnesses that the prosecutor did not bring specifically the shooter and other witnesses who could say specifically how he got the gun? That was the question. And the judge's answer was no. And then she read over jury instruction 2.9 again. To the jury and sent them back.
You muted.
I'm muted?
I can hear him.
Yeah, I can hear him.
Or did I?
You're all kinds of weird, Farrell, because you were talking over me like you couldn't hear me. But anyways, yeah. So the question is can we infer from the evidence and witnesses that the prosecutor did not bring specifically that the shooter and other people who could say specifically how he got the gun? So I think that's a good question for the defense. And the fact that the judge said no, even though, like Sean said, they can consider whatever because it's behind closed doors. I think the fact that they got a hard no is good for the defense. Now we're back to deliberation and just waiting some more. It's me. That's weird. Yeah, Farrell, it is all you.
But yeah, that shows that they're not just sitting in there and figuring out how to write their names in which order. They are
Yeah.
discussing. They are discussing the case. The first question kind of was, well, I find this part leads to guilty and this part leads to guilty. Now we have an indication that at least some of the people don't find that the parents left it out on the kitchen table to take it with them. And the journal, as someone pointed out, said, "My dad hit the pew-pew."
The jury has been deliberating for 4 hours thus far. 4 hours.
Yeah, I felt that question was in my mind. I was thinking, yeah, how can you really convict this woman of this without knowing how he got the gun that day? I mean, that's just my thought personally.
Exactly. And that's a fundamental issue with regard to the first count, which is that the defendant caused the deaths of the 4 students by storing the firearm and its ammunition in a way that allowed Ethan to have access to it, thereby acting grossly negligent. So I think that first theory is out if this is really where they're at. Now, the second theory, which for some reason is allowed, 2 alternative theories on one count, the defendant committed involuntary manslaughter by failing to perform a legal duty. That is, that she knew or has reason to know the ability to control her minor son, knows of the necessity and the opportunity to exercise that control, that the defendant knew of the facts that gave rise to this duty, that the defendant failed to perform, and that failure was grossly negligent, and that as a result, death occurred. There's a lot of knowing in there, right? There's like 3 or 4 no's in that. Plus, if you go to the failure to perform is grossly negligent. Well, in the grossly negligent statute or jury instruction, there's a bunch of no's in here too.
Yeah.
Meaning knowledge, right? So she has to have known so much in order for her to be guilty just under the statute. And again, the prosecutor herself said nobody saw this coming. So I don't know how we get there.
Yeah, I don't know.
Wait, what? This is for you, Sean. Brandon with $4.99. Yes, it's a good question because Sean, is that supposed to be
I think it's
S-E-A-N?
Shannon.
Oh,
I think he's
Shannon
talking about
loses
Shannon.
every battle on the law. Oh, I thought that was supposed to be
Seems a whole
Sean.
lot.
Throwing shade at Sean. Let's invite him on and just throw shade.
I do lose. I lose more than I win, but that's kind of par for the course.
Brandon's typos are, well, if
Yeah.
you're a criminal defense attorney, you're going to lose.
Well, that's the thing. Some people are like, oh, if they, I want an attorney who wins all the time. Like, then you find a guy who's not taking cases or he's bribing people.
Mm-hmm. Exactly.
So
there was a female wrestler once who had a promo where she said, "I don't win many matches. Actually, I'll lose most of them. Who cares?" Well,
yeah, I know. Yeah, no, I know. But yeah, I mean, but everyone's like, we win. You see those advertisements for attorneys. They don't win everything. And if they sincerely tell you that we win everything, they're lying to you.
Yeah.
Or they're not taking clients, right? It's easy to win when you don't have clients.
Yeah.
So Ken's counseling couch had a question, but did the part of the journal about him, meaning Ethan, trying to find the gun actually come into evidence? It did not. It did not.
Why didn't it?
Because the judge found that it was impermissible hearsay, although other parts of the journals were.
Oh, there's a forensic judge.
So what?
Yeah.
How is that hearsay, but not the rest of it?
That's a good
we yelled
question.
about that Friday
Because
for a couple of hours.
Said so.
Yeah.
I was
Farrell's
sleeping,
obviously
Baker.
watching.
She's like Ron Swanson. Why? Because I said so. I decreed it.
Yeah. But don't you know it's a present tense recollection of whether?
Yeah, well, it's a present sense impression. I mean, there's a lot of different hearsay examples it could be, and if any, I mean, it's all hearsay in one form or another because you don't have the right to confront Ethan. Although I think
fundamental violation,
which I think it's still you drag him in there to make him say the fifth. I have the right to, like, he might change his mind. You don't know he's not going to.
Mm-hmm.
I still think you do that anyway.
And that makes no sense to me how one part of his journal could be permissible hearsay,
Mhm.
but other parts are not.
Well, I mean, there are exceptions. I mean, it's some hearsay is acceptable, some isn't. I think it all depends.
The question is well, there's two fundamental questions with hearsay. First of all, let's define what it is. It's an out of court statement,
Mhm.
not under oath, not subject to cross examination, that's offered for the truth of the matter asserted, right? You're offering it to prove a fundamental fact in the case, right? So,
Yes.
so that's what you're doing, and it's not subject to cross examination, which is what makes it hearsay, right? So, so with that, you're talking about the right to confront the witnesses against you, and you're also talking about the reliability of the statement itself. How reliable is it? So a lot of the hearsay exceptions go to the reliability about it. Yeah, you don't have the right to cross-examine the statement because it was made, 6 months ago and not in court or anything like that. But when we're talking about a visit to the ER, the statements can be fairly credible because they're doing it in an emergency situation, presumably for medical treatment, right? So someone's not necessarily going to lie about some of the facts in that medical setting, such as I got shot instead of I got stabbed, right? You don't really want to lie to the doctor about what the nature of your injury is when they're trying to save your life, for example. So the reliability of it is not really the fundamental issue. So that is one of the exceptions that's brought in. It's the same thing with an excited utterance. It's like in that moment, in that heat of passion, seconds after the event occurred, someone's not necessarily had the time to think about a lie that they're going to project. Now, that's not saying it's impossible, but the reliability of it is fundamentally kind of there. You can kind of rely on it because of the nature and the circumstances. So that's where some of the stuff comes in. But something that's in a journal that's written down days, weeks, months, whatever ahead of time, it doesn't fall in any of those categories. It's inherently unreliable. So it should be allowed to be cross-examined. It shouldn't be allowed in. And so that's why I have an issue with any parts of the journal being let in. But that being said, if you're going to allow parts of it, you should allow other parts.
Yes.
Right.
I
Why
think
is
the
the only
problem that
part that is good for the defense?
they got like 5 or 6 provisions of it admitted under the present sense impression exception of the hearsay rule. And apparently the parts that the defense wanted to get in, the judge says, well, that's not really a present sense impression. Although I disagree. That's what the judge said. The only other option was to admit all of it, which would have been really bad for the defense in general. So I think the defense was just hedging their bets and be like, all right, forget it. We're not going to bring it in.
Sure sounds like they could have used it.
David, you should still invite Shannon. I'm going to, but apparently the gag order is going to be in place on this case until after James's case is done. So she's not going to be able to come in and talk about
I
it.
don't see how that's I don't see how that's legal though if she's not counsel or a party of that case.
Yeah, I don't know either, but maybe they'll hold off sentencing. Oh, by the way, did you hear the king has cancer now?
King Charles?
Yeah.
Oh, I'm sure. Well, nobody likes him anyway, so.
I heard that when we were the court at one point, or the feed at one point, went to a story about him while we were just sitting here waiting. Channel 2, Fox 2 News, for some reason, likes to jump around a bit. So I'm going to find another feed.
Good citizen asked, why is Ethan pleading the fifth if he pleaded guilty? Please remind me.
Because he has a lot of appeals going on.
Yes, and he also has the right to plead the fifth.
Mm-hmm. He does.
He has the right not to talk.
Okay, so all the feeds are down. So I'm going to go to the court feed. I'm going to open Zoom up again, just in case they come back. I don't know
he has
why
the right to plead the fifth, and he wasn't immunized, so is what it is.
Mm-hmm. All right.
Jackie Kennedy, the second was if they could infer anything from the state not bringing Ethan on the stand.
Yeah, is the defense allowed to infer anything from
Well,
those
that tells
witnesses?
me that, yes, they are all wondering why that kid isn't here to say, yes, my mom gave me the gun.
Mm-hmm.
Yeah, we had them flying around the house all the time. I could just pick him up and they said, go, take it to school.
Yeah.
That's what they want to hear.
Okay, I have the
But-
Zoom feed up. So if the court comes back and the news media is not going live with anything, we'll still be able to pick it up. Oh, where is it now? There we go.
If you're
Yeah, because they're now
questioning
talking about
how
Las
he
Vegas
got the
welcome
gun,
Super Bowl
reasonable
celebration.
doubt.
Yeah, well, there's
Yeah, exactly.
a reasonable doubt. We'll see.
What is 7/25/25 day 6? What is this? 7/25/25 day 6. What is that?
Is that when Mom was talking about it? But they want somebody that's not her to say if the gun was locked up or what. They want somebody to verify what she's saying, kind of. Or
Yeah,
to say,
specifically, the question was word for word. Can we infer from the evidence and witnesses that the prosecutor did not bring specifically the shooter and other people who could say specifically how he got the gun? So
Yeah,
that's the exact question.
If I'm the state, I'm getting concerned
Yeah, me too.
because the jury's starting to smell a rat.
Yeah.
And even though there's reasons, yes, as a juror, remember, people like stories, they like the narrative. Well, why isn't the shooter here, the kid who actually did it? To say, yeah, she gave me the gun. Yeah, she didn't supervise me. And
By the
that
way,
leaves the state in a predicament.
Only half of you watching right now have currently taken the poll. I'm going to shut it down in a little bit if you want to go vote.
Ride the poll, chat.
And hit the like button. Not even half of you hit the like button. That's
Also,
why Phil and Jamie doesn't turn the camera on.
Brandon Lesko asks,
that's true.
Did you think you would be having this much fun, David? Okay. Also, why can't you read? Well, you got to spell correctly, sir.
Says David.
Yeah, I know.
I'm all good with it. I see no conflict there. What's the problem? Let me see here. Okay. Yeah. Okay. So Fox is still, for some reason, on the on Las Vegas welcomes the Super Bowl celebration. That's what we've got going on right now.
Oh, Super Bowl.
Taylor.
That's right.
Usher.
I
Taylor's
can't broadcast
gonna win.
anything that says Super Bowl, or I'm going to get struck in a heartbeat.
You'll get
Yeah,
sued.
They're gonna hit you harder than Disney. It's
Well, I've said the word twice now. I'm going to get in trouble.
Uh-oh.
Did you see
Yeah.
the lovely Taylor Swift was accused of
4 times winner of the Grammy, 4-time Grammy
Yeah,
winner.
and she was
Grammy winner.
accused of racism because of that, because she won more than all the others combined. So now she's a racist.
Yeah, well, it happens. She's gonna, you know what she's gonna do?
We all are
Gonna shake
at some
it
point.
Well, she's blonde hair
Shake
and
it
blue
off.
eyed, so the blonde hair, blue eyed white girl.
Yes, David.
Although I do like the I don't know if you guys ever seen the where people were taking like quotes from Hitler and they're like attributing the Taylor Swift.
No,
And
really?
it shows like, yeah, well, so it's like a picture of her all dressed up, like doing a pose, and then there's like it's all a nice, like fancy girly handwriting. It says Taylor Swift at the bottom. You're like, actually, that's a Hitler quote. And there were some really
Brandon,
good ones.
that was for you, David's little song.
And then people
I
started,
said the same thing to him this morning.
and the funnier thing, David, was people started doing it backwards, and they put Taylor Swift quotes and attributing them to Hitler, and those were even funnier.
Yeah. What to do about Lebensraum? Just shake it off. Shake
I
it
have
off.
sworn to live only free. Taylor Swift, is that a? Let's see here.
That is not a Taylor Swift quote.
Let's see. If
That is the
let's see.
Austrian
Do not
painter.
compare yourself to others. If you do, you're only insulting yourself. That might be a certain Austrian artist quote.
Sorry.
Ooh, let's do a who said it.
Okay, so it isn't history that makes heroes; it's heroes that make history.
Yes.
Taylor Swift. I believe it's on his second album.
Yes.
is to
Well, like this one's here. This one, I can get this one open up. Yeah. Relationships are like traffic lights, and I just have this theory that I can only exist in a relationship if it's a green light from Hitler.
I like Sweet Little Lang. It's me. Hey, I'm the problem. It's me. That should be attributed to the painter as well.
Actually, there might be a better argument for the Crumbley conviction if he did just unalive himself, because that morning they were concerned about self-deletion.
Yeah.
So it would actually be a stronger argument in favor of convicting James and Jennifer Crumbley if he did that, as opposed to taking out others.
Here's a good one. David, I put one up for you. I'm sharing.
Isn't everything Nate? Isn't everything
Nature's the best instructor.
Nice.
I mean, it sounds pretty mundane, but that's not from her.
Let's see.
Then there's also some really good ones, like Humanity's Fate is Among the Stars, and it's Taylor Swift. And it's like they take from like bad guys in video games, and it's actually pretty good after a while.
Like the colors in autumn, so bright just before they lose it all. That's
yes.
Mr.
Killer Mike got
Aslan
arrested because he had warrants because he's a black guy. It was BS why he got arrested.
Wait, hang on.
Is it against the law to be black in the Americas? We hear that all the time in Europe. Or is it? Do you need to do something more? Because I remember a couple of years ago, we had a Black Lives movement in Denmark with our 85% white people. And I think 13% are Middle Eastern, and the rest might be from Africa. But
that's kind of what the ratio of our demonstrations are too.
Yeah, but it was very fun. She did live up to BLM, so she got hit with some charges for fund mismanagement. It happens.
As a Christian, I have no duty to allow myself to be cheated, but I have the duty to be a fighter for truth and justice.
Oh, is that another quote?
Yes, another quote.
Yeah, there's some like they're great.
I can't pull it up because it's like a really small image, but it has her like kneeling down and all this calligraphy and stuff. It looks like it would be a Taylor Swift quote. That's awesome. Let's see. I think every girl's dream is to find white. No, I don't know. Oh, this one. This one, I think, is this a Taylor Swift quote that's attributed to now Hitler? I don't know. I think every girl's dream is to find a bad boy at the right time.
Adolf Swiftler.
Adolf Swiftler. Yeah. Who wants to not be bad anymore? Nice.
Yeah.
I think they're going back and forth now. That's a Taylor Swift quote attributed
these
to him.
These are brilliant.
That's awesome.
I forget how good these are.
Oh, welcome everybody.
Yeah.
We are back live in the courtroom.
Oh wow!
I see heads moving back around. What's going on here? I keep seeing heads walk by. Let me see if I can get some information of what's going on, because obviously the clerk is not emailing me.
And Kristen Hall asked, when is Boone trial? Before the sun burns out, maybe.
Yeah.
That
there is
probably not though.
So Sarah Boone, I covered it on Thursday. Who knows? I get the feeling this judge, this is attorney number 7, Rod 7 going on 8. He might tell her, well, then you're on your own.
That could be. I'm staying home from Tennessee. Then I'm staying home and covering it.
Yeah.
But she's supposed to be back in court on May 3rd for a pretrial hearing, and it's supposed to start on May 13th. Was the last.
Yes, but I have a feeling they might try to schedule something if the attorney's asking to withdraw. because until that's granted, he has to keep working.
The judge is going to make this attorney stay on because it's the best attorney that she's had rapport with, but is going to appoint him as standby and say she can go improper.
Which if she does, God, she's toast. But yeah, I mean, I could see her doing the impro, but I think it depends to the extent, and this will probably be done in camera. I mean, this will be done in chambers. What were the ethical issues? Because if there is stuff she won't like, I mean, sometimes the relationship is just toast. So I think it's going to depend. But I think I don't know though. But he's going to have
ethical issues are her intelligence and her thinking. It's not intentional. It wasn't intentional. Gets her off the hook for manslaughter.
I think so. I think it could be that, but she also might be asking him to do illegal things or unethical things.
Yeah. Oh, I guarantee she is.
I mean, it all depends. I mean, some attorneys are just like this attorney. He's an old timer. He's like, he probably says, I got better shit to do in my life.
It was so quick though, because you didn't hear anything, and all of a sudden there was a letter, and then there was a motion.
Yeah,
and I thought for sure they were getting along. The last time I saw them in court, there was like they were chit-chatting and stuff.
This is normally how it goes with Sarah. Things are pretty good for the first like 90 days. And then it all falls apart.
Then she drops the letter. He spent 1 day for 3 hours with me online, and I haven't heard from him since.
Yes.
That's 472 minutes since I last heard from him. And Judge, you must step in.
And I'm sure she's one of those, David, you've probably had these clients before where, you know, if you have a client who's stuck in jail or something happens, they screw up on bond, they call you and they call collector, like, I'm not taking the call, but I'll come, like, use that as a way for me to come see you. I'll come see you. So they call and, you know, okay. And then they call and then they hang up and they call you again, hang up and call you again, hang up and call you again. And they literally blow your voicemail up because that's partially how they handle things in like their normal life is they just call and make 85 million. Like they just call and act like little kids about it. So I have a feeling that's kind of how that went.
Oh, I guarantee.
She wants her attorney to be in her cell with her and be her beck and call 24 hours a day.
Yes. She thinks that the only case this guy should have is her.
Yep, exactly.
So,
but the judge is eventually going to get tired of it and is going to say, listen, we're going to trial. It's been 3.5 years. No.
David, pull up John's comment. It's at the very top.
They will sign Steve Gosney to her. Yeah. I think, didn't Steve say, no, who did he say he'd be willing to represent? I think it was Sarah Boone. He said he'd do it. I think he said he'd do it pro bono. I might be wrong. I might be misquoting him. And I don't mean to, if Steve, if you're listening and you never said that, but I believe he said he'd represent somebody. I thought it was Boone, but yeah, wouldn't that be amazing?
No, that's out in Orlando. He's not there.
He's not there, no, but he's practiced there before. And
yeah,
he knows the judge. He said, so he'd be willing to. I think is what he said.
Oh, I think. Yeah.
Oh, that was the Melly trial. You're right.
Yeah.
I'm sorry, Steve, to misquote you. That was
you know what the thing is? Like, I would take Sarah Boone. Like, I would do. Like, if they appointed me as Sarah Boone, like I'd do it. And you know, I have a pretty high tolerance for clients and their bullshit. Like, I think it'd be fun. Like, I think it'd be a hard case. Like, you know, I mean, I would do it, but I can't at this point because I've talked too much shit about her. But, yeah, like I think
all of us millionaires. She said that in one of her letters. Everyone covering on YouTube will be millionaires, and she should get a cut of that.
She's so mad about that, like the whole internet.
That's right. I forgot. I got my millions off of Boone.
Yeah.
Wow.
We had a trial once where one of those belligerent a-holes who just kept yelling at everyone, especially because it was some criminals fighting over probably some drugs or something, and his buddy was there to testify. He beat him up a bit, and he just kept yelling, and his lawyer was just constantly grabbing his arm, said shut it. And in the end he said, Judge, could we have a second? And we could just hear him outside the door. He screamed his head off of it, and then he came back and he was quiet the rest of the trial. But some people really don't know how to stop digging holes. It's always fun when people are stupid, but still believe they're the smartest guys in the room.
Wait, where's
Where
it go?
beyond?
There we go. All right, you guys want to see like a truly uncontrollable client? Here we go. The court just keeps flashing back and forth to nothing. Let me pull this up. You guys know the Toledo toe liquor?
No.
This has to do with racism. This has to do with some of my. I suggest that you not do it. Well, why not?
I just think it's in your best interest.
Well, I'm super intelligent, so I
understand that. But for right
Who's that? Who's this helpless defense attorney trying to get his client away from the news cameras?
this is pending, so it's
Not sure. He's missing his beard.
I'm not going to speak on anything specifically, but I do know my rights, and I'm allowed to speak. I am.
no, I understand.
No,
that. I can't stop
hold on
you.
a second. You don't want me to express myself.
That's not it at all. That's not it at all. I just don't want you to say
you-
something that
We don't want you to.
try.
It won't.
You to
It
cause
won't.
yourself any trouble.
I'll be fine.
Okay.
I'll be
I
fine.
just-
I just thought that was great. So, for those of you who don't know, that's Sean
Yeah, so that's the Toledo toe sucker.
with the Toledo.
Wait,
toe
what?
sucker face.
That's a Toledo toe sucker.
That's Sean with his Toledo toe sucker client.
No, you were really there?
That's when I was
Yeah,
in the
that was
PD's office. Yeah,
That was him.
Yep,
Holy
that's-
crap.
that's a public defender's.
Do I need
Yep.
to pull it back up for Jamie?
Yeah, go back.
All right, hang on.
I was just listening. I wasn't watching the video.
Oh,
Yeah,
well.
alleged
Yeah,
toe
now you get to watch
sucker.
it again.
The alleged toe sucker. We
I
need
don't
to
think
see
that
it.
mattered left foot, right foot. I think he was okay with
Well,
all
I'm
of it.
super intelligent, so
I
I
understand that.
He's super intelligent. Sean walks up. Listen, Mr. Jones. I understand you're super intelligent, but shut the fuck up.
Yeah.
Oh my God. No, that is amazing. That is
Yes.
amazing.
Yes. Oh, it was great when everybody in town saw it too.
No, it's just like how you are like on YouTube. It's funny because you're just like, I know that, but
Sean is his brain is crying right now. He doesn't know what to do. And he's panicking. His client, who is clearly guilty of sucking toes, is now talking to the news media without his consent or knowledge ahead of time.
Yes.
I'm sorry. Can we play it one more time?
Sure.
When you walk up,
okay,
that's my favorite part.
You
You
gotta,
like
you
when I
gotta
look at the
first
camera?
give the backstory here real quick first.
Okay, so this guy had a bunch of pre-trials. This guy, he literally went up to women, and like one of the women was at a shoe store, and he said, "Hey, can you try these on for me? I want to see if they fit my girlfriend." And she popped her shoe off and immediately dropped down and was like all through her toes, and kissed her on the cheek and said, "I'll be back later."
Oh
And
my
sure as
God.
shit, he shows up at closing, and then he does it to a.
Oh my God.
He does it to a lady out on the street somewhere. So he's got 2 counts of it. And yeah. So I'm having a pre-trial and he's being obstinate. And I'm getting ready to go. One of the bails comes in and he's like, "Oh, he's talking to the news." And I'm running a courtroom because like we have a docket day. And I said, "Your Honor," he's like, "Yeah, you should go take care of that." And that guy with me is my intern at the time, Josh. He's actually a really good guy. And I come down there and he basically tells me off. And when I look at the camera, I realize, oh my God, it's on and they're recording. Like I thought he was just talking to them at first, but I'm like, oh Jesus, it's recording. I'm on camera now. So it's like, it's getting worse from here. I then run downstairs after it's over and I go tell my boss. And we start looking because we're like, uh-oh, because he's worried like what's happening. And thankfully we didn't make the noon, but then we got I made the 6 o'clock news and I didn't know it until I was driving to see my parents. And my phone just kept buzzing for like 10 minutes straight.
Jamie,
So-
if you're into the toe licking thing, I think he's probably still single.
And here's the thing. He viewed himself as like a Don Juan. Like if you've
Oh, I
ever
can
seen-
tell.
If you've
Look
ever
at him.
seen Predator, he's a sexual tyrannosaur, like Jesse Ventura would refer to. And he, after I think it was a hearing or two after that, he didn't like me anymore, so he told me to get lost. and the other public defenders were handling it. And I went to his trial, and I sat in the back, and he told my colleague he didn't want me there. And my buddy was like, he's like, you really don't. He's like, he doesn't want you here. He's like, I can't kick you out, but. And I was like, I get it. It'd make it easier on my buddy who's in the defending the case. Like, I left. And I sat outside, and I'm watching through the windows of the doors. And there's one point you could see everybody in the jury kind of visibly like squirm and try to push backwards a little bit. And they're bolted down chairs. They're captain's chairs that swivel. And he had testified. He's like, if I was, to the men out there, but also, to the women on the jury, but also men, your wives. He's like, with 30 seconds and any woman and they're putting in my hands. And everybody visibly wanted to get away from him. And he got convicted. They were only misdemeanors, so it wasn't that big a deal.
Ladies, this is the face of a man who licks toes.
Oh
he had a lot of mental health. He had a ton of mental health issues. He had a ton of them.
Why not?
And I hope
great.
I hope he got help.
I just love when Sean comes up. He's like, I know I'm really intelligent. Like, I'm sure you are.
Well, I'm super intelligent, so I
understand that. But for right now, this is pending, so it's a pending matter. Yeah, come over.
I'm not going to speak on anything specifically, but I do know my rights, and I'm allowed to speak. I am.
No, I understand.
No,
I can't stop
hold on
you.
a second. You don't want me to express myself.
That's not at all. That's not at all. I just don't want you to say something that
we don't want you to
try.
It won't.
You to
It
cause
won't.
yourself any trouble.
I'll be fine.
Okay.
I'll be fine.
Wait, hang on. I don't know why I keep doing that. But yeah, so that's the Toledo toe sucker there.
I'm sure you are.
Yeah.
I love that Sean was part of that.
Yes.
That was
Yeah, it was
Oh
great.
my God, stop it.
Well, then after a while, they the guards and the deputies at the courthouse, they'd be like, it's when I would use my hands, they'd say it's like, or other trainers would do it. They're like, oh, he's doing it. They're doing it, Sean. Or I'm trying to like steer him with my hands, and yeah. Oh,
The jury has been deliberating for
God, I love it.
like
Oh my gosh.
4.5 hours. The jury's been deliberating for. Somebody asked that while we were watching the Toledo toe sucker.
yeah.
I just love that that's his name too.
Yes. Joseph Jones. Or is it Johns? I forget.
Yeah. So like 4.5 hours. The jury's been deliberating.
And I think
Joseph-
Sean's right. You kind of have to have something wrong up here if you're just going around a stranger's
I don't know,
feet.
Farrell. How do you get by?
What?
She's
I wasn't
annoying.
paying attention.
The toe sucking. It's something that you're into. I know, but
Listen, I'm muting you.
Well,
she just canceled herself.
do you
out.
prefer like all the toes at once, or do you prefer like one toe at a time?
Why
No
is this guy on the
thanks.
stream again? Rose.
This could be exclusive Patreon content. So there you go.
This is really important, Farrell, for my OnlyFeed account.
Yeah.
Only feet account.
Yeah, apparently I have a OnlyFans with my feet on.
Let's see.
I
here,
didn't
live
make it.
chat. Sorry, I've been ignoring you guys a little bit, chat. I'm just trying to keep track of everything. How you guys doing over there in chat world?
Mhm.
What is considered a long deliberation? Well, in Michigan, I would say a long
35
deliberation is. Well, that's you. But in Michigan, I would say anything that goes beyond 2 days is good to be considered a long deliberation, at least in my experience.
I mean,
Seaside, yeah.
that's the thing. Yeah, I've had 20 minutes. I've had like, day and a half before. It all depends.
Yeah. I had one in Oakland County that you have to sit close. So I was like, all right, take the elevator down to the cafeteria. I was gonna sit and hang out for a bit, and then as soon as I got down there, I got a call that jury was back. Like, oh, okay. And then I've had some that took. I haven't had any that have gone 2 days, but I've had other colleagues that have had some that go 2 days. Most of my stuff is fairly quick.
Yeah.
You don't think Dave's actually sorry for ignoring chat? Yeah, maybe not. I like chat. Chat's fun. What a poppin' toe. Wait, what? What a poppin' toes. Yeah. So, Sean, have you ever fired a? Well, we got on this track because of Sarah Boone, and she keeps firing, or not firing her attorneys, but keeps causing conflicts. I've only had to withdraw on a couple of cases where I really
I've had to
like,
withdraw
serious
here and
conflict.
there, but generally I don't withdraw until they tell me to leave. I mean, like I could put up with a lot of bullshit.
Yeah.
And you know, it's like I for the most part, like I don't think it's gonna, you know, I don't know. Usually when I'm at that point anyway, it's because I'm they brought me along anyway. So it's like if I've been appointed, I generally try not to withdraw if I can't avoid it. Because I feel like it just causes more problems. Because I've also been where you're the second, third, fourth attorney, and I really at that point I'm like I really don't want to withdraw because it's like, you know, you're you know, it's not you, it's them, and you just work around it the best you can.
Yeah.
But,
And
but
then
have
they
you
just seem to get more vocal.
have you ever had someone who you just couldn't control? Because I bet like a Daryl Brooks kind of guy shouting and yelling. He did that when his defense was there. Because normally you'll see them they act up in court, but in Denmark when we do the most of the criminals know the rules. They just go in there, do the thing, and. But have you had anyone you just couldn't control where you had to say, I just can't. You're just too stupid.
Not Daryl Brooks.
The only
bad,
time
but
that I really had an issue for me was when I had a client that wanted to essentially admit perjury on the stand and present perjured testimony and evidence, doctored evidence and perjured testimony. I was like, I absolutely can't do that. So you're on your own, man.
Yeah. And I've been pretty lucky in that regard, but yeah, I've never had anybody Daryl Brooks bad, but you know, I've had one or two where they've been like just real asses, and I'm like, okay, fine, well I'm out. But
life's too short to deal with some of the clients.
But a lot of people, but for a lot of people, really, at the end of the day, if you sit there and just people want to be heard, and if you let them just get it out, generally that kind of takes care of a lot of the problems.
Lovely Beth wants to know what the sticky notes are behind Baker.
It's my wall of fame for when I get super chats or memberships or buy me a coffee contributions. Then I have the 6 different levels you have on YouTube. And then I have my $1 million banknote that I'm going to bring to Tennessee and buy David a drink with. He's going to buy, he's going to bring it to the bar, but I'll let him have it. But it's another way to remember that some people are way too generous and support us crazy people having a YouTube channel.
Yeah, I don't know why you all are here listening and supporting us, but we appreciate it very much.
Because of Jamie, as always.
That's true. Oh, someone had a question for Jamie earlier in the chat about where she gets her headbands from. And when she comes back, maybe she can answer that.
Huh?
Your headbands. Someone wants to know where you get them from.
Amazon. I just get them from Amazon.
I was just going to say she probably gets them from Amazon. So I'm glad you confirmed my thoughts. All right. So the first jury question was whether the jury instruction 16.10 and 16.13 are different. Are there two different ways that we can find for involuntary manslaughter was the question. So 16.1 is this instruction, which is, if I could find it again. This is 16.10, which is the defendant is charged with the crime of involuntary manslaughter for failure to perform a legal duty. And the other one, no, I'm sorry, that was 16.13. This one is 16.1, which is that the defendant acted in a grossly negligent way. And what the court has said is that the jury can find her guilty of involuntary manslaughter both ways, and that they do not have to be unanimous on which way they find her guilty of involuntary manslaughter. Half could be this one and half could be this one, which I don't like at all, because that means that the jury's not consistent. They're not agreeing on the facts, which they should be. They should be unanimous on the facts. And then the second question was, can we infer from the evidence and the witnesses that the prosecution did not bring, specifically the shooter and other people who could have specifically stated how he got the gun? So that one I feel like is more pro-defense question. So there's been 2 questions thus far. Now they're back to deliberating, and we'll see how long this goes. What happens if she doesn't agree to the pro se? Could they make her that feels? There's been some courts. I've never really looked into it because usually at that point I'm not on the case anyways. But there's been some courts that say, "Listen, you gave up your right to have an attorney by being so difficult and not working with."
It's not unlimited.
Yeah.
You know,
Right.
70s
Eventually, you're going to run out of attorneys in the country. You know, like it's not like you can go through every attorney in the United States.
Yeah, but this at some point, yeah, she's pushed her luck, and you know, is she really wanting an attorney, or is she jerking everyone around? Like it's never, no, that you run into all these issues with that.
Yeah. Sorry, all of a sudden you got really hot on your mic, but I just made you.
Sorry.
I just automatically adjusted you, so you're fine.
Okay.
Non-specific charges, 2 theories. I think. Well, the problem is that the defense apparently agreed to this. Although I don't know if she agreed to the jury instruction, which is 20.30a, about
That's the one the judge said you both agreed to this. That
Yes, but did she
2030A.
agree to it because she thinks it's a brilliant idea to have 2 different theories to find my client guilty, or did she agree to it because, Judge, you made a ruling that there's going to be 2 different theories, and if that's the case, then 20.30a, as we bastardized it, is going to be the best shot for my client. It's going to have to be there. Did she agree to it essentially just because it was her only option to agree to it, or did she agree to it because she thinks 2 different theories of finding her client guilty is appropriate? Those are 2 different things. I have to imagine she would have objected to the 2 different theories of guilt issue, but since the judge made a ruling on that, all right, well then I'll stipulate to 20.30a because I don't have a choice. So that would be different, and it could be grounds for an appeal.
Mm-hmm.
How much milk does a lawyer get when milking a horse? Not very much. Not very much. Red questions. By the way, if you guys have questions, throw a red question mark up in front of it, super chat me or whatever. And if I miss it, feel free to ask again. I'll try to keep on top of it. How many elements are they considering? So the second one has longer amount of elements. The first one is the involuntary manslaughter, which basically Jennifer caused the death of those 4 students. That is, that the deaths or those individuals died as a result of Jennifer failing to store her firearm and ammunition in a way that prevented Ethan from gaining access to it, and that by failing to do that, she acted grossly negligent. Now, under grossly negligent, there's 3 things that the jury must find that Jennifer did, which is she knew of a danger to another, and she knew that the situation required ordinary care to prevent, that the ordinary care would have been sufficient to avoid the danger, and that she failed to exercise that ordinary care to prevent the injury. So that's the first one. Then the second one is that she had a duty to act, or she had a legal duty to prevent or to control Ethan rather, and prevent him from causing intentional harm to others. In order to prove that, they need to establish that she knew or had reason to know of her ability to control the child, that she knew of the necessity and an opportunity to exercise that control, that she knew of the facts that gave rise to her duty, and that she failed to perform that duty, and as a result, there was a death. So the other one has many more factors, but essentially the same kind of thing. Also, because there is a gross negligent component, there is still these 3 additional factors under gross negligence that need to be proven as well. Essentially, she knew of the danger, and that it required ordinary care to prevent, that the ordinary care was actually exercisable, and that she failed to do so. And we lost Jamie, but that's okay. So,
She'll be back. She had a thing to do.
And Watermelon, I don't think that any jury knows what jury nullification is. It's just something that
Unless there happens to be somebody playing coy on the jury, yes.
yeah, unless someone watched the Brooks trial, they don't know that
Well,
word.
I engaged in it when I was on the jury 20 some years ago, but I didn't know what it was. I didn't know what it was called. I didn't know it was a thing. I just said, listen, this guy's walking down the street. It could be any one of us, getting stopped and accosted by a cop and manhandled and all this stuff. No, I think that's BS. However, once you're under arrest and you're in the cop car, maybe don't kick out the window. So we found him guilty of kicking out the window and nothing. We acquitted him on the other charges. But I didn't know that was jury nullification. I just said this seems dumb.
But I don't know. So jury nullification, isn't that just that you just throw it out? So, well, the law doesn't kind of abide to this one because
Sean actually has a really good example of the jury nullification we went over.
Yeah, I mean, it's not even that the law just doesn't apply. It's just we don't think this should be done. It's not even that the law doesn't apply. It's just nobody likes, we don't want to use the law in the situation. Like one of the ones is Gary Plauché. He's the guy famously. His child was molested, and the guy fled the state, and then when they were bringing him back to the airport, So the jury didn't want to convict him, but the court said you have to. And, he ended up getting probation out of it, which is basically the court nullified it to an extent, but he had to be like the jury was told they have to convict. And in reality, they could have just said, nope, not guilty.
Yeah, because that's when the level I'm on in the Danish court system, we are only 2 laymen and 1 judge. And we do the sentencing and the verdict and all of that together. But we can just say not guilty. We have a democracy system. So if 2 of us agrees, we overrule the third one. We don't have to agree. So we can just say, well, we don't find him guilty. And even if the judge saying, well, clearly the law says he's guilty. Well, we don't find it. It's not jury nullification, but it's just that, well, we don't find that they proved it. And you can do that. But then they'll probably appeal it from the state if we did that. But it's a different, because we're only 3 people in the room trying to get in accordance with each other. And
it doesn't have to be unanimous, right?
No, it's a majority rule.
Okay.
And everyone has 1. It's not like the judge has 2 votes. On the next level, you have 6 laymen and 3 judges, and the judges have 2 votes in that one. So
my understanding is that if she's found not guilty, sorry, just to answer this question, that she's going to have to still go back to the jail to get processed out, but she'll go home today.
Oh yeah, no, she would get released. Yeah, but she has to go back. They have to take her and dress her out and stuff.
Yeah.
But yeah, she gets cut out right away. Like they can't jerk it around. But yeah, she gets to be a free woman. Although we talked about this, how free are you really at this point?
Yeah, she has no house. She has no husband. She has no kids. She has no income. She has no friends. She has
no life.
no
Nobody's
money.
going to want to be her friend.
Will Megan take her in?
Well, Megan and her mom probably would, actually. Now that you mention it.
I was going to say she has at least one friend.
That's true.
And the thing is, if they lose here, what I could see them doing is offering her immunity, because she could still assert the 5th. But if they offer immunity, complete immunity at that point, they could use her to testify against James. And number 2, they're going to go full tilt after James. They will push every limit. They will bend every rule to get him, because
and that's why I think
if they get goose egged on both of these,
that's why I think the gag order that's why I think the gag order, they still have jurisdiction over that, because she would then be a witness in James's case.
Right? What would they offer immunity on? Anything, everything. I mean,
but if she's found not guilty,
it doesn't matter. I'll offer you immunity for any and other crimes that may revolve from your testimony in this matter.
Yeah, who knows what she's going to testify to? There could be a lot of other stuff.
Threaten her with other charges and then offer her immunity for it.
The point is, I'd be offering you complete immunity, so it doesn't matter what it like. Because I have the 5th Amendment right, no matter what. Okay, well, I'm granting you immunity. At that point, it doesn't matter. I might not even be planning to prosecute you. Now you have no longer your 5th Amendment right. is no longer an issue because, Your Honor, we promised not to
Okay.
prosecute her, so they could force her to talk.
And the thing is you
Okay.
don't know, the state might not
Yeah.
necessarily know what your potential guilty liability is. You're just
Yeah.
concerned about it. And the potential immunity could, or
Can
the
you deny
immunity would,
it?
could you deny the immunity?
Yeah,
not-
that's
What do you
Ken
mean?
asked.
What do you
Could
mean?
you
could
say,
we
no, I'm
deny
not going to
what?
accept your immunity offer, and I'm
That
still
doesn't.
gonna pay
That
the
generally
fee?
doesn't work because you're giving them like you can't turn down a agreement not to be prosecuted. Like the prosecutor saying, "I'm agreeing not to prosecute you,"
Yeah.
pretty much.
So yes, gross negligence is required for both theories of the case. But the second one, so the first one I think was dispensed with the second jury question. The first one was that the storing of the firearms and the ammunition was grossly negligent. But I think the jury question the second jury question, which is, can we infer from evidence and witnesses that the prosecutor did not bring regarding how he got the gun? I think that leads me to believe that the first theory is an acquittal, is a not guilty. The second one, however, involves a lot more knowledge and a lot more evidence and hoops that the state has to jump through. So I think, like Sean said, I think the state is not going to be happy with that question because it basically says their whole first theory is out the window, which is the easier one to prove, because all you have to do is say, oh, well, she was grossly negligent in the way that she stored the firearm and the ammunition. And then you got it.
Yeah.
Define ordinary care.
privilege.
Ordinary care is what a reasonable person standard is.
And what's a reasonable person?
What the jury says.
Yeah.
And people are asking for spousal privilege.
Spousal privilege applies, but
You said apparently
not
it
to
doesn't
this.
count much in Michigan.
It doesn't really count much in Michigan. There's so many exceptions to it.
But as Kicks ask, if you go up there and say, well, I did it. He did. Well, my husband didn't know anything. I gave him. I wrote a little note. Go have fun, pew-pewing all over school. My
That's
husband.
why
didn't know.
you get the blanket immunity, because presumably that would also cover perjury, right?
Well,
Yeah,
I think
exactly.
but I think the perjury would be conditioned on like truthfully testifying.
That's
Yeah,
true.
that's Kayla Montgomery has that. She got like a reduced sentence if she would testify truthfully against her husband in the 2 trials against him. So, but she still got 3 years for perjury in front
Well,
of
I think the
grand jury.
judge could also impose contempt proceedings
Yeah.
for perjury.
But then but that'd look bad on this judge. She's already kind of.
Yeah. Yep. If it's a hung jury, she's back in jail. They're not going to give her bond, and then they'll give the state, whatever, a couple of days to file new charges.
Yeah.
Will the ATF agent arrest her if she's found? Well, that's the thing too, is there could be potential federal charges.
I'm not sure what the federal charges would be, though.
Well, are you allowed to freely hand around your firearm if it's only registered in one person's name? I don't know. I'm not a gun expert.
Yeah, there's no rule on that as far as like I can, I filled out a 4473, but they haven't done anything illegal under federal law. You might, the idea that as far as like straw purchasing goes, that's actually not, this isn't that bad as far as that's concerned. So
the only thing I got for the ammunition is that it was placed somewhere different than the firearm. That's all I know. I can't remember exactly where they said it was. I distinctly remember them saying in the police interrogation that it was stored separately from the firearm. But if it was in a drawer or something, I can't remember. I don't remember hearing anything like that. It's not a community state, therefore, how was it her gun if James bought it? Well, anything acquired during a marriage is considered communal property, or property of the marital estate, if you want to look at it that way. But that's usually just for divorce proceedings, not legal ownership. However, possession is 9/10 of the law, right, Sean?
What's that?
I said possession is 9/10 of the law.
Well, there's
It's not
that,
a
but it's
title of
also
property.
There's also an issue of what counts as possession. Well, possession's pretty, possession doesn't mean just legal ownership, but also like dominion over it and control over it. So there's more than one way to establish possession.
My very first trial ever at the prosecutor's office.
I don't know. Can you guys hear me?
Yeah, no, we can hear you.
Yeah.
No, I was just gonna go off of that. My very first prosecution ever at the prosecutor's office was a bench trial in front of Judge Brennan out of Livingston County. Someone was talking about her earlier. And I hated this. Is what I started feeling slimy as a prosecutor. It was my very first trial. And the young lady that was being tried for minor in possession of alcohol was in the passenger of her boyfriend's vehicle. He picked her up. He drove to the store. He went in. She stayed in the car. He bought Mike's Hard Lemonade with his money, put it in the back seat of the car, and then headed towards a party. They got pulled over. He was charged with minor in possession, and she was charged with minor in possession. And the theory is because at any time she could reach around behind the back seat and manipulate and or exercise control over that Mike's Hard Lemonade. Mm-hmm. Therefore, she was in possession of it.
Yes.
And she got convicted.
Mm-hmm.
Because I did my job. But those are the kind of charges I hate. Those are dumb. She didn't buy it. She didn't drink it. She didn't carry it. She didn't touch it.
Accused the cop of grape. And then when he said, well, you have the equipment, you could have done it.
Mm-hmm. Yeah, no. So that's how Michigan law recognizes possession.
But that's a lot of states recognize that. Yeah, a lot of states do it that way.
If you can exercise control over it, then you are in possession of it. I think it's good for the defense. The way the question was phrased, I think is good for the defense. And can we infer from the evidence and witnesses that the prosecution did not bring specifically the shooter and other people who could say specifically how he got the gun? And I think that's what they're leading to is we don't know how he got the gun, and the state didn't call any witnesses to tell us how we got the gun.
Yeah.
So can we infer from that? And the judge's answer was no, you can't. Which I liked. I like that answer, and I think that dispenses with the first theory. We already talked about this. Sort of, kind of, but not really.
Yeah, you have super chat.
I have a super chat? I'm way behind.
Kingsley Damocles. Oh, I shouldn't have said it. Now I want to hear you say it.
Kingslayer Damocles. Could you, for a $5 super chat, thank you very much. Could you say we don't trust the prosecutor to honor their side of the immunity agreement? I've never dealt with immunity agreements, and I have never dealt with a situation, obviously, therefore, that where the state had violated that. Sean, have you? You know what the penalty would be if they try to charge anyways? Would it be just an immediate dismissal?
Well, I mean, it depends. You'd be able to say like, no, we have an immunity agreement where, you'd bring that up as a defense. I'd argue an affirmative defense
kind of style.
Yeah, I mean that's how I would argue it.
Yeah. Let's see. What were the factors in deciding that Jennifer trial before James? I don't know, honestly. I thought that Jennifer's case was most likely ready to go, and James maybe still had some loose ends to tie up. Would be the decision, but honestly, I don't know how the decision was made. What's the court's time now? They have been, 5 hours. 5 hours and 2 questions.
Yeah, well, now we're into that gray zone. The first 2 hours is good for the state. The next couple of hours is good for the defense, and after that, isn't that normally how we go up till 4 hours, and then after that, it's the Wild West.
I mean, the longer it goes, the better generally. So.
Well, yeah. I wouldn't say that because I was covering the fourth trial against Carol Rintala, where they went for 35 hours, switched 2 jurors, which I don't understand. You can switch 2 jurors during the trial, and they had to go back and pretend they didn't discuss it for 3 days before that.
Yeah,
and that was such BS. And then they agreed to a lesser included. So, but that's better than going away for life. But
Why
still,
did they switch out the jurors?
Yeah, because I don't know.
Wasn't one like had to go back to work or something? It was something stupid.
I don't even think it was just oh, we need to bring in 2 of the alternates, and then they was instructed again that they had to go back and don't and pretend they hadn't discussed it for 3 days, and that you can always put the toothpaste back in the tube, as they said in the Courtney Clinic case. No, it's the other way. You can't. That's the way they said it.
Why is it good that the judge answered no to the second question? I think it's good because I think the whole issue of how did Ethan get the gun is a fundamental issue with especially the first theory of the case. And if the state failed to produce a witness that could say definitively how Ethan got the gun, and the jury is asking the question, can we infer, and the judge says no to that, then you can't. You have to stick with the evidence presented, right? That's what I'm thinking. What do you think, Sean?
I mean, I think that's where they're at, and I think the big thing is if that really does come out to be the clincher, then they're screwed with James because they can't bring it in otherwise.
Yeah.
Yeah, and if that's something, if let's say a couple of people in there sitting and say, but do we know how he got access to the gun? We know the other two guns were locked away. Do we have any idea if this gun was locked away? No, we don't know, because we found the gun case, and we were only told it was on the bed by the guy who arrived after they found it. So we don't know.
He wasn't able to testify as to how he found it because there was a bunch of objections because he never found it. I don't think they called any officer that said exactly how they found it.
Yeah, they only found it they only talked about when they found it when they were searching the house, but that was after someone else had already tossed it.
Yeah.
Yeah, it was on the bed. But did you find it? Well, I arrived later. Wasn't my job. Someone else's job. Whose job? I don't know. I work for the government. It's not mine.
Yeah.
So that's why I think it would be a good thing for the defense that they are talking about. Have we even been proven that she gave him the gun, or they gave him the gun by a careless act?
Knowing what came in on this trial, what I'm working on is finding a way to present the defense without calling James to the stand. That's the biggest thing that I'm working on right now. Just because Jennifer said so many things that could potentially incriminate James, I would definitely not want him on the stand. So if I can present evidence any other way, and that would include potentially even Jennifer if she's not pleading the fifth. I don't know. Sean, what are your thoughts?
Well, I'm sorry, what was that question?
The question is having heard Jennifer's case, is there anything that you'd be working on with regard to James's defense?
I mean, well, now you know a bunch of answers. I mean, that's the good thing. These guys are locked in.
Yeah.
Like that's the best part about it.
That is the best part about it. But I think the only thing that I'd be really focusing on is a way to keep James off the stand.
Oh, yeah. I mean, yes, I think so. I think so at this point.
So I went over this earlier. Each count is 15 years max. And there's been some confusion in the mainstream media regarding consecutive and concurrent sentencings. Now, Michigan has both available, but the primary default is consecutive sentences, which means that she would serve all 15 at the same time. There are some exceptions. Some exceptions of mandatory concurrent sentences are for charges that she's not facing. And the discretionary ones are, again, for charges that she's not facing. So this should be a consecutive, meaning she'll serve all of her terms at the same time, and the most she'll ever spend is 15 years plus time served, or minus time served, rather. So that's where we are with that. Let's see. What is the likelihood this precedent will be used against? Oh, she doesn't even have to be convicted. She could be acquitted, and they'll still try to use this. They will try to use this until it sticks with someone going forward. And other states will start using it too. The mere fact that she was charged leads to other prosecutors wanting to try this. So this is not going away until we get someone some poor soul that's convicted, and then we get a Court of Appeals ruling or a Supreme Court ruling that says, no, you can't do this. But someone's going to have to be convicted before, and then the Court of Appeals is going to have to overturn it. Before this really sort of dies down a bit. Let's see.
Thoughts on Courtney Clenny? She's got a hell of an arm. If she can put that kind of knife 6 inches into his chest in a distance of 10 feet, she got a hell of an arm. She should join the circus.
Didn't she get new charges?
Yeah, she got a 3rd-degree felony for tampering with an
Evidence
electronic
tampering.
device.
Yeah, her and her parents.
What were they tampering?
Apparently,
they stole his laptop.
Well, they removed it from the crime scene after the crime scene was released.
Yeah, and they spent time trying to get into it, and no, they took it. They took it in kind of the police never got it, and the police definitely wanted it. They started these iCloud messages with the mom and dad, but also her defense team. So all 4 attorneys were involved talking about this. Ooh. So the attorneys have some problems themselves because they list out the names of 4 individuals, and those are one of them's her attorney and the legal team. They have, we're like, we can't get it open. What do we do? Go talk to Courtney, ask her what she thinks the passwords are. They finally crack it. And then there's text messages from mom saying she's dropping it off to the attorney who came out to Texas. Yeah, it's not a good look for them.
Oh boy. No kidding.
And that hearing was there's so much bad blood between the state and the defense. Oh my God, they didn't like each other. They you could tell those it was like someone had dated and dropped the other guy. They really hated each other. And but I love that TMC was making a totally unbiased docu-series about Courtney Clenny, because that's the state's claim was, well, we're just cooperating with TMC because they want to do an unbiased docu-series. Yeah, TMC is known for their unbiased reporting.
Yeah.
Do I think Michigan will change the laws?
The state was doing that?
What?
The state was doing that?
No, defense.
Oh, okay. I thought you said the state. I was like,
Yeah,
when's
the
her trial
set
set to go?
It was set to go this month.
Nearly?
Yeah, I think so. It was set the end of the month, I thought.
Yeah,
that'll be interesting. Do you think they'll show Jody Arias like photographs and videos?
Yeah,
you can find them in the Discord if they do.
They have ruled on that because I think that was it in December they had a hearing about her X-rated stuff that the defense wanted it kept out, but I think he participated in some of it.
I think her X-rated stuff is already in my Discord. I think Salvador put it in there already. Do you think Michigan will change its laws regarding shooting ranges like only 18? No, absolutely not. Well, first of all, they already have a law that you need to be, if you're a minor, you need to be accompanied by a parent. But do you know how much money the DNR, Department of Natural Resources, makes off of children hunting?
Yeah, I mean, that's another thing. Like, there's nothing wrong with children being on a range. Like, that would be, So
yeah. No, there's way too much money the state's going to lose.
There's also a Second Amendment right to be exercised, among other things. And also, if you're a private range and you do that, you're basically, people will quit coming there because they'll say you're, anti-Second Amendment. So that would take care of that.
Yeah, no, that's not going to happen. The state cannot appeal if she's acquitted. Nope. It's done and over with.
But if it's a hung jury, they can retry her, right?
Oh yeah, absolutely. Now I'm
Mrs.
thinking,
T, was he though? Jamie brought up a good point today. If he was really crying out for help, like they're claiming, why didn't he say something when they had that meeting that morning?
well, more proof that he wasn't telling his parents the whole truth, right?
Yeah.
That's what I'm saying. Because I was talking about a lot of platforms and people saying, but he was crying out for help. He was writing on that paper crying out for help. And I said, if he was such in dire need of help, when he got brought down to the counselor's office, why did he not say anything? Why did he not say,
Yeah.
I've been trying to get help from my parents and they won't help me. Somebody help me. Why didn't he do that? Because he lied. He said nothing was wrong.
I need to talk to the boy for a minute, so I'll be right back.
But that's just my like point of view.
No, just silence.
Can you even hear me? Did you hear me?
Yeah, I can clearly hear you.
Oh.
Everyone's just sitting here. But
Yeah, I know. Like everyone got quiet. I was like, is it me? But yeah, like he could have cried out for help to the counselors. He could have cried out help to, it's not just on his parents to be like, they were the only ones. He was in that office that day. He could have said, these voices that I'm hearing and all these bad things that are happening in my mind. I need help.
Judge is back and Davis gone.
Of course he is.
Is there anything on Twitter? I'm blocked, so I can't see it.
No, I haven't gotten any
I
messages.
don't know.
Not sure if you saw it, but Detroit Free Press posted breakdown of juries selected and bios just so we know 100% which one are in, I guess. DR is Foreman. Doctor
Where
is
do you see
Foreman.
the judges back? Because I don't see anything.
In chat.
Oh,
People
no,
are just
it's
being smart. Judge is always back in chat.
Chat lies. Yeah.
I was gonna say,
I trust chat more than I trust Farrell.
The judge is
Why?
always back.
Look, right there. Now I'm trolling.
Yep.
Well, I still believe him. It's like it's 5 o'clock somewhere. Judge is back somewhere. He could have gone to school counselor on his own. Yeah, and comment. Yeah, I know it's from Bricadas chat. Yeah, but we normally don't see it over here. It's because all of the new people are. It's the jokesters.
Mm-hmm.
Why is Baker muted? Baker's not muted.
He's gonna get your. They're gonna troll you now for the rest of the day because
You
you're
don't
so
you don't
gullible.
trust chat anymore?
I trust chat 100%. So
Except Mass.
well, he's from Sjælland, so I know he's part Swedish.
I'm just like bothered by that. That's one of the points I was thinking about since I've been watching the trial. Is like people will be like, "But he was crying out for help." Okay, well, he had multiple people and talking to him, and he said nothing to nobody. He was choosing to do what he wanted to do that day, and I don't think anybody was going to stop him.
Yeah, I think he was going to put in work, and there was nothing you could do about it.
Yep. And even when you see the, I don't know what it was. I don't know if it was from the Miller hearing or it was from like when he was sentenced or whatever, but Ethan made a statement where he claimed nobody made me do anything. I did it on my own. My parents.
Yeah, but that wasn't able to come in because you pled the fifth.
I know, but I'm just saying, like, I saw that myself and I was like, oh, okay, well.
Yeah.
I don't trust chat anymore, but Baker Lynn says jury has another question.
You better hope she's not trolling you. I don't.
She probably is, and I'm blonde and I'm stupid, so I can just see now the Montgomery case is just, oh, Baker, judge is back. Baker,
it's great when you see people in law and crime saying not guilty verdict is coming soon and all this stuff. Well, they also say OJ was innocent, so.
I'm surprised law and crime isn't like OJ needs to hang for what happened.
They're just all over the place.
But funny enough, if you follow Law and Cock, most of the time they hit the jury better than we do, but it's because it's just wine moms who sit around for 6 hours and then yell everyone's. I love the time when they said the defense lawyer should just sit down because you shouldn't be allowed to have a defense when you're clearly guilty.
Well,
that's kind of like against
that's what
the
wine moms
Constitution.
do.
That's Baker's favorite comment. They said, and he always, I'm like, it's ridiculous because they're like, you just need to sit down. He's guilty. It's like, oh, okay,
Yeah.
I'm sorry. I'm sorry. I'm
Why
trying
are
to
we
defend
wasting
my
time on
client.
this?
Yeah.
Law and C word is saying it looks like another question. I was going to pull up their chat, but it looks like we might have another question going on here.
You need to. I was gonna say
Cover
I have a StreamYard. I have a custom one set up where it blocks out.
Oh, yeah.
Yeah.
Yeah, I don't usually use them for this one in particular.
okay,
If
well.
I do, I have this one, I have this one, and I have this one. They're all over the place. Just in case if I need to block somebody out. But the camera's shaking a lot. It's usually a sign of something to come.
Oh, maybe it's just an earthquake.
Well, we get those in Michigan all the time, so.
I know.
Yeah.
So much.
3 questions
Sure you
to
have another
reach a
question?
reasonable doubt. Yeah, that could be it.
I don't see
I'm just
anything
looking
about a
here.
question. So
I don't either. Usually it would pop up on click on Detroit.
Sarah Rayner has a super chat.
Tara, with the toonie, Canadian toonie, this is making me feel sick. She shouldn't be here. Yeah, I know. I'm getting a little frustrated with this process now.
mhm.
And
Should she get her job back? Probably not. Probably not, since her former employer testified against her.
Yeah.
No,
Well, I
you-
mean, he's gonna want to hire. Like she's not entitled to it back. And then he's gonna hire. If he does that, he's hiring a hated person in the community. So I doubt he's taking her back.
She's gonna have
But-
to like literally.
But can she
move out
sue
of
him for
Michigan.
wrongful termination? Because if he's
No.
innocent. No.
No, I can fire you for any reason. I think you're a bad guy. I think you did something bad. Okay, well, turns out I was wrong. Oops. As long as it's not an illegal discriminatory reason, nope, it's perfectly legal.
Sorry, as long as
I
it's
can
not
fire.
based
I
on
can,
food.
yeah, I can fire because she's bringing bad PR to me. It doesn't
Yep.
look good. I don't like her anymore. I don't like what happened.
I don't like the color of the shoes she wore
Yeah.
the last time she was at work. As long as it's not for gender, religion,
Illegal
race,
discriminatory reasons. Yeah.
those sort of things. Outside of
Yeah.
that, no. Or retaliation for something.
Yeah.
Whistleblower statute and things like that.
Yeah. Isn't it like
Yeah.
at will employment or something? I mean,
Yep.
that's
Yep.
really what
That's what it's
everywhere
called.
is.
You are at will as well as your employer.
Yep.
So,
So was the employee in the WWE.
yeah, too bad there's not like a Family Medical Leave Act for wrongfully incarcerated. No one will want to hire her. I wouldn't want to hire her, but not because of her charges.
She's really gonna have to leave the state, to be honest with you. I feel like she's never.
Supposedly she's got family in Florida, but I don't know if that's James's family or if that's her family, but there's some sort of connection in Florida. That's one of the things that was argued by the state when they wanted to keep her without bond was she's got family in Florida. They can flee to there, but that might have been James.
That's true. It sounded like James, but I could be wrong too. Yeah.
Can we get a Vince McMahon? Yes. From Sean?
Yes. Yes.
Did you read his complaint, by the way?
I
Oh my
read, I
God.
read the whole thing, and when it got to, I didn't normally like the just the basic points. I didn't talk to that, but with the Vince text messages, I did them. I tried to do them in Vince voice, it wasn't like Vince McMahon. I did him as Chairman McMahon, like he's on the stage.
God.
That's great. That complaint is
I about
horrible.
lost my voice.
That could
Oh,
put
I
him to sleep.
I think it's a shakedown, because if this is it's the worst case of human trafficking ever, where the traffickee is like, wait, am I going to get my promotion still? Like,
Yeah. Yeah, it's
and
not
also,
human trafficking. I don't like
yeah.
that idea, but I don't like the facts of the case.
Yeah. Also, she's like well into her 30s, and this is like her first job ever.
Yeah.
Like, there's so much of this doesn't make any sense.
Yeah, but how stupid can you be as Vince McMahon? It's some girl who lives in my apartment, and some guy said, "Could you?" Yeah, I'm gonna make her. He
No,
has
because
some
this
of
is
the
what he's
hottest.
done before. It's probably
He
done
has
it
some
like
of the
this
hottest.
before.
Has some of the hottest women working for him on the planet.
Yeah.
And he choose someone who works.
Well, they
Well,
might not be available. I mean, like, think about, like.
Yeah, he had a little problem back with Sable.
Yeah, well, there was that, and you got to worry about Brock Lesnar wanting to break your neck. So you offer him up, Brock Lesnar. Here's this fine young thing, and yeah.
I want to know which wrestler it was.
was Brock.
Who participated. Was it Brock?
It's got to be, because who else would it have been that was trying to sign that was a UFC fighter?
Yeah, that's before CM came back.
Well,
No,
it's not
you
only that,
had,
but CM Punk wasn't like, But yeah, so she's getting like hollowed out by like, and here's the thing. I will say, if Vince McMahon could keep do what he did, he is a sexual tyrannosaur. Like, that is like, I'm bro-fisting that, because how many think about it. He's 75 years old, and that's after decade. And Vince McMahon's up until recently was a pretty jacked guy. He he was very in shape.
Mm-hmm.
So I mean, that's decades of the finest steroids, and
he
could. Well, yeah, he's not using the garbage stuff, and he doesn't have to get drug tested. So he's taken all these steroids. He's been severely injured multiple times. Part of the reason why and it's saying he couldn't get dressed. Yes, he's had crippling elbow, shoulder, and knee injuries. And he could still whip it out and throw it down like the best of them. That's impressive.
Yeah.
I mean,
how late will they stay today? Wait, hang on. Let me get to this question. So the court normally shuts down at 4:30. Everyone's out of the building by 5. The judge apparently has special permission from the sheriff that they will stay there because they act as bailiffs. They'll stay as late as she needs them to be. So
special permission from the sheriff. That's cute. The judge got permission from. I was gonna say, there's no that judge is not like, oh well, thank you, Mr. Sheriff. I'm sure she's we're staying. I mean,
so
no judge who
apparently they'll stay late if need be, but I don't think this is a judge that's inclined to keep them really late.
Yeah, she'll let him go home and eat dinner because then she don't have to pay for it.
Yeah, exactly.
But yeah, I don't understand what's so funny about the whole Vince thing. He's an old guy throwing it down, and she's she be a hoe.
More the phrasing.
Yeah,
it's the way you talk about it, Sean.
it is what it is.
It doesn't even that's what's killing me more than anything.
I mean,
listen, guys, this is serious. He's whipping it out.
He is. That guy's he's slinging wiener, and he's able to do it like that. That's impressive.
And in his 70s,
he's got a massive cuck issue, though. A massive cuck issue.
You have super
chat when you're saying sexual tyrannosaurus.
Yeah, he is. I mean, he's just I wish I was I hope if I can make it to 75, I'm half as virile and fired up as him, because that's he's sprinkling testosterone. He's sprinkling TRT on his Wheaties every day or something.
Lefty with the $5 super chat. It's 2024. We all know how to deal with a boss who tries what Vince allegedly requested from his.
That too. There's always that point. It's well, she's she felt like she had nothing else. It's she had no other job. She hadn't been promised the job. She was mooching off her parents' estate. Let's not act like she was living in her fucking car without any teeth. No, seriously, because they make her sound like that. It's this poor girl getting crapped on, and it's it sounds like she came from a pretty good life when her idea of making a resume was I'm going to go volunteer and not actually work at McDonald's or something. It's
yeah, if you can live in the same building as Vince McMahon, you're probably not there.
Well, they weren't in the same building. It was different.
Yeah, but
It
it
was
was a
the
guy
building
who
manager
knew
knew
him.
Vince.
But again, what do you think the 2000 undisclosed medical bill was? $20,000 undisclosed.
Oh, I'm sure.
That's probably an airbag upgrade.
Nah,
definitely.
maybe an airbag upgrade or something happened downstairs. A little bit of an accident. Somebody got a little too forceful. I could easily.
Aw.
They went full page on her.
Well, or they may have gone, or they may have performed also quickly known as the Major League Baseball team from Boston. I'll leave it at that if you want to Google it.
All right, so I'm asking LNC's chat to put a 1 for
Yeah.
guilty. I spelled it wrong, or put a 2 for not guilty.
Now, what else? What else is there? Yeah, there's just so much that. Although Vince was a dumbass for not paying the NDA.
Oh,
he skipped
yeah.
on that like an idiot. He should have kept paying it.
Yeah, that I read that part. And I was like, oh my God, what an idiot. Why'd you stop?
He's got the money. He's got the money for it, and he didn't do it.
Mm-hmm.
He's a billionaire.
Not guilty, not guilty. She's guilty by association. Okay.
What?
Not guilty. That's a wine mom for you.
I want to be friends with Shannon.
That's the
Where's the one
wine
that says
mom
I
for
want
you.
to be friends with Shannon?
Yeah.
That is the dumbest, most ignorant
No.
comment I've ever heard in my
See,
life.
I want her to
Guilty
get
by
acquitted. I
association.
want her to get
victim too.
acquitted, just so it's like if that happens, go out and buy stock in Libby Glass because there's going to be a lot of wine moms throwing their drinks tonight.
We got a 2. We got another 2. I haven't seen any
Yeah,
ones.
they're
or, like,
right.
any-
She should not have associated with her son.
Yes.
She shouldn't have associated with herself.
No, she should have drowned him in the bathtub, Andrea Yates style.
Jesus Christ.
Oh, here's a 1. There is a 1 in there. What is guilty by association? Somebody asks. Let's see if they answer.
I'm sure there's going to be a brilliant legal standard by
I really want
Carla.
somebody's.
Carla is going to tell us all about it. Let's go, honey. Tell me all about it.
Guilty, guilty, guilty. The parents need to get him counseling, not buy him a bloody gun when he is depressed and begging them.
They bought him a bloody gun, like it came already pre-used. Like that's pretty. Like what's like? Can you get those at a discount? Because I'll buy one.
Right?
They just have to go down a back alley in Chicago. They
I mean, you
my
just like
God.
you pick it up out of the box and you're like looking at it and you're like, there's some like bits of hair stuck to it. And you like flip the gun and they fly off. You're like, okay, now I'll take it.
Do you get those at the Goodwill or something?
Oh, look,
Yeah.
they're diagnosing everyone with mental health disorders. Everyone involved in the case. That's cool.
Okay.
I do know people who own weapons that have been used in like suicides before and stuff.
There's a lot of not guilties for a law and crime check.
That's
Not guilty. Here's a
surprising, too,
guilty.
yeah.
Here's 100% guilty, but then it's flanked on both sides by 2 more not guilties.
Next we're gonna hear you're all been bought by the Jennifer Crumbley paid you off. That's all conspiracy.
My favorite is
You're all in
guilty
her
by
pocket.
association.
Yeah, she paid us off with all her commissary.
All right, we got 50
We got Twinkies
Swedish
for
krona
days.
here. Is the law and crime chat expecting a not guilty verdict? Thank you very much for the super chat, and this is what inspired me pulling this up. So,
Oh my God. Well,
They are pro
guilty by association is my answer. I think that's
They
a
are
winner.
pro state.
let's see here.
You need to go in there
Not
and
guilty
say
if legal eagle defended her.
Legal Eagle defended her.
Not it would be not guilty if legal eagle defended her. That's what
I don't know about that.
he'd be
Legal
in
Eagle,
jail
Legal
along
Eagle would
with
not.
her. If
He would not play well to a jury in rural Michigan.
Would he
No,
have to
he
bring his bookcase with him?
yes,
Well, he'd have to bring his green screen with him. He actually doesn't have a bookcase. I'm pretty sure.
It's a modern day. That bookcase can be green screen. It's all. You can't put a Kindle
I
up
have
there.
a real bookcase. I have real books on my bookcase.
now the guilties are coming out. Help me, nothing guilty, simple. Okay, 100% guilty.
Lawyer, is saying not guilty. Well, then it must be true.
Yeah,
Yeah,
definitely.
I mean, I think it's even if you really don't like this, you have to say not guilty. And I
This is just
didn't listen to
politics.
Peter, but did he say he reluctantly says not guilty, or he's just like they can't meet their burden, or he just disagrees? Because that's where I think there's, for people who are really professional about it, they can say, look, I don't like that she did this, but I just don't think this is right. And that's not guilty. Like, those are the ones I respect more than any, because they're at least admitting, like, yeah, this is BS.
Yeah.
So therefore,
no, and that's why whenever Jamie and I covering cases, we're always saying it's not what we think; it's what do you think the jury thinks? Because we have our clear opinions, but still, the jury is it's made up of the same people watching Law and Crime, and
for the most part,
yeah, because you won't be in a courtroom if you're not guilty. It's how's the conviction rate in the U.S.? 93 point something or 95 point something?
Pretty much.
Yeah,
I believe in Denmark it's 95.7%. So, and we don't have plea deals. So
I was gonna say prison in Denmark sounds pretty nice overall.
I know, right?
I'm not gonna lie.
I should show you our Supermax prison. They have it better than retirement homes.
I was gonna say they get shuffleboard and
No, they get their own TV and they get I think they have like 3 X-rated channels. So
also you get X really?
Yeah,
Wow.
because
your
then,
guard's like, hello, good morning. Would you like eggs this morning?
Yeah, it's
I don't know how do you say Danish? I don't know how you say.
Godmorgen, vil du have æg til morgenmad?
Yeah, it's like oh, read the menu. It's like, no, I'll have the poached eggs this morning. Yes,
Yeah,
sir.
Oh no, I'm on a diet. Can I have the vegan option?
Getting the spinning wheel of death here.
Seriously though, you guys get to watch porn at the gym. Wow.
That
alleviates a lot of issues though. Seriously.
We have a few. I have a few buddies who's prison guards, and they had a female coworker, and her movie came up one night on one of those channels. So she stopped being a prison guard after that.
Do they do conjugal visits in the prisons?
Yeah, because we have the guy, the submarine killer, who unalived the journalist and chopped her in a. He had a big problem. He made it smaller.
Yes.
He's been married like 3 times in prison, I think.
Oh yeah, good for him.
And then you have Peter Lundin, who actually was in prison in the U.S. for murder. I believe he killed his mom in the U.S. and then he came back, killed his girlfriend and her 2 sons. He's been married a hell of a lot of times. These ladies are really, really randy. Oh, talking about a prison guard. Another prison guard was on vacation in Florida when she got a call from the prison saying, "Oh, we found out you lied and visited one of the inmates in our Supermax where the ones who can't be released again are sitting. And you lied and gave them a false name. So the press is calling, and you can call them and tell the story, or we will disavow you 100%. It probably wasn't the most fun flight with her husband and 3 kids back from Florida.
Oh.
So, but
Uh-oh.
that's from F around and found out, and she F'd around and found out that wasn't good. And the stupid thing, because in Denmark, if you work in the prison system, you have a super the pension system is so great, and losing it for effing a criminal, that's so stupid. We had another guy who was paid in hookers for doing stuff for Hells Angels. It's like 1,500 for one of those ladies, and you lose your lifelong pension. I would have sprung for that. You can get a streetwalker for 1,000. So why do that? It's so stupid. But again, maybe it's not the brightest bulbs who gets to be prison guards.
I'm having a hard time with the feed. It seems to be blanking out, and the one with the main feed doesn't seem to be showing anything. So I'm trying to find another feed. So if I seem distracted, that's what's going on.
Okay.
WXYZ is handling the main feed, and they are they have no live feed up. Fox News has a feed up, but it's just a spinning wheel of death.
Oh
and,
no.
Let me see what Ellen Seward has.
Law and Crime just has the wall.
Law, crime law.
Yeah, but theirs was spinning out too for a while.
Crime law with the benevolent dictator Addy in charge.
So I'm gonna get my.
Well, that's how I got my start. I ended up when I first started doing this, the first little group of people I had on my channel that were hanging around. I became like it was because of the Theodore Edgecombe trial. I had like refugees from long crime that got like banned out of their chat and stuff. And they were just like, and they were like nice old ladies, and they're just like, we weren't doing anything, and I was like,
that was my first
welcome.
chat too. Was on Facebook, and they were banned out of some other Facebook groups, and but they came over to mine, and I don't know where they are now. They're not here, I don't think.
Well,
But
yeah, some of my original ones, they ended up moving on and doing their own thing.
Yeah, as it happens. There we go.
Yep.
Yeah, but
you don't think? You haven't checked on them?
Well, I
What?
started streaming back to
I don't-
Facebook again, but there's only like a
I don't
handful
really.
of them in the chat.
Like Critter, if you're out there, Critter,
Well,
Gabby, hope you guys are doing well. If you're out there and you hear this,
I feel
Aww.
like that. I feel like that name sounds familiar too.
what Critterville?
Yeah, Critterville.
Yeah, she's been around.
Emmanuel Resu, yeah, that was the bike guy. Yeah, that was Theodore Edgecombe, the self-defense. He was
Yeah.
wrongfully convicted.
He what?
He was wrongfully convicted. He was clearly trying to get away and de-escalate.
Well,
It was, and the 6 months he had to use to find an attorney. It's just that was clearly because of his skin color.
Yeah. You know what though? I will say honestly though, I don't feel bad about the guy he killed.
Oh, he was probably an a-hole as well, but
Well, he went looking. He went looking for a fight, and it's like that is, you know, he did stupid things in a stupid place. Like he did what I call tard jousting. Some dumbass guy said something as he's riding by on his bike. It's like, you know, don't worry about that guy. But no, instead he's like, no, I gotta go grab my lance, and I have to tilt it towards him. And you know, my good retard, I shall joust you, and I accept your challenge. And he ran right at that retard full speed, like a big old retard, and he got killed over it. So
yeah, and that's again, it's most of the cases we do is it's what's called 244 in Denmark. That's regular violence, and it's the bump Friday night kind of things. It's because you have one guy bumping you, and instead of just walking on, you turn around and say, "Vavido, come on, Vavido, man, you smell that." That's Danish for "What do you want? I'm going to kill you." And
wait, how do you say that again?
Vavido.
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 The Viddle.
Yeah.
So I need to get out the airport. I need to get out the airport in Copenhagen and start screaming that, right?
Yeah, you just go to the nearest taxi station and bump one of the taxi drivers.
Well, no. I thought like as soon as I get out of the air, like I'm in the airport, just start walking up to people and just do that.
Yeah,
they're gonna run you over with their bicycles, though.
Like I get
we don't
probably
ride
run into the
bicycle.
police.
Well, you can actually not a real bicycle, but you have those where you stand on the middle and just scoot along. You can't have those in the airport, but go to Nørrebro and try walking on the bike lane. You will die. They care for no one.
Oh yeah, they absolutely hate me. I'm always in the way.
It's because we have for pedestrians, then we have twice as much for people on bikes and a little lane for cars. Because in Copenhagen, the former Communist Party had a bigger share of the votes last time, so they do everything they can to keep cars out of Copenhagen.
Baker's gonna get so concerned when he gets off the airport in Tennessee, and he's like, "Where's all the bicycles?" He's gonna get scared.
I've been to the US before. I know. My biggest problem is I have to install Uber. Uber is illegal in Denmark, so
oh, really?
I have to figure out how to do that. It's because
illegal.
We have
taxis.
We have a taxi law that to make sure that we have taxis in the rural areas. So we have a taxi law, and then they found out the taxis don't want to ride around in the rural area because no one lives there. So now they're talking about bringing back Uber, but it was made illegal in 2017, I believe, in Denmark, because it interferes with our socialist paradise. So yeah, it's It's a different country, but now it's coming back, maybe. And
if they
you don't
find
wanna ride a
innocent,
taxi.
not foreseeable gross negligence is full and void. What?
null.
Are you
Oh, is that a
still
brother?
reading?
No, if find
David, is that your brother?
who?
Jeff?
Jeff. No,
Jeff Helm.
this is Randy V.
No,
he's
Jeff
looking at-
Helm.
In
He's
chat.
Hi, Peyton. Yes, that's my brother.
Hi, Peyton.
Yeah, everyone say hi to Peyton.
Hi, Peyton.
Leah
And
says
even the
hi
dogs are
too.
saying hi.
Yep.
Yes. Is there really a third jury question, or was that just that was just the chat trolling? That was just the chat trolling. There is no third jury question, at least not yet. At least nothing that I have that indicates that there's a third jury question. We are just waiting, hanging tight, talking whatever, talking Danish. That's what we're doing.
Yes.
So apparently the scuttlebutt is that the judge is sending everyone home at 5. The scuttlebutt. So
Yeah.
the judge is sending
Real
everyone
word.
home at 5, which I didn't think this judge would keep them very late.
It's a bird
What's
from
so funny
the
about it? It's a
Mermaid.
real word.
I know it's a real word, but I don't hear people use it very often. And
I use it all the time, Jamie. Where have you been? Oh yeah, that's right. Streaming with Baker.
you do not say scuttlebutt all the time.
Aw, he's so jealous of her other daddy.
I still adore you.
I know, but
I
don't
wish
say
there
it
was
when
more
David
jury
said it.
questions.
I'm just stuck on that lady saying she's guilty by association. I want to know.
I
where-
know. Reading,
I want to know
watching
your
this,
theory.
and see
Yeah.
the chat. Yeah, I gotta open this up a touch.
Yeah, that's just stupidity. Oh, she's associated to her son. Yeah, then she's guilty.
There we go.
Am
We'll
I?
get it- we'll get the question
I
in there.
probably owe some reparation from that forefather I had who stole from a bank in Denmark and went over to the US and invested in. I believe it was Dodge he invested in, or maybe you owe me reparations. I should get a part of Dodge. Well, it probably went bankrupt a couple of times.
Oh. You had relatives in
320.
Schleswig-Holstein. So the Prussians stole your land.
She's not guilty by association. There we go.
I don't. Did you hear me, Baker?
Yeah, but Prussia always steals stuff, and Swedes as well. Prussia and Sweden stole all of our land. And just because we backed Napoleon, we lost Norway.
Let's see. They're behind the times. They're saying that there's 10 women and 7 men on the jury. No, there are 6 and 6 now.
Hey, 10:32 in Denmark. Hey, Savik, you should watch me instead.
Oh, tell your Denmark friend to stop hanging out in Law and Crime.
I was hanging out and talking to, I believe it was 3 or 4 ladies from Denmark and Law and Cock the other day. We were talking Danish and everyone was going apeshit. English, please. No. Why?
Why? Yeah.
There we go. I'm saying anyone from Denmark needs to get in the MLS where we have real games.
You're real danska.
Rigtige dansker, nemlig.
They're gonna block you now
12:30
after
in
that.
Kalifas.
Yes, we
I
have the
always
real
do that.
Dangeld here.
Yeah. For real coverage,
Some real Danish
real
action.
attorneys, and a Dane
Can't with you.
get into MLS.
It's not his text to speak that messes it up. It's just him.
If you want some of that hot Skagerrak action, come here.
If you want to be oiled up like we gave away all our oil to Norway, come on in.
Let's see if our numbers go up at all. Hey, if you guys are listening and you're coming over from Ellen Seaward, let us know.
Well, let's keep an eye on the numbers. We're
Having
808.
friends is
you
an
ask-
American
Hey,
thing.
there's a
Why don't you ask-
Michigan.
Michigan, USA. Oh,
Yeah.
also, we have Michigan attorneys.
Spell attorneys right, please.
There we go. I got it. I fixed it. My fingers are faster than my brain. Or slower. Whatever works.
Giggity.
They're not in Central Time Zone. We're in Eastern. Oh my God. How do you guys not even know where we are?
Well, they don't care.
They
Yeah,
really
We're
don't.
they don't
talking about
care
absolutely
where you
nothing.
are. They just
They're
want to
guilty
convict
by
you,
association.
David.
Yeah, guilty by. Where's the guilty by association lady? Bring her over here. Let's have a
This one
discussion.
woman doesn't like it when people pull the chat when it's not a mod. Let the mods do that.
What?
This one woman
Ma'am.
says, "Don't pull
Pull
the
the
chat.
chat
Let
again.
the mods do that."
Do it again. Pull the
And
chat,
I'm gonna
David.
do it.
What was her name? Myra? Okay, Myra.
There we go. Guilty hit 1, not guilty hit 2. I'm pulling the chat.
Eddie's gonna come after you so hard. Remember to cover her logo, so she can.
Composer C, 1 or 2 chat. Nice composer. Oh, look at we got
Won't
Fox
be, yeah.
in there. Look at all my chat is in
Aw,
this.
composer.
Yeet it.
Oh, slow-mo mode.
Oh, okay.
Oh my God.
Every time I want to understand the not guilty side of argument, I come here. All right.
What? Somebody said that?
Sure, Jan.
Let's
Do
see.
you really understand the not guilty side? Because they don't really have really good arguments over in LMC.
Help me 2 hours before killing for. I don't think he said help me.
He wrote it on
Oh,
his
on the math
paper.
worksheet.
It's
Yeah. on the
okay.
math
We'll take
worksheet.
your view.
But like I said, he didn't clearly want help. He lied to people. He never said a word.
Well, the prosecutor even said nobody saw this coming. When the prosecutor says that, then they have an issue with their case.
Mm-hmm.
Let's see. Poll was done. Oh, no more polls. Everyone's getting all upset that we're polling in the chat.
Oh, Jesus.
Michigan has 2 time zones. Okay, technically, if you want to talk about the Upper Peninsula, right there near the Wisconsin border. But that's not where we are. We're not even close to that. I hate view is still a view.
You should
Farrell?
go to live chat so you can see. I just wrote a message, but no.
Oh, I thought I was on live chat. Yeah, Miss Baker's message. Did you write it in Danish telling him to get over here?
That's what you should do, because then that'll bring all the Danes over.
Yeah. Baker, say any Danes come over to MLS, but you gotta say it in Danish so that Law and Crime doesn't know what you're saying.
Sneaking around.
David, radio for 1. Awesome. Did you ever have any experience with Sheba in Oakland County? Let's see. Family mem of mine was a victim of a crime, and she was a judge.
In Danish, you got it.
Inmates called her.
He doesn't see it.
Go. No, not really. But I'm awesome. It's awesome that you confirmed, Amy Z, that you are in fact radio for Win. Remember, that's everyone needs to go check out the Detroit Cast. I've been trying to do stuff with Mike Walters, by the way, and he keeps blowing me off. So, Amy, go bug him and say that he needs to get on MLS with me.
You hear that, Amy?
Scroll up.
All right, I'm scrolling. I'm trying to keep track of 2 chats now. This is a pain in the ass. There we go.
Well, everybody's kind of just doing their own thing in here now. Except Mo. Wait, are we drinking? And then she also said, also, you all made me giggle so hard at Walgreens with Swift or Austrian guy I was getting looks.
Nice.
The Swift thing.
LNC banned me during the cruise trial. Oh, poor Bifrons. I don't know what this says, Baker, but I hope it says come on and join us over at MLS. He disappeared on me. Okay.
Did you put he's a smart advocate?
I don't know what he just said.
I said he's a smart lawyer. You should join him instead of sitting here with all these people who don't know the law.
Hey, David, you got somebody from LNC over here.
And then Mass is there
Innocence.
writing in Danish. If you're from the north, you should come over to Making Law Simple. They are super cool. Even, can you pull it down a bit? Can you scroll up so I can read what
Oh yeah,
Mass said about
David.
you?
Exploited Innocence is from Law and Crime. They just came.
Oh,
out.
They're super
Excellent.
cool.
Welcome.
Even if the host is another.
Thanks. I'm glad I got the love from Mads. But welcome. We've got Exploited Innocence. Welcome. I came on over. Well, thank you very much. Yeah, we're just hanging out, waiting for the jury verdict. We've been talking about this case throughout the entire trial. We've been streaming it. Normally, we're not streaming LNC's feed, but we were trolling the chat. So, because sometimes we have fun. What's the mood like over there? Exploited is so we always use Law and C as sort of a barometer, if you will, for what the jury is going to do. And unlike most of the Law and C word chat, this seems to be fairly mixed. So I'm wondering what your thoughts are. What's the vibe over there at Law and Crime?
Yeah,
I
and
feel
where
like
are
if
you
they're
at?
mixed, we're more likely to have a hung jury here.
Mm-hmm.
Tell us who
Yeah,
referred you.
Exploited Innocence needs to let us know, like, what are you thinking on this trial? Where are you at?
Yeah. Oh, I've watched the Detroit feed. It's about 50-50 over there and at LNC. Yeah, see, that's what we're seeing too, about 50-50, which is very interesting. Especially on LNC. They're usually very, very pro prosecution. Well, we even had Coffin Daffer on Twitter, who's former FBI and is always everyone's guilty in her mind. Saying like Jennifer is not guilty for these particular charges. Can Sean read the Vince text about the crew for Jamie?
I don't know if I can handle that today.
Let me see if I can pull up the Vince McMahon complaint. That thing is scary.
Tamery did say, does anyone think EC Ethan is a psychopath if you know the definition? Do you?
I don't know the technical definition. Is Jung here?
No, well, you can't. Isn't that the Goldwater standard? You can't talk about.
Ken is.
Oh, Ken's
Oh,
in
is
here.
Ken here?
Yeah, but
he said
yeah,
he was
just
analyzed by
answered.
several mental health experts who have said he has 0 diagnosable health conditions.
That's what I heard during the Miller hearing.
Yeah, and again, it's the Goldwater rule. You can't really talk about other people's health if you haven't examined them yourself.
Really?
Yeah, that's the Goldwater standard from the president. Wasn't he Goldwater? What's the name of that president where they said he was a psycho or something? And it was brought up multiple times during the JD that as a healthcare, as a mental health professional, you can't talk about diagnosing someone you haven't had a meeting with. You can't, like that Dr. Smeagol who watched Pirates Caribbean and
well, I mean, there's a difference between watching Pirates of the Caribbean and reviewing medical records, right?
Yeah.
Mm-hmm.
That's well.
Did you
Dr.
did you
Smeagol,
say Goldwater?
Yeah, Goldwater. Yeah.
Yeah.
Oh, psychiatrist, not psychologist. Okay.
What page did the text messages start? I didn't read the whole thing. I just read the allegations at the beginning.
Again, I know more about American history than Americans.
I think Sean disappeared for a minute. What's that? Excited?
Exploited has. Excuse me?
I have an issue with the diagram. The parents knowing before coming to school. What happened? Okay. Knowing when they came into school and still not taking Ethan home or asking about the gun before leaving. Yeah, I mean that's a big issue. But if you listen to the counselor's testimony, he was concerned about self-deletion. He was also concerned about Ethan not being left alone and thought that it was fine for him to stay in school because there were people there, other people there. The whole checking of the bag thing, yeah, that's a problem. But the school is the one that had control of it. It was left in the math class. So that's a big issue. Who's dead man walking? Am I missing something? Hello?
Oh, no, we're fine.
Farrell and Baker. Everyone's disappeared on me.
I'm here. I'm trying to read the thing to see.
Yeah, I'm here.
All right. So I don't think Sean's going to do the Vince McMahon reading since. All right. What are you guys talking about?
Oh my god.
There's something going on in the private chat that I'm not going to read right now because I'm already trying to manage 2 chats.
Yeah, I know. You got a lot going on.
Yeah. Welcome everybody new. Let's see. So
Hey,
if
David.
the counselor was truly worried about immediate harm, there are processes to have the kid involuntarily committed. That's the other thing
100%.
is that the issue they were dancing around is removing the child from school. And the counselor was like, well, it would have been disciplinary. I feel like
Not
the
true.
defense counsel failed in the cross-examination. I would have said, in your tenure as a teacher, 20-some years, whatever, have you ever experienced a child leaving school or being sent home from school for a non-disciplinary reason?
Yeah.
And if he said no, he's a liar. And if he said yes,
Yeah.
then we further explore. Okay.
Yeah.
So it's possible that a child is sent home from school for non-disciplinary reasons, right? So then, therefore, it was possible to send Ethan home for a non-disciplinary reason. I would have explored that more, but she failed on that front. But at the end of the day, I don't think they proved that they had prior knowledge. Let's assume that the prior knowledge took place at that school meeting with the math worksheet. Let's assume it happened there. It was an hour and a half before the shooting. Now, what's the reasonable, ordinary care that could have been taken? All right, we removed him from school that day. Who's to say he doesn't do it tomorrow? Right?
Mm-hmm.
So that's the fundamental problem I have with this type of case.
Yeah,
Also,
I did. I literally ran everyone off the panel.
Sorry,
Yeah,
David, I'm back. I'm back.
We have to go make sure the trees are watered. So
Well-
I'll be back later.
Okay, sounds good.
All right.
I'll be here.
No, David, I had to step away. I had a phone call. Sorry about that.
No worries. No,
but yeah, no, I
they
think
were asking if you would read Vince McMahon text messages.
Oh, okay. I mean, if you put them up, we can read. I'm sure. If you want that in here, sure. I mean, that'll be. But no, I think the bigger problem ultimately for this, that person is, did you ever have children who are in crisis, mental health crisis? Because are you telling me that if a kid's in mental health crisis, that's considered disciplinary to give them treatment? Like the kid's just like something happened, they're in crisis. You're like, oh, we can't get them help because that counts as discipline. It's like that is such BS.
Yeah, I absolutely agree.
And that would go exactly to the whole like Mr. ATF agent, do kids lie? Oh, I don't know if I can answer that.
Yeah, I know. He's not an expert, and then the judge calls him out for being shortly out of high school himself.
Yeah.
You've probably answered this, and I missed it, but why is no one from the school being charged? Do they have any kind of immunity from prosecution? Not from prosecution.
No.
The state just chose not to prosecute.
Because it's a bad look for the prosecutor to prosecute a teacher.
Yeah.
But the Crumleys are, and I'll say it like this because it is what it is, they are not popular. They're not popular in the community. They're poor. So there's a reason why this is happening to them and not anybody else.
Yep.
Nobody cares about poor white trash. the educators, they're allowed to roam free.
Yeah, the counselor didn't know he had access to the gun. The parents did. Well, I don't know if the parents knew that he had access to the gun, but the counselor did have an email from the day before, or that morning rather, about the conversation that happened the day before with the other counselor, that Ethan did have a gun, that they went shooting at the range, that he was looking up bullets, that she was concerned about his other prior writings, and that was communicated to the counselor that morning. And he testified that he read it at 8:30 a.m., which was hour and a half, 2 hours before the meeting with the parents.
Well, the other thing too about that whole thing about like, oh, we didn't know, is
they could have done a psychological.
Ultimately, this is 2021. The idea that like you're not thinking kids have guns, your first thought is, does the kid have a gun? Like, there's no way that these counselor didn't immediately think that. So the fact they didn't ask, it's just they just messed up.
Well, the other thing too, as the principal,
I mean, that's where I'm
testified-
going with this.
Well, the principal also testified that a lot of kids in that rural area had guns. There's girls that would dress up for homecoming and take pictures with their guns. There's kids that would go hunting before they came into school in that very school, in that area. That's the principal testifying to that. So the fact that he had a gun and was shooting at a range was not at all anyone's concern.
Well, lots of people lose their dog, lose their grandma, lots of people have loss in their life, and they don't go out and do things like this. It doesn't mean that everybody that loses these things is going to become psychotic.
Well, there's that too,
You know.
yeah. But I just
sorry, I was referring to something in the chat also. Sorry.
Okay. Yeah, I just think they did a and you're right, David. There's so many times you could ask questions where, and this happens a lot when you're dealing with a witness, either they're going to have to agree to your question, or like they're either a liar or they're an idiot, and either way,
yeah,
it doesn't look good. So
right, and that's why I think the defense counsel dropped the ball a little bit with that counselor. She did really good with the principal, but I think she just dropped the ball a couple of times with the counselor. I am late. 4:50 a.m. here. Is the longer the jury out a good thing or a bad thing for Jennifer Crumbley? At this point, I say it's a good thing. But I don't want it to result in a hung jury. I want some definitive answer, because I just don't want this being tried again. And as it stands right now, they're still just deliberating. They have like another hour to go. We'll see if they come back with a verdict before the end of the day, or if we'll be waiting until tomorrow. Sean, can I hire you before I commit a crime? Farrell's asking from the chat for some reason, even though she's on panel.
Just check your text message, Dave.
Text. Oh my God. People are messaging me. Oh, I see. All right.
You didn't even realize it. It was hilarious.
No, I was completely nope. That's why we're talking about dead men walking. All right, so everyone wants you to read apparently this, so we can do that.
I really do.
Let me pull this up.
Oh, I got my method. What's my motivation here? I need my method acting.
What page does this start on? This, by the way, so this is the Vince McMahon.
Down. No. Down. You'll see their Apple text messages.
Oh, okay.
Keep
All right,
going,
that's
keep
what
going,
I didn't
keep
know.
going.
I read through the first like basic.
Oh no, we did the whole thing, all 4.5 hours
so
of it. Yes.
This one.
Yes. Yes.
So this is following the threesome on May 11, 2020. McMahon sent an explicit message to Miss Grant and further detailed his fantasies of seeing her engaged in sexual relations.
Yes, from the chairman. Well, I just want to say real quick, if this ever gets a deposition, I know it won't, but it'd be hilarious to hear Vince McMahon do it. You know, when he kind of like has to give his like panicked answers, like when he's on the show. When he's acting like the chairman, he's getting scared. He's like, "Oh well, I love it. That's you, Janelle. You just can't get enough, can you? In the future, it's gonna be so." I hate how he uses "you" and "be" so much. It's going to be so bad that you'll demand to be. Do you want me to just as is? David?
Yeah, whatever.
Okay. You'll demand to be fucked twice a day and not just with it in a 3-way. Why not just let others see the beautiful, voluptuous body and watch you shake uncontrollably when you come? They'll go out of their minds. Then I'll find more friends and we'll tie you up so you're helpless. I'll direct them to have their way any way they want. Who can make you scream the loudest? Maybe I'll just line them up and have them squirt in your mouth, your pussy, and all over your tits and ass all at the same time. You'll be covered in cum and we'll make you eat it all. It tastes everybody's cum. The next morning you'll be a little sore, but you're still going to want more. After all that fucking over and over, I'll be...
All right.
That
That did it for me.
You know, you're right, Sean. He is a sexual trait of sorts.
After the threesome began,
Oh my
McMahon
God.
became more sadistic, and his fantasies focused on controlling, such as choking, sensory deprivation, pain, humiliation, group scenarios in which Miss Gant was to be
God.
physically overwhelmed and subservient.
The way I read this, even though it's such a boomer way, read your last picture. It's like he wrote it like a memo, and it's like he wrote it in there, but I wrote it out like he was reading it. It's like read your last picture. You need your. I gotta hold the mic like I'm Vince McMahon, and like I'm in the middle of like SmackDown, like I'm on the middle of the stage, like he's doing it like, and you. You
By
need
the way,
your.
Sorry
Okay,
for
go.
anyone coming in. These are text messages that Vince McMahon allegedly sent to Miss Gant as presented in the complaint just recently filed against him.
Yes. Yes. You need your panties ripped off and 3 big black dicks in all 3 holes at the same time. What? Way up your pussy and way up your ass. As far as they will go, but even further. And the thickest cock goes down to your throat, so it makes you gag and convulse as those big black cocks pound away. It feels like from the start you're being assaulted, but it's made you come nonstop. Just one continuous orgasm. And just before you pass out, those big black dicks squirt their loads of cum inside you.
Vince.
Lay on your stomach. The cum is coming out of all your holes. I'll turn over and jack off all over you.
Is he writing a romance novel? Is this like 50
Yeah.
Shades of Grey?
I feel like these are all the dirty books that are out there.
Yes.
Oh my God.
All the dirty books.
Oh my God.
See, and you got to do it. You got to look right into the camera. Just zoom. I wish you could like maximize me and have that off in the corner so I could still read it. And I'd be like, just,
Still not illegal.
yes.
Oh my God.
That's
Oh.
yes.
Yeah, this is not appropriate for children. Sorry.
Yes.
We're still waiting.
Well,
We're still
neither
waiting
was
on the court.
what Ethan did was neither appropriate for children too.
Well, yeah.
This narrate like this in court. We need to know.
I wish. Your Honor, my client is not guilty. He did not stick all of it. He did not stick his cock all the way down that woman's throat. Just barely. She got to savor the flavor, Judge. Therefore, we ask to dismiss all charges.
I hope. I mean, does he have a lawyer that's just like him? That would be just so much fun.
Probably. A lot of times people like him get lawyers who are just like them.
Yes.
Yeah, I was
I
looking
hope
down. I
so.
was looking away as the reading was taking place.
Yeah.
That's so bad, though. That's so bad.
That's why I want Vince McMahon to do 50 Shades of Grey like a dirty book. It'd be great.
Yeah, but it's got to be an audio book.
More black dicks. More.
This is so bad. So the allegation. This is a 30-year-old woman. That was the thing with the age.
30
I thought this-
something.
Yeah, I thought there was like an 18-year-old, 17-year-old. Yeah, she's 30
No. This is a grown ass woman.
Well,
Wait, this isn't family appropriate. Yeah, no.
I like Ken.
Good. Your kids will learn a lot.
This is what happened to invite Sean on your stream.
This This isn't
Yes.
a family appropriate.
No.
I've been using this to teach
Yes.
my fourth
Now
grade
we talk about the
civics class
globalists.
today.
Somebody's talking about Alex Jones. Yes. Let me tell you about the globalists.
So what happens when we have 7.5 hours of downtime? Hey,
Yeah,
MG.
it's-
Oh,
Hi, MG.
I think I need a cigarette.
I
Well,
know, right?
I need to go get a drink right now because my throat hurts. Janelle said that too, by the way.
Sean, I can't with you.
Oh, that was great.
So I'll be
Hey,
right
MG,
back.
have you been watching I know you've been chatting a lot. Have you been watching the whole trial?
I have not watched any of the trial.
No? Oh, okay.
No. I it's been crazy busy at work, and so in fact I just got out of court and am headed home. So
Did you present your case like Sean just did in court?
I wish that'd have been great. That'd have got me thrown in jail.
Everyone, MG has a channel. He is an attorney in Oklahoma where the winds go sweeping down the plains. So go check him out. I'm putting him in the description.
Yep, I think I'm going to start rewatching the Edgecombe trial since you love Borowski so much.
Oh, God, that judge. I hate that judge. He's so
he was great. He was great.
I know you guys love him. I'm just imagining being in front of him, and I'd be in contempt.
Yeah, I was gonna say, MG, do you feel that way too? Like Dave does? Dave talks about
like
more like being in front of him, like having to be in front of them.
But you learn what sets the judge off and what doesn't. So
yeah,
it's true.
Yeah, you know how you learn the proper decorum for his court.
A friend messaged
the other
me
side,
and said we went.
and the defense
MLS.
did not.
Yeah,
they messed up.
Wait, is this the right one? Yeah. Okay. I keep seeing heads popping up, so now I'm getting curious. Do we have noise? I'm hoping for something here.
Even though MG hasn't watched a second of the trial, he's got some good insight. I will say.
What are your insights?
Well, it's not that this case should never have been brought.
Well, yeah. I think we're all there.
I mean,
no, but like to just say it outright without even watching it.
The whole control thing. I mean, to me, I would think the statute was written for parents who are in the presence of their children to exercise reasonable, ability to control their children to keep them from hurting someone else. And once your kid is, especially a teenager, is not in your presence, you don't have any control, and you really can't exercise control, no matter what you want to do. So,
well, that's the idea. I always say, so imagine you invited somebody into your home, and while they were there, they stole your firearm and then went and committed a crime. Would you be held responsible? Yeah. Everyone's going to say no, of course not. So now you have a 15-year-old.
But with this case, you could. If you didn't have it locked away, you just have it sitting on the shelf, and even they had it locked away. So.
If she is found innocent, will she have a case against the state? She has 2 potential civil actions against the state. That would be wrongful prosecution and abusive process. But that she'd have to be fully acquitted on. And
you were saying earlier they're creating law with this case, and I don't think you should be. You should be creating criminal law in court. It should be through statute.
Yeah.
If you wanted this to be a crime, you have the legislature who should pass it in a statute, and the governor sign it and make it law. Otherwise, you don't have a case. You shouldn't be bastardizing a civil jury instruction to apply it in this case.
Yeah.
Jury has been deliberating for 6 hours. This is what happens when we do a jury verdict watch. We entertain ourselves. With Sean reading Vince McMahon text. That was so bad. That was so bad.
That was great.
Where'd it go? I lost it now. Oh man, I accidentally shut it down. No, but Vince McMahon is either the worst person in the world or this woman is. That's the only way to balance that out.
Did they force her to go to work for him and sign and work there? From what I could tell, she kind of knew what she was getting into. Not to condone what the guy did if he did it, but
Oh, I have
it's
no
not
doubt
like
it
They were
happened.
shy about why she was being hired.
Well,
Yeah,
I
no.
have
She
no
knew.
doubt it happened. She knew what she was getting into.
Still doesn't make it legal though. Still.
No.
But my husband changed his practice as a dean after we spoke about this trial today. He separated child from belongings, searched backpacks, and found ammo. Thank you very much for the $4.99 super chat. Yeah, that's the thing is I think a lot of schools are changing their practices as a result of that, but it still doesn't mean that the parents are guilty.
Yeah.
So let's assume they found the gun. What are the parents guilty of anything then? He stole it, obviously,
Yeah.
or not obviously, but let's assume he stole it, right? Are the parents then guilty? There's a lot
unless
of
the
things
parents
here that I have a problem with.
watched him put the gun in the bag or put it in the bag themselves.
Am I doing another trial after this? I don't know. We have James coming up in March. We'll see. Because we have Courtney Clenny coming up. We have a bunch of other trials. Nope, there's no verdict yet. Not that I'm aware of.
Yeah, we got Karen
No, I-
Reed, Courtney Clenny, Adam Montgomery.
We have so many trials.
There's so many. James.
No, and she should have known. Should I put up another poll? Because now we have.
No. Why? How should she have known? If you don't
Because
know,
she's
you
a
don't
mom.
know.
Moms know.
I guess. I don't know.
Yeah.
Karen Reed in March.
Yeah.
Is that actually going to happen in March?
Well, I mean, we'll
Wonder when we'll
see.
have Turtle Boy. Oh, what happened to MG? MG died out.
Oh.
I think he was on the road. He'll be back.
Yeah.
What if he unalived himself? I would say there could be more of a potential cause of action if he unalived himself than this particular case. One, they had a possible resolution or a possible heads up about that from the counselor. And two, I mean, I don't know if it wouldn't be involuntary manslaughter if he unalived himself. I still think there need to be more facts, but you could probably, or maybe even get, at least the law works for neglect of a child. Child neglect.
And
what are the mandatory reporting requirements for this? That school?
Well, that's the other thing too. If he had a sincere belief, he would have had. He is a mandatory reporter, so he would have had to report something. And to my knowledge, he didn't. So, James's trial is in March 6th, or something along those lines. March 3rd, 6th. I can't remember exactly when it is, but that's when it's scheduled for. Early March. February 15th is the next date for Karen Reed. Trying to sanction
yeah,
the
that
DA.
will be the hearing or what pretrial hearing or whatever.
Baker's not here anymore. Jamie, maybe you can answer this. What happened with the hearing regarding the Turtle Boy and the whole like conspiracy and all that stuff?
I think there was an extension for like some response for tomorrow.
Yeah, something like that.
Yeah, of course.
I think. I don't remember. Yeah, Baker would have to answer. We were going to get into some stuff, but we haven't yet.
Moms are equally revered and hated in our society, and it sucks sometimes. Well,
okay, so Miss T is in chat and she's going crazy. I feel like this panel has no effing cue of mental health. He was hearing voices. She said
not
he was hearing
confirmed.
voices. Yeah, none of this has been confirmed.
None of it was confirmed.
He even had mental evaluation and none of this. He was saying this stuff in text messages to his friend, right?
Yeah, no information that the parents ever knew of it.
Even if he was saying this to his friends, first of all, we don't know that that was true. Any of this was true. We don't know if he was just saying these things, but it was his friend that he was saying these things to. This was not his parents.
I also say that he's been evaluated by 3 doctors since, and that was presented during the Miller hearing, and he was found not to be suffering from any mental health issues.
Yeah.
So I don't know. Well, I mean, the one crazy doctor that dropped an egg said that he suffered a brain injury or something, but that was nonsense because he literally saw a video of Ethan falling at work and said, well, he must have hurt himself because he fell and he did all this stuff and then dropped an egg in the courtroom. It was just nonsense. So I don't really follow that quite a bit. Oh, also, it's a racial thing because he was white. And if he was a black student, they would have paid closer attention to him. That was said by the doctor, too.
I think
so
the
there's a lot
doctor
of
just
things.
wanted to break an egg in court.
Yeah, I think he did, too.
Right?
His friend had, well, they sent him to an OCD camp. I don't know. But apparently his
What
friend had
does
mental
okay.
health issues.
Yeah. And what does 14 years old oh my god, he's a 14-year-old young boy. What does that have to do with anything? They still lie. They still make up stories.
Yeah, they do more so than anything.
I don't
You should see the way
understand.
my kids, I go through my kids' phones, but you should see the way that they talk to their friends as opposed to talk to me and text to them. They make up all kinds of stuff. OCD camp sounds fun. I know, right? You just spend like days organizing boxes. What do you do with OCD camp? By the way, Farrell, are you back? Because I heard I called you by the wrong name and now you disappeared. Is Farrell that fragile?
I don't know.
You're not on panel, Farrell. Should I just remove you? Here, there we go. If she pops up in the window again, I'll bring her back.
Well, his brain's still developing because he's only 14 years old. It doesn't matter. It doesn't mean that the parents knew what was going on if he was having problems. And he wasn't telling anybody. He wasn't telling anyone but his one friend. He never told his counselor. He didn't tell his parents. What are you supposed to do about that?
Yeah, I mean, he had the plenty of opportunity to talk to the school therapist and everyone else. I want to know. Oh, there we go.
Yeah, and also it's just like, they tried to do an insanity motion and he was competent. So I don't, if he really thought stuff was flying around, he would have had a chance.
Mm-hmm.
I went through my
just
son's
saying.
stuff one time,
Yeah,
found everything I
agreed.
suspected. I felt terrible. Well, but then you at least know, and then you can address it. That's what I always say.
Yeah.
There's no point in burying your head in the sand. And it sounds like from the evidence presented in this court that this mom did that. Now, whether she really did or not, I don't know. We're just going based off the evidence in the court. The evidence in the court seems to suggest she didn't know. And even the prosecutor said nobody saw this coming, which is telling.
The teachers, the principal that saw him with the gun in the hallway said, I couldn't believe it was Ethan. I remember that testimony.
Mm-hmm.
So the state says there's no way anybody could have known. Then how did they even get past like the first element of this crime? They had to know that there was some risk in order to have that duty.
Right. Tell us your darkest secrets. Ears wide open.
Well,
that was a text that Jennifer sent to Ethan. Actually, while he was in the bathroom after the meeting, she texted him and said, you can talk to us about anything. We don't judge. And he responded, I know. I'm sorry. I love you. While he's getting his gun out in the bathroom. At least according to the surveillance video.
Yeah, I love that. He's like, it'd be funny if he's doing voice chat, like, yep, yeah, mom, love you, click, shunk, clunk. Thanks, mom.
Yeah. So, like, what are you supposed to do with that when you're trying to open up to your kid and he's constantly like, no, I'm good.
Problem is the jury doesn't think like lawyers. I agree.
You're like, no, you must have more therapy.
Yes.
In all your holes.
You need to be locked up for 72 hours. Let me drag you to the hospital.
Mm-hmm.
I don't understand what people want.
All right, so I'm clearly going to probably need to set up another stream. So I'm going to set up another stream.
You do that because Yeah, it's not gonna be quick.
Somebody's head is there.
So,
Yeah, I saw that.
Why do you need to set up in the stream?
Well, because I don't think we're going to get a verdict by the end of the day today. Just in case, I'm going to set up another
Oh, you mean
stream.
set up a new stream for tomorrow? Okay.
Yeah, yeah, yeah.
I thought you might continue on tonight. I'm like, this one can go for a while.
yeah. We're having too much fun here.
Day 2 verdict watch. If I spelled it with a V. There we go. Farrell's not here to comment, so we'll just leave that be. Yeah, so I'm going to set up another stream for tomorrow, and just to make sure that we are good to go when. Let's see. Oh, no. Capture. There we go. And the guy's head keeps bobbing around. That's what I keep seeing. Like, oh, is there
Yeah.
something going on? Is there something going on?
Did you say they were only going to keep them there till a certain
Till
time?
5. We have like a half hour left.
Oh.
They'll bring them in and excuse them fairly soon, I imagine. Let's see. All right, well, talk amongst yourselves while I'm getting this going.
Mhm.
Oh. Let's see. Jury instructions, verdict watch. All right, we're set up for tomorrow.
Paul said, "What
So-
was the?"
Well, I did want to say while we're working on this, guys, tonight after a little while. Wait, what time is it right now? Oh, probably
4:16.
I don't know, about a half hour. So I will be starting the day whatever, the Michelle Trakunis trial. She is accused of she is the mistress who helped her husband dispose of the body of his. So husband or his wife, she's the mistress. She helps dispose of the body. Yet we've been through 17 days and we actually haven't seen her do anything disposing of the body, anything blood related to her, anything DNA related to her, anything fingerprints related to her. But we have learned that the wife got chopped up in a million pieces in a pretty gruesome manner. So that one is going, and it's actually, I think we're getting to the point where they're going to start tying it all together. And we're going to watch probably part of that today. And then tonight at about 8:30, I do my local show every week. So that's over at potentiallycriminal.locals.com. You guys can see us there. It's usually a very fun time.
I'm working on getting a link to your channel in my description. So everyone could follow that. And if they're watching this on rewatch or whatever, they'll be able to follow.
How'd the tree watering go, Baker?
Besides that, it's raining cats and dogs outside. It went fine.
Oh,
now
so the
she's,
trees are watering themselves.
Yeah,
Aw.
but now she's biting my foot to play with me because playtime is at 10:15 at night.
Is it 10:15 there?
Yeah.
It's been raining all day.
We're supposed to get like a month worth of rain the next day.
Nice.
Ooh.
It's always nice.
No snow though, even though you're near the Arctic. Aren't you near the Arctic? I don't know. You're somewhere. You're north of us. That's all I know.
I'm kind of like Nova Scotia or something like that.
Yeah, something like that.
So
Oh my god.
no, it's half the country is supposedly gonna get a lot of snow tomorrow. We're just gonna get a lot of rain.
Brandy Churchwell is covering that as well. I haven't talked to Brandy.
Oh,
I thought
that's
she
right.
wasn't streaming much.
She's
Oh, by the way,
covering,
Sean, you're coming on to do Legos with us on March 2nd, aren't you?
Yes.
Yeah, that'll be a good time.
Yes.
We'll talk some Vince McMahon and build some Lego.
That should be a lot of fun.
Sean's gonna be on. Oh, that should be fun.
Oh, it'll be a great time.
Will the judge finish verdict and release the jury, etc., at this time of day if the jury comes back now? Oh, yeah. If the jury came back now, yeah, they would just put a verdict on. They have until 5 o'clock. But I think the jury is going to be closely watched at this point going forward to see if they're like close. She might even slip them a note and say, hey, do you guys want to keep deliberating for like another hour? And that sort of thing. Let's see. Oh, the golf stream. Yeah, the golf stream keeps you guys warm.
Yeah.
Yeah, and apparently it's slowing down, so we might be just as miserable as the Norwegians at some point.
Why does the judge not let them deliberate? Because it's late. She doesn't want to pay for lunch. She doesn't want to stay there. She doesn't want
Keep the courthouse open. Yeah, she can set the times on that. It's her court.
Yeah,
her trial.
but she doesn't. She's not going to sit there all night long because she'd have to stay there. She's like, no, I'm going home. You guys come back tomorrow. I got to be here tomorrow anyway. So,
Yeah.
Why would she stay late? I don't get that when the judges want everyone to go like super late. I could get that a little bit on a Friday, but not on a Monday. Be like, no, you guys go home. I'm going home, and we'll see y'all back here in the morning. Yeah, judge has a box of wine chilling, ready to go.
She does.
I can't believe there's still 758 of you hanging out with us, watching us literally talk about nothing, but welcome. Glad you're here.
We're not talking
What
about
else are we
nothing.
gonna do?
We're talking about a lot of things. We're talking about Vince McMahon. We're talking about Arctic Circles. We're talking about Lego.
Right.
Have you seen the new Lego drop? You can get the Millennium
Star Wars.
Falcon.
Yeah.
And the Princess Leia's ship from A New Hope. And I think 2 more was just put up today as future releases.
I saw a Chinese dragon Lego. That looks cool. New Lego. Let me see what I find.
Yeah, there's like 5 or 6 Star Wars coming out next, I think, beginning of March.
No.
Well, tell the beautiful people about your Lego streams,
So once or twice a month, myself and Valhalla Awaits, along with Wendy H, who may or may not be in chat, we do a Lego stream where we invite other YouTubers onto the channel, interview them, while at the same time chit-chatting about life, having a few drinks, talking some law, and it's a good time. And it's harder than you think, apparently, according to our guests, to build Legos and talk at the same time. So we'll see how Sean handles it, but he's usually like building something while he's streaming. Anyway, so Star Wars is not dead, Lefty.
One of these days, I'm going to get me a set to build. But
yes, MG, we'll have you on too. We have them stacked up right now. We have one February 17th, I think, is our next one, which is Solomon Anderson. And then Sean's on the one that follows, which is March 2nd. It gets really expensive to build these over and over. I like spreading them out a bit. I was just looking at trying to find a set for Solomon's stream, and they're just so expensive.
Yep.
Now I'm looking at the new Millennium Falcon. It's $84.
Yeah, it's like $80, something like that.
It looks small too.
It's 24 centimeters.
That's what she said.
Yeah, is that what she said?
Well, to
This
you,
thing looks small.
But it's on a display case and with the 25 years of Lego Star Wars. So you can get that in the tentative V or 4. It's
How many pieces is this?
It's 921. It was just on the slide before.
Really?
In the
Okay.
bottom.
Mhm.
In the bottom.
In the bottom. Oh, there it is. 921 pieces. Okay. That's
I think
pretty
if you
cool,
go,
though.
go to the last one, you can see the size of it. Oh, yeah.
Oh, there we
it's
go.
another one.
Okay.
Also.
All right, that's not bad. I might get this one.
I think it's on the size of the little less than the TIE fighter you built last time.
Yeah. Which is, here's my little TIE fighter I built during my last stream. You can see it in the.
Yeah, the TIE Fighter's cool. My brother built that one.
Oh, I just dropped my
Years.
Stormtrooper.
He had one he did years ago. It was huge.
Yeah, there's some really big ones. Oh yeah, there it is. Baker's got it.
I think he had an ATST, maybe.
Davis, since you mentioned Solomon, maybe you could talk a little bit about Zachariah Anderson. Yeah, I will talk a little bit about Zachariah Anderson. So last March, Zachariah Anderson was convicted of unaliving Rosalio Gutierrez and hiding his corpse and stalking Rosalio and his ex-girlfriend, Sadie Beecham. I believe there was absolutely no physical evidence, no circumstantial evidence that placed him there. What convicted him was one tiny speck of DNA, which may or may not have been Rosalio's, which was contained in the back of Zach's vehicle, which could easily be explained away as touch DNA transferred there by any number of reasons, including the fact that Rosalio was dating Sadie, who had kids with Zach, and people were in and out of each other's homes and cars and all kinds of stuff. But no cell phone data places him there. None of his DNA is at the crime scene. No eyewitness seeing Zach there. No witness seeing his car there. No video surveillance of any car being anywhere around. There's literally nothing other than his cell phone wasn't operating. He wasn't using a cell phone in a very narrow window, which still doesn't even help.
Wasn't long enough for him to get from his house to Rosalio's place and back.
It would have given him like 15 minutes in order to kill Rosalio, who easily had 100 pounds on him, and then haul his body away. Oh yeah, that's the other thing too. There's no body.
Yeah.
So there's all kinds of mess with that case. That's Zachariah Anderson. I have a whole playlist on it, and if I can find it, because I think I just lost it.
Well, there's no proof that he was actually murdered. So
we have a wrongful podcast, which is an excellent podcast talking about this case. I highly recommend you all go check it out. It'll give you an overview of the case and everything, and as well as show you some of the very serious shortcomings of this particular case. I'm actually working on a documentary, like a try to be a real documentary involving this case. And I've been interviewing some experts, including a DNA expert, a prosecutor, a former prosecutor here from the state of Michigan, who's handled 2 missing body, no body cases in the state of Michigan, as well as some defense attorneys, mental health professionals, and others to try to establish what really happened with this case. So,
well, you have a corrupt prosecutor. That's what happened.
We have a corrupt prosecutor,
an unethical prosecutor.
Yeah.
Yep.
Why not build something creative from the Legos you have, not following stuff? I thought about that. I have a ton of Legos. I built the courtroom because one of the other cases that I'm doing, I'm doing stop motion with Legos, is a Lizzie Borden trial. I have the transcripts from it. I have the voices dubbed, and now I'm doing the stop motion Lego for the Lizzie Borden trial. So I could do something like that. That could be fun. Will you explain the DNA? Because every fight I get into with somebody in the chat or online about this, say it's his DNA, not proven to be blood.
It's a single source male, which could have been any, like, half the population in the area.
I have an 1 hour long interview with an excellent DNA expert, Tiffany Roy, who actually filed an official complaint against this DNA expert on the Zachariah Anderson case. So I did a 1 hour long interview with her, and she explains it so much better than I possibly could. And I'm hoping to get that out to everybody. As I'm
they had no numbers to go with it. Normally you say, there's a 1 in 7 billion chance, probability that it's not that, that it is this person. They had none of that with this case.
Yeah, they didn't.
If they actually have DNA evidence, then you get the astronomical numbers.
Well, the other big thing is, say you definitively say that it's his DNA. You can't say how it got there. You can never say how it got there.
And it's one speck.
And it's one speck. And you can't. Well, you can't identify what type of DNA it is, right? You can't say that it came from blood, semen, hair, skin, whatever. And
they couldn't, because it was such a small sample. They could not test for both.
Yeah, but even if you were to have enough sample to test for it, you still can't say definitively as to what the DNA source is. She does a really good job explaining it, and just says that people rely way too much on DNA.
Yeah. Well, it's circumstantial evidence. It's not direct evidence of anything.
Well, we're only going to go for like another half hour, excited. And he's on Central Time, so it's only 3:30 his time.
Mhm.
Wow, Dave really is a nerd. I am. Yes, I absolutely am.
That's why we like you.
Yeah.
You seem normal, and then you open your mouth.
Any plans to discuss the Karen Reed case? Perhaps, but Baker's really covering that more so than I am. I've talked about it ancillarily as it applies to the Turtle Boy case. But for all of your Karen Reed coverage, you got to go check out the Broken Baker. And again, his channel is linked to my description. Lizzie Borden. Well, my thought is I feel like Lizzie Borden, if you guys don't know the story, this is 1893 or something like that. She went on trial. And for the axe murdering of her father and stepmother, or mother and stepfather, I can't remember. One of them was a step. Anyways, after reading the transcripts and doing this, I think in today's world she would be convicted, but she was actually acquitted of the charges. So that's why I wanted to do it, because I feel like in today's world with the exact same facts, she would be acquitted, or she would be convicted, not acquitted. Well, yeah. Hang on one second, folks.
But for those people who was interested in either Turtle Boy or the Karen Reed, next week, both of them are supposed to have hearings. Turtle Boy on Wednesday and Karen Reed on Thursday.
So I thought Turtle Boy was supposed to have a hearing like today or something.
No, there was the Turi hearing.
SJC was supposed to have
I believe the Turi hearing was supposed to happen today, or start today, with the feds. But Mello turned in his homework late, and
of course,
all the anti-Turtle Boy people are blowing up right now. It's a fun group. And,
why is this guy's head always there?
Well, he just had it shined.
I think this is actually the court administrator, the guy who handles all the logistics for the court. I think this is who this is.
Somebody said, "Are you pro Karen Reed in this chat?" And I will say that I am definitely skeptical of what's going on.
I haven't heard anything.
We always pro any defendant, no matter how big an a-hole they are, because until you're proven guilty, you're innocent.
Yep.
Exactly. That's our stance, at least in my channel, is that Karen Reed, as well as Jennifer Crumbley in this case, and all the other defendants, until they're proven guilty, are absolutely innocent. And you need to start with that presumption. And if the state presents evidence in the trial to overcome that, I'm fine with saying somebody's guilty.
Yeah,
everything
I've
we have
seen
on
and heard
Karen
enough
Reed,
so far that somebody else did this.
Yeah.
Yeah.
Yeah, and I
what,
say,
Jennifer Crumbley, you mean? Yeah.
Even
no,
when
with Karen Reed, you mean?
With Karen Reed.
Yeah.
Oh, Karen Reed.
Yeah,
but again, I'm reserving my final call until I watch the trial, right? Because we don't know what evidence is actually going to be admitted.
No, but Jamie and I had that what we thought would be a clear case. We just jumped on Jamie was yelling at me and said I should be streaming or else she'll beat me again. And we jumped on that. I can't remember. It's the guy who wanted to be on a home improvement program down in Florida. And we ended up saying there's no evidence he did it. And we believed he was the biggest a-hole on the planet. And then you had Bradley on. Where we had to believe him innocent until he proved himself guilty a couple of times. Don't mention like 25.
100% accurate.
We disagreed, though. We disagreed on the lady who was at the car accident and chased the guy down. We disagreed on that.
The one in Atlanta. Yeah. I don't.
Hannah.
Hannah
I didn't agree with that one either.
But I mean, between Baker and I, we disagreed on that and stuff.
Yeah, and I get called racist every 2 to 3 weeks.
You did get called racist on that one.
I got a message last week about how racist I am. So,
yeah, we don't always agree on here either, and I like that about us. We can talk about things.
Short with a purple Lego hack. I'll have to check it out. I love all things Lego.
And Vodka Blood, the retrial is supposed to begin on March 12th. So I should be done with Adam Montgomery so I can cover it.
Which retrial is it?
Karen Reed.
The feds are not your
Oh,
friend.
retrial. I thought you said a retrial. I was like,
Yeah, I
Oh,
thought you
it's
did
just
too.
my perfect
So it's just-
dictionary.
you don't
Yeah,
have
it's
an
the way
accent.
he speaks. Yeah, no accent. The feds are not your friends. The feds are
No.
the state. The feds are cops, just like everyone else. Oh,
Yeah.
am I behind?
Well, Farrell didn't agree with us on Megan, and she didn't agree with me on Brandon Notai. Remember Brandon Notai? I love Brandon Notai. Oh, what's going on now? Oh, they're going home.
I don't know. Everyone's saying like,
People versus Jennifer Crumbley, case number 222799990FH.
Thank you, Mark Keith, on behalf of people.
Thank you, Shannon Smith, on behalf of Jennifer Crumbley, who sits to my left.
All right, we made contact with the jury. They said they want to stay till 4:45, and if they finally want to come back tomorrow. But unless there's an objection, I might release two of the other 5 sequestered jurors and tell them that they're sequestered at their home. Do you object to that?
Not at all.
No.
No objection.
We've given them puzzles and Sudoku and that they're probably losing their minds. So I was going to release 2 or 3 and have them go about their business, but they would still be sequestered. So they would still be subject to sequestration of the court and not be permitted to be spoken to by anyone, right?
Yes, sir.
All right. Any preference, 2, 3?
If that's so reliable, Your Honor, I'd say 3. Can we approach him?
Sure.
wait, why you got to approach? There's no jury here. Talk.
Yeah.
All right, so it sounds like they're sending 2 or 3 alternates home. Now, the rest of the jury is going to continue to deliberate, and everyone that was watching me on Facebook has just left. Because it's shut down. I forgot to make the announcement before we hit 8 hours. It shuts down on Facebook after 8 hours.
Do you think that means they might be closed then? The judge thinks they might be closed? If the alternates are going home already?
No, I
But she
think
said
she just thinks
sequestered at home.
But she's going to sequester the ones she's sending, those alternates at home.
Which I don't understand. It's 4:37. She says, "I'm going to let the jury to continue to deliberate, essentially for another 8 minutes, but I'm going to send some of the sequestered jury members home now." So, I'm just
Which one is
arriving. What do
send
you all
them?
think the verdict should be? Is this our Megan or is this a different Megan? What do you think it will be? Is this Megan Amirowitz? Anyways, I think it's I'm leaning more towards not guilty now, at least on the first theory.
They'll find a way to convict her.
You just say that they can't talk to anybody and nobody can talk to them. Sequester them at home. These losers can't need another day.
Oh. She said, no, it's Megan, a turtle rider, who loves your channel.
Oh, okay. Well, thank you.
Hey,
Is it Megan
David.
Fox? Yeah.
I don't mean to. I'm gonna have to step out. It sounds like they're gonna go for a little while. So
Yeah, no
I'm
worries.
gonna get ready for my stream a little while. Guys, over at Potentially Criminal, we'll be doing Michelle Trakunis, not Megan Trakunis. Day 17. Hopefully, we actually get some evidence that's actually inspiring and confident. And you guys could join me in the lovely future Mrs. Mark 2.0.
No, everyone go
It
check
just-
out Sean.
Yeah.
His
No, I was
his
waiting. Sounds
channel
like we're
is in
about
the
to go
description.
somewhere. Yeah. Also, if you guys, oh, hold on, where are we? Oh, they're releasing people. Okay. Also, don't forget simplystrungtogether.com if you want some Mrs. 2.0's handmade
Oh yes.
talent.
Send me a link for that.
Sure, I will.
I'm so sorry. Hopefully you realize the reason.
You notice the prosecutor and Sam say this isn't a laughing matter. This isn't funny to the judge, which they should have done that. Judge, this isn't funny. These little kids are dead. Ethan played duck hunt in study hall.
In the event that one of those jurors was indisposed, we would need one of you
Your Honor, these are my deliberations. Thank you.
Freaking quiet.
Deliberations all the way over.
It's my jury.
Because she's not using a mic.
That's the reason for it.
Oh.
That being said, I'm going to dismiss 3 of you by blind draw today. Actually, I should use the word dismiss. I'm going to.
There we go. Now we got
it. You not return tomorrow, but you're still sequestered. You understand what I'm saying?
So she's going to keep them at home. They don't have to come back tomorrow.
People sitting out here would love
But they still can't talk about it because they might need them.
Yeah.
But there's 5 total alternates, right?
Yeah, so there's 2 that still have to come back.
So there's 2 of them that just sit in the courthouse aimlessly.
Yep.
Yeah, pretty much.
God, that's gotta be hell.
It's going to be random, isn't it?
Yep.
Or is it?
Yeah, it's random.
All right.
I hope 17 goes home for the rest of the trial.
But I'm gonna have 2 of you come back.
Yeah.
I think you've already ordered your lunch, so I'm hoping the 3 of you ordered something we like. No? No. Yeah.
My question is, if we are one of the 3 that go home and spend their day at home tomorrow, how do you know if will you call us as soon and let us know what to do the following day?
Absolutely. I feel bad enough that I feel like I kidnapped you.
You would stay home
Okay,
until.
so I feel bad enough that you're here.
Yeah.
I know that you know why. Okay, because when this is all over, I'll tell you stories about strange things that happen and jurors and, just life happens. So, as you know, this is a very long, emotional, and frankly expensive process. To start over would be devastating for everyone in the room. So I appreciate you. I feel bad, but I would feel worse if we didn't have enough jurors to finish deliberations. Okay. So 3 of you, I'm going to pick three numbers by blind draw, and then you can exit, and they're going to take you down to your car. And we have your phone numbers. You are still sequestered, all of you, and the other 2 have to return back in the morning. Okay. And I'm going to tell you again that during the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they can give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. So do not go on social media, don't post anything, don't go on Facebook, don't do research, don't discuss the case with anyone, whether you're at home or at work or here spending the day with me again. All right. So I'm going to pick 3 of you by blind draw. The other 2 have to return at 9 o'clock in the morning. All right.
3 of the alternate jurors are being sent home to stay home unless they absolutely need them to come back and fill in a spot. Otherwise, the rest of the jury is going home a little before 5.
Juror 17. You can be
Yes.
sequestered at home.
Good.
Juror 4. You can be sequestered at home. And juror in seat 10. 10. You can
Right.
be sequestered at home. All right. You can bring things with you. You're 9 and 15. Jurors in seat 9 and 15. I mean, obviously you can't bring a newspaper or something like that. You still can't research the case, but if you have work, you can finish my crocheting for me if you know how to crochet. Anything like that. I know it has to be really boring, but I think you understand the purpose. You can't talk to anybody. Again, a lot of people here would love to talk to you, but none of you are allowed to talk to the press or discuss the case with anyone. All right? And we do have your phone numbers. So I'm going to release you to go back to Judge Anderson's jury room, and then you're going to be escorted out of the building.
I'll come back
and
to
then
this
the 2
one,
remaining
Josie.
Jurors, if you could come here at 9 o'clock tomorrow morning. All right? Any questions about that? Okay, we appreciate you. Thank you for understanding.
What did she ask?
She wanted to know why we didn't like juror 17, and I missed this super chat, so I'm glad I went back and looked. $10 super chat. Ethan was organized enough to wait to do the shooting until he had the weapon of his choice, ammo of his choice, and multiple clips. If not today, tomorrow. If not tomorrow, the next day. He was determined. I agree with that. I agree that that's an accurate statement.
God. Seriously.
Well, David, I'm gonna head out and start the.
All right, take care, Sean.
yeah,
Everyone, go check out Sean.
Yeah.
Over
Yes,
potentially
he's
criminal.
hilarious.
Link
Fingers
in the
crossed.
description.
Fingers crossed for Jennifer. They get this settled quick, guys.
I hope so.
Yeah. All right. Good night, everybody. See you guys.
Bye,
See you,
Sean.
Baker.
Night.
See you, everybody.
Bye.
See you, Sean.
Yep.
Oh man, oh man.
Nick says he's canceling his stream today. Waste of time. That court. Why don't we like juror number 17? All right.
Oh, let me count the ways. Is that right, David?
Yeah, yeah. So she's a white female married, 2 school-age children. She works as a veterinarian. When she thinks of this case, she gets enraged.
How is
And
she not dismissed?
I know, right?
Sure.
And when she was leaving court last Tuesday for jury summons, her husband turned to her as he handed her her Yeti and said, "I'll be thinking of you." Oh, by the way, her anti-gun husband. Because they were
Yeah, I don't see
selecting
how she
the Crumbley
was-
jury today, and she said, "Oh my, I didn't know that was today." And it was this whole like melodramatic way she said everything.
Yeah,
I
she
don't
should have been let go.
Yeah, I was surprised to see that she was still on the jury.
I mean, that to me, that's not even a peremptory. That's a for cause.
Mhm.
Do we like 9? 9 is good.
9 o'clock. Okay,
Jury
you're
is
gonna
being
return tomorrow at
dismissed.
9 o'clock. We
9
appreciate your
o'clock.
efforts. We appreciate you taking this seriously. This is very serious, as you know. And I need to tell you that during the trial, do not read, listen to, watch any news reports about the case. And the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they will give you incorrect or misleading information that might unfairly favor one side.
All of my information
So
is
to be
correct. How
fair
dare you?
to both sides, you must follow this instruction. Do not go on social media, don't post, don't go on Facebook, don't do research, don't discuss the case with anyone. All right? Any questions about the schedule? We'll be kind of at your will, so get a good night's sleep, maybe sleeping on it will help you, right? Stay healthy, we appreciate you, and we'll see you at 9 o'clock, right?
All right, for the jury.
All right. And that's where we are. I don't get why the ATF guy is still there. Yeah. He just takes an interest in the case. That's all.
Probably want to ask the judges. He can go back and say, "I feel really stupid. I said a Derringer was a target practice gun. Can I take the stand again? Sorry."
So my prediction was either late today or early tomorrow. So I'm still on track for my prediction.
Yep. I'm surprised actually, but that's fine.
ATF guy gets a day out of school, you know, in all fairness.
Yes, thank you.
Thank you, Judge.
All right. And that is it for today, guys.
Everybody, David did a whole verdict watch. I'm so proud of him.
God.
I'm not gonna do a verdict watch.
I hate for it. You know what? Let's remove Pharaoh here.
And he hates his life right now.
I feel
No,
like
he
I
had all the
wasted
fun
the whole
people on.
day.
That's it's fun.
I feel like the defense is looking fairly confident. The longer this goes, it's typically more
Usually
favorable
better.
for the defense. Yeah.
Yeah.
So I feel like she should. I mean, she's still nervous. Oh, is Megan in the courtroom? She turned and said hi to somebody.
Oh, I hope she's got a friend.
I think it's a good thing. Link, definitely. Definitely a good thing. Defense. Stammer at every word. Yeah, but that's her style. She's a Columbo. We're just staring at Jennifer. There's really nothing else going on here. So, all right. Any parting thoughts before we go? Shut this thing down for the day.
No, just hoping for a not guilty tomorrow.
Yeah. I go with MG. I just hope the jury gets the right one, the right verdict.
Where should I send you guys now? Off. Let's see here.
You should send them all over to MG Law and subscribe to him because
MG doesn't have a
he's
stream
going to
up.
start up.
I have a stream, but I'm going to start watching Edgecombe. So
he's going to start watching Edgecombe, and it's going to be amazing.
Yeah,
Do you have a
I gotta,
stream?
I gotta
right
find
now?
the streams for it. I think Baker sent me the link to the Law and
Well,
Crime.
Sean said he's going live, so we'll
Mix.
just send him over to Sean.
Yeah, go over to
Does he
Sean.
have a link up?
He's live right now, apparently. So, or will
But
be.
everybody, yeah, they need
Be
to
soon.
put the
And to Emily, CBE, Megan is a woman who spent time in prison with Mrs. Crumbley. We covered her trial. She was accused of unaliving her father with lie, and she was found guilty and was released for time served.
Yeah,
Very-
Megan Amirowitz.
very
That was
sweet
a tragic case, but she made friends with Jennifer while in Oakland County Jail, and so we've interviewed her and Megan's mom. But she was in the courtroom on first day of jury selection when I was there, and then I was gonna do potentially or Good Logic, by the way, but he's shutting down, so I'm not gonna send you over there just to be redirected. But yeah, so I was hoping to get some insight from her. I don't think she wants to come on the channel though, and that's okay. But you guys all head over to Sean's now. And that's about it. Courtroom is done. Court feed went out. All right. Well, that was a giant waste of a day, Baker.
It wasn't. We've talked about all the important stuff.
No, because you had
yeah.
jury questions that were really important, and you would have had to keep coming live.
And again, we had like 700 people watching us all day because I'm not much of a
Baker's going to do the verdict watch tomorrow. I'm just going to pop on.
I turned into a good Christian channel at New Year's, but still, imagine 700 people who would have been watching Law and Crime if you didn't say that.
Exactly.
So everyone, remember to tell Dave.
Do it for you people.
We're going to do it again tomorrow. Keep people away from Law and Crime. This is too important to just sit at home in Michigan and think, I have the chickens, I have the treehouse. No. You have a duty.
Yes,
you have a higher duty.
But Lefty, $150 over the course of 8 hours, almost 8.5 hours, and then you got, YouTube gets their cut, so it's not even that.
Well, if you became a YouTuber for the money, you choose the wrong job.
Yeah, no, definitely. Let me find my Megan Amirowitz interview. Oh, here it is. Share. Copy. All right, I'll put my Megan Amirowitz interview here in the chat so you guys can all check it out if you want to. We talk a little bit about Crumbley's, but also a lot about her case. So there you go. You have a duty to us, MLS. I know. Oh, and don't forget, tomorrow at 6 p.m. Eastern, so right after verdict watch, maybe, we have Fun Time with Friends stream. Cool. And all of you guys on the panel, by the way, you should have a link. If not, it's in my Discord. And then I don't know who else all coming on, but it'll be fun with friends. I'm hoping we have a verdict by then. Oh my god, I hope we have a verdict tomorrow.
So it'll come during the stream.
Yeah, I know. Yeah, it'll come during the Fun with Friends.
EU is wondering what the ad revenue is with these numbers. 1,000 views is $3.
Yeah, I was gonna say. Yeah, I made. Yeah.
Yeah, he can't pay the
This is not for the money,
bill.
people.
No. Remember, if you want to be a YouTuber, don't do it for the money. Do it because you find it fun. Hanging out for 8 hours and 17 minutes with your bestest friends online. And
Kathy, not my realtor in Jersey, with a $3 super sticker. Thank you very much. That super sticker.
See, you just made 1,000 views. You didn't even have to have 1,000 views. You made the same money now.
That's right. All right. Thank you, everybody, for joining me on this.
Yeah, you might not get any ad revenue after Sean reading today.
Clip Sean out. I should have read those. I should have read those text messages before I had Sean. Just
you had not seen the text messages yet?
No. I had just read like the preamble, like just the basic facts and some of the argument.
How many? Wait, how many more are there?
No, I think Expert went through them the other night. He had them. They were more redacted though.
There's 70-some pages. I'm like, I'm not reading all this. This guy's either a douchebag or she is, fine, whatever. So I had never seen those texts. And yeah, I should have read them before I had Sean read them. Oh my God.
He said, yeah, just say all the words. I'm like, what is he saying?
Well, I never read them. He's like, do you want me? I'm like, because we don't hold back. We read things as they are.
Yeah, you're more than 2 hours in too. So
yeah, but just the voice and the words and the voice. Was not expecting that. Farrell, are you going to make an appearance on panel at all to say bye or no? All right. Okay, you all have.
He's like the expert. She just shows up and sleep on streams.
That's exactly what happens. You guys all have fun over at Sean's. Tell him I said hi, and we'll see you tomorrow.
Yep.
Bye, guys.
Bye.
When I was young, my daddy said, gotta keep one eye